The top law enforcement officer in the state of Texas impeached.
Republicans and Democrats in the Texas House of Representatives overwhelmingly adopting 20 articles for misconduct.
It's 10 times worse than it's been voted.
Ken Paxton maintaining his innocence, calling it all politics.
And they are showcasing their absolute contempt for the electoral process.
Now all eyes are on the Texas Senate for the first impeachment trial of a Texas Attorney General.
Everyone will do their job to the utmost in fairness.
KVUE special coverage of the impeachment trial of Texas Attorney General Ken Paxton starts now.
And good afternoon to you. Hope you enjoyed your lunch break. I'm KVUE senior reporter Tony Plohetski.
And I'm Ashley Goudeau. We are waiting for the impeachment trial of suspended Texas Attorney General Ken Paxton to resume. We last left off with Mark Penley on the stand. He's one of Paxton's former top aides.
As are all of the whistleblowers. We're talking about people who worked in the executive offices of the Attorney General's office, making allegations way back in 2020, September and October 2020, that have now triggered this historic impeachment hearing for Ken Paxton, the first time in a century that a statewide elected official has faced ouster from office.
And if we just recap a little bit for you about what Mark Penley has testified to so far. He was being questioned by Rusty Hardin, who is one of the House prosecutors, and he really described for us the same thing that we've heard from the other whistleblowers, which was that he listened to Austin real estate investor Nate Paul's claims that the federal government and FBI agents were, looking to get him, and that they had concocted this entire ordeal, changing warrants so that they could investigate him. And he found those claims to be insane. But despite, and insane is his word, that's a quote,
yes,
insane.
Yes.
But despite that, and despite the warnings that Penley and others gave General Paxton, he continued to want to move forward with helping Paul investigate the feds.
Mark Penley saying this morning under oath as well, Ashley, that not only did he listen to these allegations from Nate Paul, that he did in fact take investigatory steps. That is key, because one of the things that Ken Paxton has claimed as a reason for Penley's dismissal is that he was not doing his job. And so Mark Penley taking the stand and saying that he did, in fact, investigate these claims by Nate Paul, but again, not only found them unfounded, but found them, we've heard them described as insane, ludicrous, all sorts of other words. But at the same time, just before we broke for lunch, we were beginning to hear a cross-examination from Attorney Mitch Little. Ashley, he has also questioned one other witness for the House Management Prosecutors, and seems to be very much taking a similar aggressive, some might even describe it as semi-hostile position toward the witness now, Penley.
One of the things that I think is interesting, as you mentioned, he already cross-examined one of the witnesses, and so Rusty Hardin was sure in his line of questioning with Mark Penley to sort of point out this idea that because the defense is arguing you had no evidence of this happening, to point out that to file a whistleblower claim or to investigate claims, you don't need, what some would consider a hard piece of paper evidence, tangible evidence.
It doesn't have to be in a neatly with a bow on top, right. In other words.
You're right, that they went forward to the FBI with these allegations against Paxton based on their own dealings with him, based on the meetings and the conversations that they were having with him that was raising concerns for them. And he talked about the FBI actually investigating in the conversations that they had with the FBI for 4 hours, sort of this really intense process of laying out all of their claims, laying out what they had experienced with Paxton that led them to believe he was doing something wrong and potentially illegal.
Which successfully triggered an FBI investigation that, to our knowledge, is still ongoing.
And significantly just had proceedings before a grand jury not too long ago.
Exactly. We know that at least some witnesses have been called before that grand jury. And if we look at the Senate floor now, we are seeing the senators definitely making their way back to their desk. On the Senate floor, we do not yet see Lieutenant Governor Dan Patrick. But the witness, Mark Penley, is likely, obviously, being kept away from the floor until he is recalled back to the stand.
We're hitting that 1 p.m. mark, so we were on a lunch break until 1 p.m. It's 1 now as we're waiting for them. There's Rusty Hardin there walking across the bottom of your screen, getting in position for the second half. And we want to take a note to talk about timing. Whereas we initially heard this trial could last for 3 or 4 weeks, we are on day 1 of week 2, and the Lieutenant Governor Dan Patrick kind of gave us a time check saying that this could go to the jury this week.
This could go to the jury as early as Thursday afternoon. Both sides really are continuing to chew through their time. Dan Patrick also saying that, he plans to keep the Senate convened into the early evening hours, 6 or 7, but also actually making it clear that if this requires weekend work, that is what is going to happen. So we could very much see, unless a verdict is reached, we could very much be here with you on Saturday and even into Sunday as this possibly goes to the jurors, who in this case, as we know, are the state senators.
Certainly will be interesting to see how long certainly it takes them to deliberate 16 articles of impeachment, because it is a big task before them. We're not talking about guilt or innocence.
All rise. The Court of Impeachment of the Texas Senate is now in session.
Guilt or innocence, considering the fact that that's not what they're deciding. They're not deciding whether or not there's criminal, but rather to convict or acquit. But the burden remains the same, is that they have to believe that General Paxton committed these acts intentionally, and they have to believe that beyond a reasonable doubt that happened.
And we're watching Lieutenant Governor Dan Patrick call this court back into session, reconvening, and in just a couple of moments, we will see Mitch Little continue cross-examination of the witness.
Bailiff, call in the witness, please.
Mark Penley, who again has been kept away from the Senate floor until now. He is being recalled. Similarly,
Little,
we've seen the same thing with other witnesses who have testified.
Mark Penley, the former Deputy Attorney General of Criminal Justice for Paxton, again, as Tony mentioned, a whistleblower who was fired, and that firing of those whistleblowers and the therefore settlement of that lawsuit between Ken Paxton and those 4 whistleblowers who sued. There are 8. Some of them resigned. Some of them stayed on until they were fired. 4 of the fired filed that lawsuit. That's what really triggered this entire impeachment.
That $3.3 proposed $1 million settlement, of which Mark Penley would receive a portion if it is indeed approved by state lawmakers.
Which would have to happen, Tony, during a special session, because the session has ended. The lawmakers are not in session. They can't come back to approve that settlement for the AG's office to pay out, and it would have to, it's a line item in their budget that would have to be approved by lawmakers. Penley taking the seat now, so let's listen in to the rest of the trial.
You testified under oath before today.
Yes, I've testified under oath.
Did you testify under oath before the House Board of Managers?
No.
Did any of the House Board of Managers, Andrew Murr, Jeff Leach, Charlie Guerin, any of them put you under oath to provide testimony in connection with the impeachment proceedings in the House?
No, I did not testify in the House.
In fact,
not in a proceeding in the House. I did speak with their investigators.
Did you review the video of your meeting with the investigators before testifying here today?
No.
And during that proceeding, isn't it true that Ms. Therese Buse, who was hired as one of the investigators, told you that there was a legislative privilege that covered your testimony in that proceeding?
I don't know that she told me that. It was my understanding there was a legislative privilege.
Just to be clear, when you testified there on video, did you tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, that was my intent.
Yes, and it was your intent.
Yeah, I mean, I may have gotten a date wrong. I may have gotten an event occurred one day instead of another day, but it was my intention to tell the truth, the whole truth, and nothing but the truth. Yes, sir.
Of course. So if we have your statement from that interview that was conducted by the House Board of Managers and their investigators, we can rely on it as being true, correct?
I believe so. That was my intention.
All right. At this time, Your Honor, I'm going to introduce AG Exhibit 68. May I approach the witness?
Yes, you may.
Thank you.
It's not on our list, so you'll have to submit it at the right time.
And we move for admission of AG Exhibit 68.
Any objection?
No objection, Your Honor.
Admit AG 68 to evidence.
Eric, Exhibit 68, if you would. Thank you so much. All right, to be clear, Mr. Penley, this is the referral that came to your office from the Travis County District Attorney's Office, and it was dated June 10 of 2020, correct?
That's correct.
It's received in your office sometime around June 17 of 2020, correct?
That's my understanding, yes.
And when you got this, neither David Maxwell nor you were excited about the assignment at all, and neither one of you really wanted to move forward with it, correct?
That's true.
And what Nate Paul was accusing these people here, or at least complaining about, if true, it was a 20-year felony. You would agree with that, correct?
An alteration of a federal or a document, yes, it would be a 20-year felony.
And there's a state analog to the federal statute concerning alteration of government documents, true?
Yes, I believe that's 3710.
So there was a state offense that had been alleged in this referral, true?
He was claiming there were state law offenses, yes.
Yes, that's what I said. There is a state offense alleged in this referral, true?
Yes, if you believe what Nate Paul was saying.
Yes, and it wasn't a crime to follow up on this. It wasn't obstruction of justice. It wasn't interference with an FBI investigation. True?
To a certain point, I agree.
Very good. In fact, when you were working at the U.S. Attorney's Office, there was an FBI employee in the U.S. Attorney's Office, in the Northern District of Texas. His name was Jeffrey Fudge. Do you remember that person?
I don't.
He was an FBI employee who was accused, indicted, and convicted of plugging other people's information into government databases and letting them know if there were investigations about them. You familiar with that?
I'm not.
It happened your first year at the U.S. Attorney's Office.
Pardon me, Your Honor. We're talking about something he doesn't know anything about. Now he's testifying about it, and I object to that.
Overruled. He can ask the question, but be careful of your line of questioning.
I certainly will. Have you ever heard of an FBI employee named Kevin Kleinsmith?
I believe so.
Yes. At the same time that you were doing this investigation, an FBI employee was being investigated and subsequently indicted for providing false information in pursuit of a FISA warrant. Correct?
I've heard that.
Operation Crossfire Hurricane, you've heard of that before, correct?
I have.
Yes. And so the allegations that are being made here, it's not a crime to follow up on them, and a state offense is alleged. True?
I felt it was appropriate to do an initial review.
Object now responsive.
Sustained.
True?
Could you ask the question again, please?
Yes. The state offenses that are alleged here, it wasn't a crime to follow up on them, was it?
No, it wasn't a crime to follow up.
No. But your testimony earlier was you hoped to slow walk it.
Yes.
Did you tell Michael Wynn that?
No.
Did you tell Nate Paul that?
No.
Did you tell your boss Ken Paxton that?
No.
And in fact, between June 17 and July 6, 2020, you only talked to David Maxwell about it, right?
Between what dates?
June 17 and July 6 of 2020, you only talked to David Maxwell about it.
That's not correct.
That was your testimony on direct. Would you like to correct it?
I would, if I may.
Please.
I'm sure I talked to Jeff Mateer as well. In fact, we talked to Jeff Mateer when he handed us the referral on June the 18th, probably.
We may be talking past one another. You did no investigation between June 17 and July 6. True?
We didn't do any, no.
Didn't do any work. True?
That's true.
Okay. I'm going to show you what's been marked as AG Exhibit 88. We move for admission of AG 88.
Any objection, Mr. Hardin?
No, Your Honor.
It's admitted to evidence, AG 68. I'm sorry, say that number. 88. I see it. Thank you.
Mr. Arroyo, if you could publish AG 88 on Bates page HBOM 181004. So move ahead 3 pages from there. And blow up all the text in writing at the top, please. These are your notes, Mr. Penley, from your meeting with Ken Paxton on July 6th of 2020. True?
Yes.
And in that meeting, at the top you write, tampering with docs is a state issue, per Mindy of Travis County. Who's Mindy?
Mindy Monford, the first assistant at the Travis County District Attorney's Office.
Did she tell you that?
No.
You didn't know enough state law to know that there was a state offense alleged at this point in time, did you?
That's incorrect.
So you knew there was a state offense alleged. You didn't need Ken Paxton or Mindy Monford to tell you that. True?
I believe I had discussed that with David Maxwell.
You learned it from David Maxwell, right?
I believe so.
Did you look up the law yourself?
I did.
Good. Next line says he alleged they changed the search warrant. The next line after that, if you would, read that to the ladies and gentlemen of the jury, please.
Ken just wants the truth, period.
Ken just wants the truth. And to be clear for the ladies and gentlemen of the jury, who is Ken?
That's Attorney General Ken Paxton.
He told you he just wanted the truth. True?
He said he did.
Yeah, and you believed him at the time. True? True?
At the time I believed him, yes.
Yes, at the time you believed him.
That's right, but not later.
And so when you made these notes, you were making notes of what Ken Paxton was saying, and he was telling you he just wanted the truth.
That's right, I wrote down what he said.
The truth about what?
About what happened with Nate Paul.
And did you tell him you would get right on it?
We did. We started trying to schedule a meeting.
I don't think so. Let's move on to
Object
our
to the
next
sidebar.
Withdrawn.
Sustained.
This is another portion of Exhibit AG 88. Mr. Arroyo, if you could move to the next page, .5. Mr. Penley, these are your notes of a subsequent meeting with your boss, Ken Paxton, true?
Yes.
And if you could, Mr. Arroyo, blow up the bottom half of that page, please. The date of this meeting is on or around July 16. Yes?
Well, that's my best belief. I didn't date this page, and I don't know specifically when it was, but from looking at other information, that's my belief. This happened on July 16th.
And how long had you been working at the Attorney General's office at this point?
About 9 months.
About 9 months, less than a year, certainly. True?
Yes, I only worked there a year.
And you wrote the word Ken, and you bolded it, correct?
Yes.
Mr. Arroyo, can you bold that? Can you highlight that for me? And to the right of it, you wrote an asterisk, and it says, he's embarrassed.
That's what he said.
He was embarrassed with you and David Maxwell. True?
He was embarrassed at the lack of progress on the Nate Paul matter.
Because you hadn't done anything. True?
That's true.
Below it says, we've had this for 6 weeks, exclamation point. And Ken Paxton was upset with you that in 6 weeks, you and David Maxwell had done nothing. True?
Which part of the question do you want me to answer first? You asked me if we'd had it for 6 weeks. That is true. And it's also true we had done no investigating in that 6 weeks.
Ken Paxton was upset that you had done nothing for 6 weeks on a referral from Travis County that he was aware of. True?
That's true.
Down, if you would, there's some discussion about Texas Monthly. Do you see the all caps statement that you wrote in your notes?
I do.
And Mr. Arroyo, if you would highlight that portion. And the portion below it and the line below it. You're on it. And below it. It says, seek the truth, 2 exclamation points. And that's what your boss, Ken Paxton, told you to do. True?
That's what he said. I wrote down what he said.
And what he said was to tell you to seek the truth. Yes?
Yes, that's what he said, and that's what we did.
And below that it says, let results be what they are. True?
That's what he said, and that's what I wrote down. True.
And at that point in time, in that day, he did not tell you to interfere with an FBI investigation, did he?
Not that day, no.
He did not tell you to obstruct justice, did he?
Not that day, no.
No, he didn't. Mr. Arroyo, if you would, please bring up Exhibit 1, AG 1009. This has already been entered into evidence, Mr. President, before the break. Exhibit AG 1009 is on the screen here, and these are your notes from July 23, 2020, true?
Correct.
And these are notes from your review of Nate Paul's earlier meeting with David Maxwell, of which you are not a participant, true?
That's true.
Yes. And in the middle, Mr. Arroyo, it says the agents didn't. If you can highlight that portion. It says the agents didn't leave search warrants behind. Violation of the law. True?
No, it's not a violation of the law.
Is the Federal Code of Criminal Procedure the law or not?
It's a procedural code. It's not a statute.
Okay. They broke the law as expressed in the Code of Criminal Procedure. True?
They broke the procedural rules of the Federal Code of Criminal Procedure, if that was true.
Let's turn the page. Next page, Mr. Arroyo. In the middle of the page, there's a section that says metadata on PDF. You could zoom in on that. It says, actually don't zoom in on that whole thing, just get the line below that as well, was created on 9/6. Can you read that okay, Mr. Penley?
I can, thank you.
Right, very good. It says metadata on PDF was created on 9/6.
Yes.
You would agree with me if someone was manipulating federal search warrants after they had already been served or after they had already been created, that is a problem, yes?
Could you repeat the question? You said manipulated. I don't understand what you mean.
If someone were changing search warrants after a judge signed them, that would be bad. True?
I'd agree if they were changing the text.
Yes, not just redactions, but changing the actual text, right?
If they were changing the text that the magistrate judge had approved, that would be a crime.
And the next page, if you would, Mr. Arroyo. About 3/4 of the way down, there's a paragraph that says claim above an asterisk. If you could zoom in on that for us. No, above that, please. The next paragraph above. Yeah, the allegation here is that the search warrant for the file storage company, Contigo, was fabricated after the fact. Yes?
That was Mr. Paul's allegation, yes.
All right. Next page, please. And on the last page, you wrote the notes, Ronnie Saban, TFO. That stands for Task Force Officer. Yes?
Yes.
State Securities Board. Yes?
Yes.
How did he get the name Ronnie Saban?
Well, I know that he met Ronnie Saban because he claimed that Ronnie Saban had been executing the search at his residence, and they spoke to each other.
So what you're saying is, I don't want to put words in your mouth, Nate Paul knew Ronnie Saban was involved with the search warrant because he met him during the execution of the search warrant, correct?
Yes, he had personal knowledge of Ronnie Saban because he met him during the search.
Not because Nate Paul got some secret document from someone else, true?
No, that's absolutely false, and you misstated my testimony.
Object is non-responsive to everything after no.
Sustained.
Now, we're going to look at AG Exhibit 110. Mr. Arroyo, if you would, AG Exhibit, I'm sorry, not 110, 1010. There we go. All right. These are your notes from a meeting with Michael Wynn on July 28th of 2020, true?
Those are my notes from a phone call with Michael Wynn. That's correct.
Yes, a phone call. And at the top it says, wants to come to Austin to explain papers. Yes?
Yes.
And below that says the agents didn't leave copies at the premises, but you already knew that. True?
I knew that from reviewing the first meeting, the July 21st meeting video. Yes.
Next line down says inconsistent signatures and stamps. Yes?
That's what I wrote down because that's what Mr. Wynn told me. Yes.
Yeah. And these notes are from a phone call in advance of an August 5, 2020 meeting with Mr. Wynn and his lawyer. Yes?
Correct. We set that meeting date during this call.
Yes. And by this point in time, Mr. Penley, had you done any investigating at all?
Yes.
And what did that include?
Well, it included watching the video of the July 21st meeting where Mr. Maxwell met with Mr. Wynn and Mr. Paul, listened to their complaints, listened to their theories. So I'd reviewed all that, and he wanted to come have a second meeting, and I agreed to it.
All you did was listen to them at this point in time, true?
Yes, that was an initial report.
Object not responsive to everything after yes.
Can the witness finish his answer, please?
Sustain the objection. Overrule your objection.
I'm going to show you what.
Please let him have time to finish.
I will do my best. Now we're going to look at Exhibit 1011, AG Exhibit 1011. And these are your notes from a meeting with Nate Paul and Michael Wynn, true?
Yes, that's the August 5th meeting.
And you can see there by your first asterisk, hold on, it says thumb drive of docs produced.
That's true.
They gave you a thumb drive.
They
yes?
did, yes.
And I want you to scroll down. Do you see the line that says J. Lane?
Yes, I see that.
This J. Lane said he didn't have the original search warrant. Yes?
Well, I don't know if he did or he didn't. That's what Michael Wynn told me.
Yes. And so what Michael Wynn told you in this meeting is that the magistrate, the federal magistrate judge, informed them that he did not have the original search warrant. True?
That's what Michael Wynn said, true.
And if that were true, that would be really surprising if a federal magistrate, for whatever reason, did not have the original search warrant. Yes?
Yes, that would surprise me.
Did you ever look for the original search warrant?
How would I do that, sir?
Did you call anyone?
I raised that with the Attorney General and the First Assistant that was an option.
Object non-responsive. That was not my question.
Sustained.
Did you call anyone at the magistrate's office, a clerk, a deputy clerk, the magistrate himself? Yes or no?
No, I never called the federal magistrate or his staff.
Did you call Alan Bowie, perhaps?
No, I did not.
Did you call any of his deputies at the U.S. Attorney's Office?
I did not.
How hard would that have been to do?
It would have been problematic in my view.
It would have damaged your reputation and the office's reputation potentially, true?
Not my reputation. I wasn't concerned about that. I was concerned about the reputation of the office and our work with the federal authorities in the state of Texas.
For you to call the feds, you would have worried that that would have harmed the reputation of the office.
Not to make a phone call, but to
then
make
why didn't you do it?
Because a phone call about this seemed to be high risk to the functioning of the Office of the Attorney General when we needed to work with federal authorities or appear in federal court, which our attorneys did all the time.
That would have been high risk to make a phone call? You're going to tell these senators it was high risk for the Office of the Attorney General for you to pick up the phone and make a phone call, yes?
Not to make a phone call, no. But to make a phone call about this, yes.
Well, why didn't you do it?
The reason I didn't do it is because Nate Paul was claiming there was a grand conspiracy between a federal judge, 2 federal prosecutors, at least 2 state agencies represented as task force officers, and a number of FBI agents. Nate Paul filed a civil suit against 100 law enforcement agents in federal court in Austin over this. And I thought to call the U.S. Attorney's Office and say, we have any belief that career AUSAs would be altering search warrants is crazy, especially when they have an ongoing investigation that's privileged.
In any event, you didn't make the phone call.
I did not, for the reasons stated.
Yeah. Isn't it true that in these videos, first in the meeting with David Maxwell and Nate Paul and his lawyer, and then with you also, Nate Paul's own lawyer said, "We're not trying to interfere with the FBI investigation"? Didn't he say that?
He may have. I don't have a specific recollection.
Isn't it true that Nate Paul's lawyer, Michael Wynn, also told you, "We don't necessarily think that these are evil people. It may have been a comedy of errors, or they may have just made some bad choices and not been able to get out of it"?
I remember him saying,
Pardon me, is he soliciting hearsay? Surely not.
It's testimony from the video that you put in evidence about 2 hours ago, Rusty.
It doesn't matter. I just simply asked, are you asking what somebody else said out of court? Isn't that what you've been arguing about for me for the last week?
You remember the videos you put in this morning and the transcripts? It's from there. I hope that clarifies it.
Overruled.
All right. Now, let's go back to Exhibit 8. So, just to be clear, hold on.
which exhibit?
We're going to go to AG 1012, please. If you could, Mr. Arroyo. This is a meeting, and you are in this meeting with the Criminal Investigation Division's forensics team, true?
Correct, and David Maxwell.
And these are your notes, yes?
Yes.
And you're talking about metadata, true?
Yes.
And they told you that the results were inconclusive, true?
That was their words, yes.
Yes. They didn't tell you that there was no proof of a crime, or that no crime had been committed, or that a crime had been committed. They didn't tell you any of those things, did they?
They said the metadata was inconclusive.
And they didn't tell you that a crime had or had not been committed, true?
That's right, and I wasn't asking
Object
you that.
non-responsive to everything after that's right.
Sustain.
Mr. Penley, focus with me. Inconclusive means we don't know, doesn't it?
It means it doesn't prove anything. That's what it means.
It doesn't disprove anything either, does it?
That's right.
It seems like if something is inconclusive, it might require further investigation, right?
It's possible.
I'm going to show you what's been marked as Exhibit AG 88. Eric, if you can go back to that. I'm going to bring the page to you so you can see it.
Thank you.
If you would, Eric, go to the page ending in 7. 007. There, stop right there. Go back. All right, blow up all the text at the top. Mr. Penley, you got out of the meeting and you had Tina McLeod, who works in IT, she sent you an email. Metadata is, quote, data that provides information about other data.
Yes, she sent me this email, and because I'd sent her one.
And at the bottom she said, hope this helps. Yes?
That's what she wrote.
You asked her to send this to you, yes?
I did.
Because you didn't know what the heck metadata was before you walked into that meeting, right?
That's not correct. I had a general impression of what metadata was. Nate Paul was making specific allegations that he could understand the metadata, and he claimed it proved the search warrants had been altered. And I was trying to go to our IT director, who is at the deputy level, and see if I could get a more definitive definition of metadata that would help me analyze his claim.
Of course. And so what had happened was, on this same day, you had met with Nate Paul and his lawyers, and No?
No.
Okay.
This was August the 6th. This was the day after the meeting.
Yes. So you met with your team, your forensic team.
On August 6th, yes.
And then you got out of the meeting and said, hey, Tina, can you send me a definition of metadata, please?
I don't remember if I sent the email before we met with the forensics team or after. Metadata was the central core of Nate Paul's complaints about the search warrant. That was the evidence that he and Mr. Wynn pointed to that would prove that state violations had occurred in the alleged alteration of a court document.
And in order for you to assess those claims, you needed to know what metadata was, right?
Of course, yes.
May I approach the witness? Mr. Arroyo, back to Exhibit AG 88. The page ending in 003, please. What is this list, Mr. Penley?
Well, it's a document that apparently
Excuse me, we're on the wrong page up on the screen.
Oh, wrong page. Mr. Arroyo, 003, please. Other way. Okay, what's this list?
Your Honor, may I inquire if he asks the witness if these are his notes or his typing?
No, it's in evidence. It was offered, admitted, over your objection. No objection, actually.
I don't believe this was prepared by him, so I don't know if he is going to ask him about it. I'd like the record to reflect he's out talking to him about something he did not prepare.
He produced it in response to...
It doesn't matter whether we produced it. It matters as to whether this witness had anything to do with it.
I'll try to lay a proper predicate.
It looks to me like we received it from the Attorney General's office.
Mr. Hardin, you can take the witness on voir dire and ask him.
Yes. Mr. Penley, of this particular exhibit, did you have anything to do with preparing it?
I don't recognize this document. I don't recall preparing this. I don't believe it's mine.
Okay. That's all I have, Judge.
Do you remember ever seeing it?
I've seen it in the documents for this trial. I've seen it in the discovery.
You produced it in response to your subpoena, yes?
I don't know that.
He didn't produce...
Hold on. I'm asking the question.
I don't know that I did.
Okay. We can go back and look.
And if I did, I don't know that I prepared it. Perhaps I received it some other way.
The suggestions on this list are suggestions of things that the office might do. Questions it might answer in connection with the investigation, right?
I agree with that.
Yeah. And it says, can we talk to the AUSA Alan Bowie, right?
Correct.
And you've already testified you didn't do that, yes?
Right, I did not do that.
And none of the other questions, how was the document created? How was the document encrypted? What did he encrypt it with? What application did he use? You never got the answers to any of those questions, did you?
No, I did not.
Doesn't that seem like important information you might want to know?
No, not based on what I learned on August the 6th.
Okay, so I want to fast forward in your mind now to August 12th. We're going in chronological order if you couldn't tell. August 12th, you believe, and your testimony on direct was, you believe Ken Paxton was no longer supporting you. True?
That's true.
Yeah, and you came to that conclusion after the meeting with Nate Paul and his lawyers at which the Attorney General was present, yes?
Based on what the Attorney General said, that was opposite of what he had told me 3 or 4 days earlier.
And now, if you would, let's take a look, Mr. Arroyo, at AG 1013. You and the deputies on August 13th, the day after you say you no longer felt supported by Ken Paxton, you got in a circle with your deputies, yes?
No, I didn't get in a circle. I briefed Jeff Mateer on what had happened the previous day.
When you produced this document in response to a subpoena, you blacked out the top, you whited out the top of it, right?
Yes, because
I just need an answer to my question.
Yes, I did. I redacted it.
Yes, and we don't know what's under there because you didn't show us, correct?
That's true.
Now we go to the rest of this item. These are your handwritten notes from a meeting, true?
Yes.
And below that, Mr. Arroyo, if you can blow up the text to the right below that. It says, call Dan Goudeau.
Yes.
That's what you wrote, right?
Absolutely.
We're talking about that guy?
Yes, the guy in the good-looking sport coat over here.
It says, ask him if Maxwell and I say go no further with this. Did you call Dan Goudeau?
No, we did not, but we considered it.
Object non-responsive to anything after no.
Sustained.
Below that, Mr. Roy, if you could highlight that, it says possible bribery.
Yes, I wrote that.
On August 13th of 2020, you had absolutely no evidence, physical, documentary, eyewitness, or circumstantial, that Ken Paxton was being bribed by anyone, did you?
I disagree with your statement. I had circumstantial evidence.
Oh, you had circumstantial evidence?
Yes.
Well, at some point on August 13th, did you go to your boss, Ken Paxton, and say, Attorney General, I'm concerned. I have circumstantial evidence that you've taken a bribe. Did you do that?
Not on the 13th of August. I did
You
it later.
didn't do that because you knew you would get fired, right?
I said possible bribery. I didn't have evidence to confront him with. Not at that time.
Oh, but you just told the ladies and gentlemen of the jury you had circumstantial evidence.
Yeah.
So did you confront him with the circumstantial evidence?
No. The circumstantial
Object
evidence.
now responsive to everything
Mr.
after
Kennedy,
no.
please be allowed to respond. I'm just begging.
Sustained. Your objections.
Thank you. Mr. Penley, below that it says, if you can zoom back out, Mr. Arroyo, he's using OAG/playing KP. Did you tell your boss you thought that Nate Paul was playing him?
Not on August the 13th.
Why not on that day? You had his phone number, right?
I'm sorry?
You had Ken Paxton's phone number, right?
Yes, I did.
Why didn't you confront Ken Paxton with your circumstantial evidence of bribery and the idea that Nate Paul was playing him on August 13?
Because I was trying to find a way to convince him to listen to reason and get away from this investigation, which I thought was highly dangerous to him and harmful to the office and injurious to the respect for the law in the state of Texas.
But also because if you had done that, you should expect to get fired, don't you think?
I could have been, and I was concerned about getting fired ever since Ken Paxton did a 180 and turned against me in the August 12th meeting all the way to the end.
Okay. So just to be clear for the ladies and gentlemen of the jury, your concerns about bribery did not arrive until you thought Ken Paxton might fire you, yes?
No, that's not correct. You're misstating what I thought.
I have your notes here.
Yes.
This is the first document I've ever seen where you've written the words possible bribery. Will you agree?
I don't have all the documents I've written. I've written a lot, so I can't agree to that unless you want to show me all the documents. I began to be very concerned about what was going on in his mind when, on about August the 8th, more or less, I told him I recommended closing the investigation. He looked me in the eye and said, okay, fine. All I ask you to do is meet with him and tell him. And then 2 days later, he told me he wanted to attend the meeting. And then in the meeting, when I announced to Mr. Paul and Mr. Wynn, I recommended we close the investigation because the metadata theory didn't prove a crime, Ken Paxton began making negative comments to me.
I'm going to object to the narrative.
Sustained.
Appreciate your answer, Mr. Penley, but my question was a little bit different. On August 12th, by August 12th, you thought, this guy might fire me, yeah?
I did.
On August 13th, you wrote down, maybe he's being bribed, yeah?
Yes, because I thought that.
And you didn't confront him that day because to do so probably would have resulted in you being fired, yes?
Could be.
The safer strategy is to wait a month and go to the FBI with whatever circumstantial evidence you have and adopt whistleblower status for the same information, right?
No, I don't agree with your characterization.
Okay, in any event, in this memo you say that the metadata is inconclusive, right?
I'm sorry, where are you pointing me to?
Zoom back out, Eric, if you would, please. Yep, metadata is inconclusive. No proof of crime. No disproof of crime either, right?
I wrote down metadata is inconclusive, no proof of crime, and that was my belief at that time, and it still is.
In any event, I think you can tell the jury, and that we'll agree, you didn't do any investigating after that, right?
No, that's not true. I tried to investigate. I tried to get the rest of the documents that Nate Paul and Michael Wynn had told me they had on August 5th. They told me they'd gotten a bunch of documents from Judge Lane, and I never felt like they'd given me all the documents.
You had already told Nate Paul and his lawyer the day before that you were going to close the investigation before you had those documents. True?
That's true. And the Attorney General didn't accept
Jack
it.
not responsive to anything after true.
Sustained.
All right. I'm going to show you what's marked as Exhibit AG 1014, please. We're going to move ahead in time from August 13th of 2020 to September 4th of 2020. Can you see this document in front of you on the screen? Or in your hand? You've got a copy of it physically.
Yes, I think I can see it better on the screen if you'll blow it up. Thank you.
This is an email from General Counsel. This is Leslie French at the OAG, and she's sending it to FLD Contracts. It says, FLD, please see the attached.
Is when it reached my email inbox.
Well, that's not what you testified to under oath before the House Board of Managers, is it?
That's why I said I made a mistake.
Yeah.
You're correct.
And when you and I think you'll agree, I'm not going to have to pull your transcript out. You testified to the House Board of Managers and their investigators that you got it on September 4th, and then you went on vacation and said, I'll take care of that when I get back. That's what you told them, yes? And now you're telling a different story, yes?
Well, you've asked two questions at least. I'll answer it this way if I may. Yes, I told the House managers I thought the date I first received the executive approval memorandum was on September the 3rd or 4th, whatever date is in the transcript. I don't argue with that. I now believe I first received it on September the 16th, so I'm correcting my testimony.
Now, you're correcting your testimony that you gave to the House Impeachment Board's investigators, yes?
Yes, that's true.
We should believe what you're saying today and not then, yes?
Yes.
Okay. Our next exhibit in time, if you would, we're going to go back to Exhibit AG 88. I'm going to show you the next page.
Thank you.
Your Honor, because it was, if I may, because this was a group offer, they're all, of course, Exhibit 88. If counsel could, on each one of these pages where he does it for us, give it some type of identifying so we can know and be able to pull back up later.
Well, they're already in. I'll identify it by Bates number if that's okay. So, Mr. Arroyo, if you'll go to the Bates ending in 8.
I realize they're in evidence. What I would like is a Bates number each time so I know which one to look for.
Would you accommodate him, please?
We'll do our best. Yes. Mr. Arroyo, go to page ending in 8. Give me all the text, Eric, if you would. This email is sent from Mark Penley to Brittany Hornsey, copying Drew Wicker. Hi, Brittany. I received a voicemail from the General today. He is requesting that all documents I have on the Nathan Paul matter be copied and given to Elise. Did I read that correctly?
You did.
The Attorney General just sent you to the showers, didn't he?
I'm sorry?
He just came to the mound and took the ball out of your hand. Said, give me the file. I'll take it from here. Yes?
He didn't say that.
That's what you should have inferred from that, right? The Attorney General came and got the file from you. Yes?
You're asking me to speculate. I don't know what was in his mind. I know I got a voicemail from him while I was on vacation asking me to get the file to one of the executive assistants on the executive floor, which I did.
You knew that was not a good sign, right?
No, I'd been given a warning that he was working up an outside counsel contract, and that was consistent with the idea that he was going around me and David Maxwell and trying to hire outside counsel.
He's taking the ball out of your hands, yes?
That's your phrase. I'll accept it if you want me to.
Okay, I do. You going to accept it? He took the ball out of your hands.
I'll accept that he was trying to take the case out of my hands. There was no ball.
Very good. Let's move to Exhibit AG 1015, if you would. And these are your notes from a side huddle with Jeff Mateer, Blake Brickman, and Ryan Bangert. Yes?
Yes, that's correct.
And at the bottom, we've got more redactions. Yes?
Yes, they were irrelevant topics that came up in a meeting that had nothing to do with this case.
Well, I guess we'll have to take your word for it, won't we?
Well, Yeah.
Below that, it says NP, file returned, Joe Brown, Cliff Strickland, outside counsel contract. So you knew about it.
Yes, the purpose of the meeting with Jeff was so he could update me on things that had gone on during the week I was gone. And he told me that the Attorney General had considered hiring Joe Brown, a former United States attorney and former district attorney in Sherman. He'd been the U.S. attorney in the Eastern District of Texas. He also, I believe, had conducted a phone interview with Cliff Strickland, an attorney in Denver.
All right, let's move ahead in time a little bit. May I approach the witness, Your Honor? Mr. Penley, I'm showing you what's been marked as Exhibit AG 124. Eric, would you bring that up, please? This is the second referral from the Travis County District Attorney's Office to Brandon Kamak on September 23rd of 2020, yes?
Yes.
And when you made your report to the FBI, you didn't know about this, true?
That's true.
And when you, I believe the word you used on direct was apoplectic.
Yes.
When you were apoplectic about the grand jury subpoenas being served by Brandon Kamak, it was because you believed they were being used for civil discovery in a criminal matter. True?
That's true.
But in fact, they were related to this second referral and a bid rigging investigation that had been referred to the Travis County District Attorney's Office over to Brandon Kamak.
You lost me on the second question. Could you repeat that, please?
Yeah, let me try again. The grand jury subpoenas Mr. Kamak was serving were relating to this referral in a bid rigging investigation that had been made from Travis County District Attorney's Office to Brandon Kamak. True?
That's not completely true. It's partially true.
It's a lot true, isn't it?
It's partially true. I'll explain if you want me to.
You can do that on redirect, I bet. We'll try. But here's what I want you to understand and I want you to appreciate and agree with me on. You didn't know about this, and the subpoenas that Mr. Kamak was serving were related to this referral. Yes?
A, I didn't know about this. I agree. B, all of the 39 grand jury subpoenas he obtained from Travis County did not relate to referral number 2. Part of them referred to referral number 1.
Thank you. We're going to move to Exhibit AG 92.
I do not believe 124 was admitted previously.
We move for admission of AG 124.
Any objection? That's the document Mr. Hardin, he had been working from before that one you were just handed.
He has seen 124, and this is 92.
I have no objection.
Show that Exhibit 124 is admitted into evidence. And now are you offering another?
AG 92, Mr. President.
Any objection on this one, Mr. Hardin?
No, Your Honor.
Show that Exhibit 92 be admitted into evidence. Continue.
Mr. Penley, after 10 days here in Exhibit AG 92, you admit, or you finally state, I'm not signing the outside counsel contract. Yeah?
You said after 10 days. You lost me at 10 days.
Your testimony today was that you got the outside counsel contract DocuSign on September 14th. You told them you got it on September 4th. Whether you've had it for 10 days or 20 days, you are now finally telling someone, I'm not signing it. Yes?
I received it on September the 16th, as I previously stated. So 8 days later, after the Attorney General called me and asked me to sign the outside counsel contract, I told him I could not and I would not, and I gave him all the reasons why. He told me to talk to Jeff Mateer and to forward this contract to Jeff Mateer, which I did.
Let's move to Exhibit AG 1017, Eric. These are the notes that have already been entered in evidence, I guess, on both sides. But these are your notes from September 26, right?
Yes, these are my after-meeting notes on September 26 from McKinney.
Okay. This is discussion about hiring outside counsel, at least in part, yes?
Yes, that was discussed.
Okay, Eric, zoom in on the last half of the page, please. Higher. There you go, stop. Do you see the line about 4 lines down? It says, I said. Do you see that?
Yes.
It says, I said I don't need him, and we shouldn't be spending money on him when we can't give raises to our employees.
Yes, I see that.
You said that, didn't you?
I did.
None of that is your business or decision or authority at the Office of the Attorney General, is it?
I don't totally agree with you. I don't have the ultimate authority, but I have a duty to tell him about things going on in my area of responsibility. We couldn't give raises to our people. I felt like he was wasting money on outside counsel on an improper investigation, and I was trying to express that to him.
Do you understand that there are 900 outside counsel contracts every 2 years at the Office of the Attorney General?
I didn't know that, but I'll take your word for it.
And your explanation here, for one reason Ken Paxton shouldn't hire Brandon Kamak is, I don't need him. We shouldn't be spending money on him when we can't give raises to our employees. That was what you said, yeah?
That's what I said.
And Ken Paxton got upset and he said, so you're going to exercise veto powers over the budget for the agency?
He said that, yes.
That was his response to you, yes?
Yes, it was.
At the bottom, it says there's a chance of media exposure. Second to line from the bottom.
Yes.
You expressed you were worried about that, right?
I was worried for his sake, yes, and I warned him.
Go to the third page, if you would, Eric. Again, we see on the third page the word inconclusive. The theory advanced by NP was inconclusive, yes?
I'm sorry, could you tell me, can you direct me to the part of the page you're looking at?
Yes, can you highlight that for the jurors?
Yes, it's about 3/4 of the way down. You see the word inconclusive? It says theory advanced by at the beginning of the line. Lower, Eric, right there. This theory, in about a third of the way down.
Yes,
theory advanced by NP was inconclusive. Yes? You see that?
Give me, if I may have just a moment to read the paper copy.
Yeah, take your time.
Yes, I wrote that.
And toward the bottom of the page, and just leave it there, Eric, it says, I'm willing to hit the reset button and start fresh if they will produce docs, right?
Yes, I told him that.
You're 3 months into this referral, yes, and you're now telling your boss, I'm willing to hit the reset button. General Paxton?
That's
Yes?
what I told him on September the 26th, yes, after repeated requests for all the documents.
Turn the page if you would. Eric, give me the bottom half. You said, I told him this is a dangerous case. A dim DA or U.S. attorney could charge him with a play-for-pay scheme if they learned about the investigation, since Nate Paul is a campaign donor. Yes?
Yes, I wrote that.
Okay. You don't have any evidence that Nate Paul ever paid any type of bribe to Ken Paxton, do you?
I disagree with your statement.
Tell the ladies and gentlemen of the jury what evidence you have that Nate Paul paid Ken Paxton any type of bribe. Go.
I've read the evidence that was filed in response to the motion for summary judgment that your team filed. I've read...
Hold on a second. This is legal analysis based on what you've read? Is that right?
You asked me if I had any evidence. I'm trying to answer the question, sir.
No,
Yes.
You're analyzing what's evidence other people are offering in this case. On September 26, did you have any physical evidence, documentary evidence, eyewitness evidence, or circumstantial evidence that Ken Paxton had committed or been bribed by Nate Paul?
I had circumstantial evidence.
Anything else?
I had his behavior,
Anything else?
the campaign donation,
Anything else?
his absolute refusal to listen to common sense and reasoned legal positions. He wouldn't listen to anybody on the executive staff.
Anything else?
There's 4,000 pages filed in response to the summary judgment. There's stuff in there.
Did you have any of them?
I didn't have it on September 26. I know about it today.
bottom portion of that bottom paragraph says, I gave him the scenario that NP, if indicted, could make up a story and throw him under the bus to the feds. That's what you told him, right?
I did.
You told him the risk was Nate Paul would manufacture false information that could harm Ken Paxton, yes?
That's the way I phrased it, yes.
That's what you said and that's what you wrote, yes?
Yes.
We get to September 30th or 29th and 30th, your head explodes. Yes?
That's true. Figuratively speaking, I hope.
That's what you said that's what you said to the House Board of Managers, right?
I did, and I was extremely upset when I found out about the grand jury subpoenas, yes.
I'm going to show you what's marked as Exhibit AG 50. May I approach, Mr. President?
Thank you.
Mr. President, we move for admission of AG 50.
Any objection, Mr. Hardin?
No objection.
Eric, if you would put that up
Admit
for me.
into evidence, please. AG 50.
You signed this, yes?
I did, yes.
It says, we have a good faith belief that the Attorney General is violating federal and or state law. Yes?
Correct.
You had a good faith belief on October 1st, 2020. Yes?
Yes.
Did you bring any documentary evidence or physical evidence to the FBI?
No documents, no physical evidence.
And just to be clear, your testimony on direct was one of the reasons you thought Nate Paul had no credibility was he didn't give you any documentary evidence. True?
Based on his theory, there was nothing to back up his theory. Correct.
Yeah. And so it's fair to say if you had had documentary evidence of any crimes by Ken Paxton, you would have brought them to the FBI when you visited with them prior to this letter. True?
I disagree with you.
Oh, so you would have sat on it?
No.
If you had any documentary evidence of a crime by Ken Paxton, you would have brought it to the FBI. Yes?
No.
No, you wouldn't have?
No. This was an initial report by eyewitnesses. And it happened in a hurry.
I agree with that. How much of a hurry did it happen in?
Well, in one sense, it had gone on for 3 months, but what really took this to a crisis level was learning that Brandon Kamek, or Kamak, I don't know the exact pronunciation, was serving grand jury subpoenas that were designed to help Nate Paul in his civil litigation against his business adversaries.
You've testified about that. May I approach, Your Honor?
Thank you.
We move for admission of Exhibit AG 97, please.
When you have time to respond, Mr. Hardin.
No objection, Your Honor.
Admit AG Exhibit 97 into evidence.
From your office email, you forwarded grand jury subpoenas that were supposed to be secret to your counsel, Johnny Sutton, correct?
That's partially correct, yes.
And to be clear, you've never paid Johnny Sutton a dime, have you?
Not yet.
You have some type of pro bono deal with him?
No.
Who's paying for him?
We haven't agreed on a fee arrangement yet. We've agreed to discuss that in the future.
Let's let that sink in for a second. This man, who's a former assistant U.S. attorney, is with the Ashcroft law firm, I believe. It's in multiple states. He's represented you for 3 years and you haven't agreed on a fee arrangement yet? I want to make sure I understand.
That's right.
Haven't paid him anything?
Haven't paid him anything.
He's never sent you a bill?
No, sir.
Sounds like a great guy.
He is. And he's a former United States attorney, not an AUSA.
At some point in time, you get placed on investigative leave, true?
On October the 2nd, correct, by the Attorney General himself.
And by that point in time, there was still no file related to your investigation at the OAG, yes?
I'm sorry, I didn't hear the full question. Could you repeat?
There was no file at the time that you were placed on investigative leave in the OAG system related to the Nate Paul investigation, true?
I had a file with my personal notes on the case, but we had not officially opened an investigation file.
If you would, Mr. Arroyo, bring up Exhibit AGU 1020, please. October 10 of 2020, these are your notes from a conversation with David Maxwell, correct?
Yes.
Blow up the bottom portion and highlight it, Mr. Arroyo. Highlight that bottom asterisk. Your plan, while you were still at the Office of the Attorney General you're on investigative leave on October 10, right?
That's true.
Your plan is to cook up bar complaints on Brandon Kamak, Michael Wynn, and Ken Paxton, isn't it?
That was not my plan.
It was David Maxwell's plan?
I write down what people say
Object
in my phone
non-responsive.
memos. I wrote that down.
Shane,
He can't, pardon me, Your Honor, he
let's
can't.
back up. Let's slow down, let him finish his answer, then you can object. Go ahead.
Time's at a premium, Mr. Penley. It was David Maxwell's plan as of October 10 of 2020 to cook up bar complaints against Brandon Kamak and Mike Wynn and Ken Paxton. Yes?
No, I don't agree with that. He said that. I wrote it down. That's what it means.
And you wrote it down because, well, why don't you tell these people what he actually said?
The best recollection, well, I have no independent recollection of these notes, so I wrote down the word cook up. We never did anything with it. We never even called the bar.
But the two of you talked about it, yes?
That comment was made on that date, and I wrote it down on October the 10th. Yes, I wrote that down.
And toward the top, it says, look at the defense fund, may need a grand jury subpoena, right?
Right.
That was part of your plan, wasn't it?
No, that was part of our conversation, and we were trying to find more links between Nate Paul and Ken Paxton.
If you would, Mr. Arroyo, Exhibit AG 1021. These are your notes. Let's work from the top. When did you write this?
Hang on just a second. I guess I don't have a paper copy. It was sometime after I was placed on investigative leave. I don't know the exact date.
At the top, it says Google KP's Defense Fund. Eric, if you could zoom in on that. See if we can access that document. Who's we, by the way?
Some of the whistleblowers. I can't name anybody other than myself.
You guys are trying to dig for dirt on Ken Paxton, right?
We're trying to find evidence to defend ourselves because we were being unjustly treated.
Next paragraph, Mr. Arroyo. At the top, you write, Missy told him he could sign the contract and hire outside counsel. Yes?
I wrote that down, yes.
That's Missy Carey, the Chief of Staff of the Office of Attorney General, yes?
That's correct.
And your notes, your recollections from this meeting were that you were all discussing it, and the Chief of Staff said, Ken, you can sign that contract, yes?
Well, I don't know this was from a meeting. I believe it was from a phone call.
Let's go to the bottom two lines on that page, if you would, Mr. Arroyo. The bottom you wrote, KP must be indicted by spring break. You wrote that, right?
Yes.
That was what you wanted, wasn't it?
At that point, yes, because I believed he'd broken the law.
Of what year?
I'm sorry?
Of what year?
The law of what year?
Ask the witness.
Mr. Hardin, redirect.
Thank you, Your Honor. Oh, thank you. Thanks a lot. Mr. Penley, I'll just take a few minutes with you. Just a few things I want to mention real quickly. But what is your testimony as to whether or not at the time all of this was happening, you had seen the referral that is called the second referral? And if we could put up the front page of AG Exhibit 124, please, Stacy. It's okay. Thanks a lot. Now, Stacy, if we could put the date, isolate the date there. So September the 23rd, correct?
Correct.
That you're really only, everything blew up, we can all agree, can we not, on September the 30th, with y'all going to the FBI and so?
I'd say September 29th, the day before, with the first grand jury subpoena being reported.
But you went to the FBI on what date?
On the 30th.
All right. Now, this is just 1 week before that, is my point, is it not?
Yes, sir.
And were you ever, during any of the time this was going on, were you informed that after filing the complaint back in June on the referral, that now after things are, you've been looking at one referral?
Yes.
Is your testimony throughout this case, y'all were only concerned with one referral?
Right. I only knew of one referral all the way to the point when I got put on investigative leave.
All right. Have you since reviewed, after this was all over, after you were terminated? Well, back up. Had you seen this referral number 2 from this gentleman before you were terminated?
I think I saw it between the time I was put on leave and terminated, which was a month. I think I saw it in between that time.
And at the time, now did that lessen your view of, or change your view of Mr. Paul, or did it increase the view you already had reached?
It increased my anger at the Attorney General.
All right, hold on a second.
For doing all this.
Hold on a second. I want to move you now to Stacy Bates Stamp. I think it's Bates Stamp 2443, please, Stacy. Now, you've heard on cross, you've been asked questions about when y'all met with the investigative committee that you weren't under oath, right?
Yes, I recall that.
I'm going to look at this. Does this page show? All right. Do you see whether or not Mr. Paul once again had a choice of whether or not to swear to the allegations he was making?
Yes, I know that on both referral number 1 and number 2, those forms from Travis County have a line for a notary signature and a swearing that everything is true.
Now, what is your opinion as to whether when he goes to the district attorney's office to file a complaint and has a chance to make his allegations, did he swear to those allegations?
He did not swear to either complaint in referral 1 or referral 2.
And when he didn't swear to the complaint, did you, once you found out about it, while you were, you say, on leave before you were officially terminated, did you look at the allegations this guy was making this time?
I looked at the allegations. With that combined with everything else that had occurred, made me look in a highly skeptical way at his claims.
Well, let me ask you this. Did you look at this referral number 2 and see that now he wants a federal bankruptcy judge investigated?
Right. That makes 2 federal judges he wants the state of Texas to investigate, even though we told him he needed to go to the United States Department of Justice Inspector General's office to take these claims.
And to take him seriously.
He wanted us to take him seriously, I agree.
Go to Bates stamp if you can, Stacy, 124. Or that's the exhibit, excuse me. Bates stamp 2445. I want you to look at how many people now does he want an investigation of. For instance, look at on page 2445, let's scroll down. Will you just read out the names of the people he now wants y'all to investigate in addition to the people he wanted you to investigate in the original referral?
Yes, sir. Brian Hardiman,
slow down. Do you know who Brian Hardiman is, one way or the other?
I do not.
Next one.
Will Hardiman.
Do you know who he is?
I've read that's Brian Hardiman's son.
Do you know who Christopher Dobson is?
No.
Are you aware that's opposing counsel in the case that he's in litigation with?
No, but I'm not surprised.
Stephen Benish, do you know who that is?
I do not.
Do you know who Jason Cohen is?
I do not.
Do you know who Mark Riley is?
I don't.
Do you know that Mark Riley is engaged in a civil lawsuit with him?
One moment, Counselor.
Yes,
Can
sir.
we take out that information, please, on addresses?
Pardon me?
Just very briefly, Mr.
Yes.
President, assuming facts not in evidence.
I didn't hear what you said. I'm sorry.
I'm saying, assuming facts not in evidence, Mr. Hardin is saying that these people are certain things and the witness has no knowledge of it.
Sustained.
Do you know Jason Bain is?
I don't know him.
Do you know whether Tony M. Davis is a federal bankruptcy judge?
Yes, I understand that he is a United States bankruptcy judge in the Western District of Texas in Austin.
And do you know who Ray Chester is?
He is the trustee for the Mitty Foundation, which is involved in a lawsuit with Nate Paul.
Is Ray Chester a trustee or is he opposing counsel representing the Mitty Foundation?
My understanding is he's an attorney, but he's also the trustee represented by counsel.
Do you know who Mr. Milligan is? Gregory Milligan.
I believe he's an attorney in Austin, somehow involved in that litigation.
At the end of the day, when you read this particular referral, is there any way on God's green earth you would ever want to support a criminal investigation based on this guy?
Absolutely not.
I have no further questions.
Recross, Mr. Little.
No recross, Mr. President. May I have a moment to collect all my goods from up there?
You may.
Are these your notes down here? Yes,
Mr. Hard, Mr. Little, may this witness be excused?
I would hope so, Your Honor.
Subject to potential recall, of course, but yes.
Yes. You may step down. Thank you. I'm going to take all those, leave those here for us.
Thank you, Lieutenant.
Thank you. Thank you, sir. Who's the next witness? Yes. Hit that. We can't hear you. Here you go.
Here we go. Mr. President, the House Board of Managers calls Catherine Missy Carey.
Bailiff, will you bring in Missy Carey?
And we are about to hear testimony from Missy Carey. Ashley, this is different because she is not one of the formal whistleblowers. She is actually, or one of the whistleblowers, she is actually Ken Paxton's former chief of staff who we have never heard from. Her name has not been previously made public with any sort of attachment to this case. So it is significant in that for that reason. Keep in mind there are still 4 additional whistleblowers that we have not heard from. But again, the House prosecution at this point breaking from calling whistleblowers and now going to a former Paxton employee, Missy Carey.
Well, and just a point, 3 whistleblowers we haven't heard from. We've heard from 5 of them.
Yes, pardon me.
No. It's
Would you
easy
raise your right hand? Take following oath.
in the midst of all of this. So certainly will be interesting to see what she brings and what she has to say, because clearly you would imagine that she has a lot of
first-hand information.
First-hand knowledge, was in the room when things were happening. Let's listen in.
You may begin.
Hey, Mr. President. Good afternoon.
Good afternoon.
Would you please state your full name?
Hold on. Both of you are going to have to get much closer to the mic and speak up a little bit more. Yeah. No, it's the acoustics are not great in here.
Is that better?
I can hear you. It's a big room. Can you hear me?
Yes, ma'am.
All right. Would you please state your full name?
My name is Catherine Minter Carey, although I sometimes go by Missy.
Is that a name your parents gave you?
It's a nickname. My sister and I were Missy and Prissy growing up, and, I got the better end of that deal, so.
So which name do you go by?
I think everyone here would know me by Missy.
All right. Okay, if I call you Missy.
It is.
All right, Missy. Where did you grow up?
I grew up here in Austin.
And what did your mom do?
She was a school teacher and a stay-home mom.
How about your dad?
My father's an attorney.
And where did he work?
Actually, his first job was he was an assistant attorney general at the attorney general's office from 1965 when I was born to 1971. And then he had private practice in a law firm here in Austin.
Was he a role model for you?
He is a role model for me, yes.
Is he why you became a lawyer?
He is.
How about the attorney general's office?
When I was a kid, he would take me up there. I was probably kindergarten or first grade, and it was like the scene from Mad Men, if you know the TV show. It was a cool place, and it was what I always wanted to be.
So where did you go for undergrad?
I started at Hollins College, which is a girls' school in Virginia, and then I transferred to Texas A&M, where I graduated with
What's your degree in?
In political science.
Where'd you go after that?
I went to law school at St. Mary's in San Antonio.
And were you licensed to practice law?
I am. I'm licensed in Texas in 1990.
After you got your license, where did you go to work?
My first job was here at the General Land Office. I was a staff. First, I started out because I didn't have my bar results, and I learned quick that the Appropriations Act says you have to have a license to be a lawyer. So I started actually as a legal secretary or law clerk, and then when I got my results, I became a staff attorney there for 5 years.
And when you got promoted to staff attorney, what kind of things were you handling?
I did employment law. I wrote legislation. I worked on the Open Beaches Act, the Oil Spill Response Act. I did a little bit of collections for the Permanent School Fund. Did different things like that.
At the end of your 5 years, where did you move to?
I moved for the first time to the Office of the Attorney General.
Okay. And which department were you assigned to work in?
In the Administrative Law Division.
And what kind of things did you handle?
So part of the time I was a litigator in administrative law, represented the state in court. The other duties were general counsel to various state agencies that didn't have their own general counsels. I did open records, open meetings. I drafted rules, tried cases about the Administrative Procedures Act, did some employment law.
Sounds like all kinds of things.
Kind of a division that does a little bit of everything government-oriented.
Okay. Did you leave the Attorney General's office?
I did. I left the Attorney General's office for a while in 1997, and I was conscripted, so to speak, to work at the Texas Lottery Commission for Harriet Myers, Anthony Sadbury, and Judge Hill, John Hill, to work on a matter with the executive director at the time that was kind of well known in the press.
Okay.
So.
Was there a scandal?
There was.
And did it all have to get cleaned up?
It did.
And did you assist with that?
I did.
All right. After that work got done, where did you go?
After that work got done, I was asked by incoming Attorney General, now Senator John Cornyn, to come and be the Attorney General's office's public information coordinator. So I came back to the Attorney General's office in 1999, and I did the coordinator position for a year, and then I was given the division chief of the Open Records Division next, and I think I held that position about 6 or 7 years.
And at the end of that, where did you go?
I was promoted to the general counsel position for the Office of the Attorney General. I think in 2006, I was the agency's general counsel.
And after that?
After that, I was promoted by Governor Abbott when he was still Attorney General to be the deputy for administration for the Office of the Attorney General, and I remained in that position when General Paxton came in and did the same basic job for both of them.
Tell us how many attorney generals you've worked for.
As Attorney General, I've worked for 4, and then John Hill at the Lottery Commission.
Okay.
So 5.
Tell us the names.
So Dan Morales, John Cornyn, Greg Abbott, Ken Paxton, Attorney General Hill when he was on the Lottery Commission. And I also worked at the land office for Gary Morrow, who was a statewide elected official.
In 2014, when Ken Paxton became the Attorney General, did you receive a promotion?
I did.
And what were you promoted to?
I was the first female chief of staff of the Office of the Attorney General, and the first person to work their way all the way up from a line lawyer to a position that high in the agency.
And who did you report to in that position?
I reported to Jeff Mateer, who was the first assistant. Well, actually, probably it was Chip Roy first. I can't remember. It was the first assistant, whichever one was there first.
And eventually to Jeff Mateer as first
Indeed.
assistant?
I think Jeff was their chief of staff, yes.
Okay. May I have Exhibit 553, please? It's not in evidence. It was used, I think, with the very first witness. And I'll offer it into evidence. It's an organizational chart.
Any objection?
No objection, Your Honor.
And I don't have a copy, but what's the number?
It's 553.
553 into evidence. In the future, if you all can give us a copy. Thank you.
Can you see the chart? 553?
I can.
Okay. And what year is this chart reflecting?
This chart, even though it's dated September 2020, I think reflects the organization as of September of 2019.
Okay. And have the names changed a little bit during the time that you were there? I'm interested actually in the divisions and the deputies, the slots. Can you, looking at the far left of the line of executives, can you tell us, as chief of staff, who you worked with during the period of time that you were working with Ken Paxton as your assistant, as your attorney general? Start at the left, if you would.
So there's a different org chart that's now come up on the screen. This organizational chart is the chart from 2019. Before September 1st, 2019. And I'm happy to answer the question. I'm just not sure which chart you want me to answer the question for.
Are we on 553? 553. 553. I'm interested in the divisions.
I understand.
Can you
which chart are you interested in the divisions on? There's 2 organizational charts, and it's different, actually.
How about the one that we're looking at right now? Does that help?
That helps.
Yes?
Yes.
All right. Let's start at the far left of the chart.
Okay.
And can you tell us which divisions you supervised and spent the most time with?
The first assistant supervised all the deputies. However, Mr. Starr and I sort of split the deputies by areas of our expertise to assist Jeff in his management of the deputies. So for me, I was most involved with the Deputy Attorney General for Child Support and the 40 Director, the Chief Information Officer, which is the IT department, the Deputy for Administration, the Deputy Attorney General for Criminal Justice, the Director of Law Enforcement, and if you could shift it over a little bit. And that would be all there. And then if you look above, directly reporting to me was the agency's Public Information Coordinator, who I oversaw. And then I also helped the first assistant with the ombudsperson and the internal auditor.
When you retired, how many years had you spent with the Attorney General's office?
Just the Attorney General's office, somewhere over 20.
Okay.
25, probably. 20, well, probably 20.
And during the time that you were there, would you say you developed certain areas of expertise?
I did over my career develop certain areas of expertise, yes.
And those particular areas, do you actually teach? You teach other people about them?
I have taught other people in the past, yes, about my areas of expertise.
What kind of places have you taught at?
I mean, I've taught at CLEs, I've taught at the National Association of Attorneys General. I was one of their instructor faculty. I've taught about how to run an Attorney General's office, how to fund an Attorney General's office, what do Attorney Generals do. I've consulted with other Attorney Generals across the country about their Attorney General's offices. I've taught ethics. I've taught contracting. I've taught administrative law. I've taught open records many times, open meetings, administrative law in general.
And how about writing? Have you published any publications?
I have. I've published law review articles and other writings, both about employment law, procurement law, administrative law. I'm board certified in administrative law.
I'd like to go forward to 2018, if you would.
All right.
Okay. What building were you officing in at that time?
My office in 2018 was in the Price Daniel building, which is attached to the Supreme Court on this side of the street.
What floor?
The 8th floor.
And who officed around you?
My office was directly next to the first assistants with his assistant in between us. And on the other side was the conference room and then the Attorney General.
So would it be fair to say that the people around you were the executive team?
Correct.
Was it all of the executive team or part of them?
It was part of the executive team. For example, the Child Support Division has its own building out on Old Wharf, and the Child Support 40 Director always had an office in each place. The Director of Law Enforcement and the head prosecutor also had 2 offices, as did the Director of IT. But it was intended to be the executive staff on the 8th floor.
So in 2018, can you tell us a little bit about the quality of the executives that were around you? Who were they and what did you think of them?
Well, I mean...
Your Honor, objection relevance. It doesn't matter what she thinks of them. It has nothing to do with this.
Sustained.
Can you tell us, please, the people that worked with you, did they mirror the policy choices of Attorney General Paxton?
Your Honor, again, relevance. Object.
Would overrule this time.
They did. The executive team was created in order to further General Paxton or any Attorney General's agenda and desires of where they want the office to go. And they did so.
And during the period from 2018 up to 2020, were you aware of how they were perceived by people outside of the office, other professionals?
Objection, Your Honor. That calls for speculation. How can she know what people outside the office thought about these people?
I can qualify.
Sustained.
Are you familiar with how the executive group within your office was perceived by people outside of the office? For example, other professionals in Texas and even outside of Texas?
Objection, Your Honor. Personal knowledge, she doesn't have it, and to the extent she has any, it would be hearsay.
Sustained.
Do you know what the general opinion was of the office from 2018 to 2020?
Objection again, Your Honor. The general opinion of who? I mean, there's almost 30 million Texans. There could be 30 million opinions.
Sustained.
Did the executive team meet regularly with Jim Mateer?
With Jeff Mateer, yes.
Sorry. And at those meetings, would you all catch up on what was going on with each other's departments?
We had a Thursday executive meeting that included, at times, General Paxton and Mr. Mateer and the deputies, and we caught each other up on what was going on, yes.
Can you tell us what General Paxton's involvement with the day-to-day operation of the office was?
His involvement was similar to most other attorneys general. Most attorneys general set the high-level policy and high-level direction of where they want the executive staff to go, and then depend on the executive staff to complete those tasks and to follow that direction.
So, Missy, you had worked in the office for a very long time at that point. As you looked around you at the people that you were working with, how would you describe them?
Objection, Your Honor. Vague and irrelevant.
Sustained.
What kind of group were they?
Again, I have no idea what that means. What kind of group were they? It could be anything. Vague.
Could you be more specific? Thank you.
Was there a description that you used for the people that you were working with? Did you call them something?
I'm sorry to interrupt again, Your Honor. It's the same objection.
I have to sustain.
Of all of the people that you worked with at the Attorney General's office, and again, I know they're like children, right? We don't like to say which ones are our favorite, but as a group, can you quantify them for us from 2018 to 2020?
Your Honor, again, I hate to slow this down, but that question is vague and, as best I can tell, irrelevant.
Sustained.
Describe your office for us in 2018.
Is she, again, vague? Is she talking about the building? I'm not sure what she's talking about, vague.
Yes, Counselor, can you be very specific?
Yes. Can you tell me a little bit about the people who worked around you from 2018 to 2020, your executive team?
It's a compound question. Objection. She's asking about multiple people. We don't know who she's talking about, but to the extent it's more than one, it's compound.
I can take them one by one. If counsel wants me to do that, we can do that.
You're on the clock. Yes, I want you to do that. Ask a specific question.
Okay. Sustain. Be specific.
Did you have an opinion about the people that you were working with, your executive team, during that time period?
Yes.
Tell us what that opinion was.
Objection, Your Honor. Vague. Which person is she referring to?
I'm referring to the entire executive team that we've talked about.
Yeah, we can.
I'm sorry to do this, but she can ask, what's your opinion of Mateer? To the extent that's even relevant, probably not, but this is very vague, and to the extent it's not vague, it's compound.
I'm going to overrule. You can ask the question. You can answer what your opinion was of the overall team.
Can answer the question.
My opinion of the overall executive team was that they were incredibly professional. They were committed to General Paxton's agenda, and it was a credible set of legal minds.
Was part of your responsibilities working with and supervising the security detail group?
Yes and no. Mm-hmm. I did not supervise the security detail because they work for the Department of Public Safety, but I did liaison with the security detail as one of their points of contact, myself and Jeff Mateer.
Okay. How about the scheduler?
The scheduler did not report to me, reported to Jeff, but I did help at times with questions and things with the schedule.
I want to talk with you specifically about spring of 2018, okay?
Yes.
All right. Was there an incident that caused you some concern?
Yes.
And I want to talk about that. Can you tell us where you were when it happened?
I believe you're referring to an incident at the Galaxy Cafe.
I am.
Spring of 2018, I was at the Galaxy Cafe on West Lynn eating lunch by myself. They have very small tables that sit 2 by 2, very close to the person who's sitting next to you. I was alone eating lunch, and there was a man and a woman sitting to the table directly next to me, probably within 3 feet away. And they were having a conversation, and the woman of the group was sharing what I perceived to be very
Objection.
personal.
I'm sorry. She's about to repeat hearsay. I object to that.
Sustained.
As you sat and listened to the conversation, did you overhear some information that you felt was inappropriate?
This question calls for speculation and also hearsay. I object.
Sustained.
As you sat and listened to the conversation, how did you feel?
Objection, relevance. Doesn't matter how she felt. I mean, that has nothing to do with this case.
Sustained.
As you sat and listened to the conversation, did you decide to do something?
Objection, vague. I'm not sure what that means, Your Honor.
We'll overrule.
What did you do?
After listening to the conversation, I took a photograph of this person and took it back directly to Attorney General Paxton.
And why did you do that?
Excuse me, can you move closer to the mic?
Yes.
Thank you, Ms. Carey.
And why did you do that?
Because I felt the conversation was...
Objection, hearsay.
I'm not asking for hearsay. I'm asking what her concern was.
That's not what the question was, Your Honor.
I asked her...
Would you repeat the question?
Yes. You took a picture of the woman. Why did you do that?
I wanted to talk to General Paxton about it, what I saw.
Is security of the Attorney General something that you as an employee were very concerned with?
Always.
Was the conversation that you overheard causing you concern about safety for the Attorney General?
No.
What was it causing you concern about?
Objection, she hasn't said that she was caused concern. I mean, it assumes that she was concerned, and she hasn't told us that yet.
Sustained, you can ask that question.
Were you concerned?
Yes.
What were you concerned about?
The level of personal detail being shared in a public space.
And was it directed to the Attorney General, Ken Paxton?
No.
Who was it directed to?
It was directed to a man who I did not recognize at her lunch table.
Okay. The woman that was speaking, did you recognize her?
No.
Did you do anything further before you left the restaurant?
No.
Did you monitor the woman as she was leaving the restaurant?
Objection, leading.
Sustained.
What did you do?
She's already said she did nothing else, Your Honor. Asked and answered.
Can you rephrase that a little bit?
I can. Before you left the restaurant, did you try to get any additional information about the woman?
I looked at the car she was driving when we were leaving at the same time.
And what kind of information did you get about the car?
I noticed the kind of car it was, the color, and that it was a car purchased in San Antonio.
Okay. You had the picture in your phone, you had the car information. What did you do with that?
I waited for a time when I could talk to General Paxton privately, and I talked to him privately about what I'd witnessed.
Okay. Tell us what you told him.
Objection, hearsay.
It's not offered for the truth of the matter asserted, Mr. President. It's to show the effect on this witness and the actions that she took as a result of it.
Overruled.
What did you tell General Paxton about what you heard?
Basically what I've just told the court, and I asked him if he knew who she was.
What information did you relay to him about what you had heard?
I relayed to him that I was sitting at lunch alone in the Galaxy Cafe, and I overheard loudly a conversation between two people, and that the details that were provided by this person were surprising to me and of concern, and I wanted him to know about it.
Specifically, what details were you concerned about?
This is hearsay, Your Honor. You've already ruled on that.
Sustained.
And I'm not offering it for the truth of the matter asserted. I'm trying to show why she's doing what she's doing.
If it's not offered for the truth, then it's irrelevant.
Sustained.
When you talked with General Paxton, how did he respond?
He told me that I had taken a picture of his realtor who was trying to sell his condo on Enfield, and that he would talk to her.
Did you believe that?
Absolutely.
Was he concerned that someone was talking about his personal business in a restaurant out loud?
No.
Did you believe him when he said it was his realtor?
Yes.
Objection asked and answered.
Overruled.
Did he provide a name for that person?
No, he did not.
All right. Let's come forward now to May of 2018. Did you have an occasion to go to an official function in San Antonio?
Yes.
And did you see someone there that you recognized?
Yes.
And who was it that you recognized?
Same lady I'd seen in Galaxy Cafe.
Okay. A realtor at an official function? What kind of function were you at?
Was at a National Association of Attorney General's reception, a happy hour, cocktail hour.
Okay. Did you get the name of that person?
He was wearing a name tag.
And what was the name?
Laura Olson.
Okay. During the course of the spring and summer of 2018, did you come to learn what the relationship was between Laura Olson and the Attorney General?
I did.
Objection, Your Honor. I'd like to lay a predicate for that. Otherwise, it's based on hearsay.
Sustained.
How did you come to learn about the relationship?
Attorney General told me about it. I was also told by the security detail and the travel aides.
And did you confirm that it was the named Laura Olson, same person?
I did.
How did that make you feel about him telling you that she was a realtor?
Surprised.
That he had lied to you?
Yes.
May I have House Exhibit 623, please? Would offer State's Exhibit 623 into evidence. Mr. President, it's a public record.
Your Honor.
Do we need to redact any of this?
I would think so, Your Honor. This is like a speeding ticket or something.
The information that's going to be put up is going to be redacted. It has been redacted.
Not my copy.
Yeah, nor on mine.
I don't think we should be using this private personal information about anybody talked about in this trial.
The hard copy will be redacted. What's going to be shown has been redacted.
I don't know what they're going to show.
Can you show us the redacted copy? Because ours is not redacted, nor counsel. We'll break in 15 minutes. We're going to continue to the top of the hour.
Thank you, Joe.
I'm sorry, we're not. I said we're going to break in 15 minutes at the top of the hour. Oh. You may stretch your legs if you like, senators, but we're going till the top of the hour.
If I may, I'm going to move on and we'll come back to this exhibit.
Okay, we'll come back to that exhibit. Continue.
During the spring and summer of 2018, were there some things that were happening within the office concerning Laura Olson that you were having to deal with?
Yes.
Specifically, were there problems with morale?
Yes.
In which areas of the office were you having difficulty?
Travel aides, security detail, Mr. Mateer.
How about the scheduler?
To the witness, can you repeat that? We couldn't hear you clearly.
The travel aides, the security detail, and Mr. Mateer was my answer, Your Honor.
Let's talk about the travel detail. What kind of problems were you having to deal with?
The travel detail was calling about the hours they were working, the places they were being required to go, and they were concerned about the general's behavior.
Okay. How about the bag man? What is a bag man?
It's a travel aide, and the travel aide is the employee at the Office of the Attorney General that's generally assigned to the Attorney General, does things like make sure they're on time, has their speeches, make sure you get to the venue on time, keeps time, sort of time management, holds on to those it's a close aide.
Were there
personal aide.
Were there problems with the bag man as well?
Yes.
What kind of problems?
Complaining about the hours worked that weren't state business, expressing those concerns to me because I approved their leave or required them to take particular kinds of leave for non-state business events.
What kind of complaints were coming about the hours?
Too long hours, no vacation, odd hours.
Were there complaints about security concerns?
Your Honor, I'm sorry to interrupt. We're talking about 2018.
We are?
Some complaints in the office from 2018 that has nothing to do with any of the articles of impeachment, I would object to be irrelevant.
Overruled.
Complaints concerning security. What were the worries?
Similar concerns.
Which were what?
Hours worked, non-state business, disorganization, and changes to the schedule.
Issues concerning not state business. What kind of things?
I mean, I think the affair was one of the concerns that was not state business. So were some of the different switches in the schedule between campaign events and state business.
Who is J.B. Skis?
He was General Paxton's travel aide at that time.
And for the court reporter, it's S-K-E-E-S. Is that correct?
That's correct.
All right. And what kind of problems did you have with him, if any?
I personally didn't have problems with JB. JB quit unexpectedly and refused to tell me or Mr. Mateer why.
You ever had that happen before?
I have not.
Okay. Were there issues with the Attorney General's wife that you were having to deal with as well?
At some point in time, Mrs. Paxton was calling the office, asking about the schedule or asking where he was, and the staff was uncomfortable sometimes answering those questions, and they were complaining about that.
Why would they be uncomfortable?
Objection, speculation.
Sustained.
Do you know what caused them to be uncomfortable?
Only what I was told.
And what was your understanding?
This question is going to be relating hearsay, which you just set it up as hearsay, so I object hearsay.
Sustained.
With a problem like that, with the problems that you were having concerning morale, what did you do?
(2018)
Yes.
I talked to Mr. Mateer. He and I talked about it. I also had a conversation with General Paxton directly by myself about it.
Okay. Let's stop and talk about that. Do you recall when that was?
I cannot be precise, no.
Do you recall what time of year it was?
It would have been the summer of 2018.
All right. Where did you have that conversation?
In my office.
Okay. And what did you talk about?
Objection. To the extent she's going to relate what she said, that would be hearsay.
She's here for cross-examination.
Sustained.
What was the topic of conversation?
Objection, asked and answered. She already told us what the topic was.
Overruled.
What was the topic?
The topic was the ethical implications of a secret affair.
Were you able to relay your concerns?
Yes.
Did he confirm that he, in fact, was having an extramarital affair?
Yes.
And did he tell you that that was with Laura Olson?
No.
Not at that time?
No.
All right. What was his attitude when you told him that things were not good within the office because of that?
He was contrite, and he listened to what I had to say very carefully.
Did you get the feeling that he thought it was none of your business?
Maybe. But we had a good conversation,
Okay.
a productive conversation.
Were you able to help him understand why it was affecting the life of the office itself?
I tried to do that.
How did you do that?
We talked about what had happened to previous public officials that I had counseled in similar situations. We talked about previous public officials and what happened to them in similar situations. We talked about the risk involved in secrets of this magnitude that began to bleed over into the work of the Office of the Attorney General.
What kind of risks are there?
I mean, there's ethical risks, there's political risks, there's legal risks.
What kind of legal?
These things can open one up to bribery, misuse of office, misuse of state time, things like that.
How did he receive that information?
Well,
Okay. Did you make a request of him to tell his wife, Angela?
I did.
How did that conversation end?
Contemplatively, and then he left my office.
Were voices ever raised during this conversation?
Not in this conversation, no.
All right. Based on what you know of him and your experience working with him, how does Attorney General Paxton react to confrontation?
He's generally very patient, and he listens well, and he takes in information. So I would say he reacts well to confrontation.
Let's come forward to October of 2018. Was there an occasion that you went to the campaign headquarters?
I did.
Right.
I think that was actually September of 2018.
Okay. And who was present at that time?
Gordon Berry, Jeff Mateer, Brantley Starr, Ben Williams, Mark Rylander, I think, perhaps, myself. And I'm not sure, I could be leaving somebody out, but that's the ones that stand out.
Okay. And what was the occasion?
We were invited to meet with General Paxton and Senator Paxton to talk about this matter.
This matter being what?
The affair.
Okay. Would it be fair to say that General Paxton confessed the affair to all of you?
I think that'd be a fair characterization.
Okay. Did he apologize to all of you as a group?
Did.
Okay. Describe that experience very briefly, if you would, please.
An uncomfortable experience. An experience I had not had before in my life. Somber. Be a word I'd use.
How did General Paxton's wife take it? How was she responding?
It was sad and embarrassed, I believe. That was my impression.
Was she crying?
She was.
Right. When you saw that, what did you do?
My heart broke for her.
And what did you do?
After the meeting had concluded, I think I hugged her, and I think I told her that I was sorry this had happened to her.
Okay. What happened after that?
We broke up and went home. Went back to work.
In September of 2018, after that meeting, did you believe that Laura Olson was out of his life for good?
Again, at that point, I didn't know her name, but I thought that this type of behavior was out of his life for good, yes.
Let's talk about August 1st of 2019, coming forward now in time. Was there a change in your duties?
Yes.
What happened?
Judge Starr was being promoted to the federal bench, so there was a vacancy in the deputy first assistant position, which was equal to mine, both reporting to Jeff and helping manage the deputies in the way I described in the exhibit. I was told that that was going to change, and when the new deputy first assistant came in, who was Ryan Bangert, that my duties would be changed and I would be reporting only directly to Mr. Mateer.
Okay. Did you receive an explanation as to why those changes were being made?
It was my understanding that those changes were being made at the general's request because I had said no to him too many times, is what I was led to believe.
Let's talk about that. What kind of things would you
Counselor,
say?
excuse me. The jurors have been here for 2 hours. Can we break? Fine.
Certainly.
Members, come back at 3:20. 20-minute break.
Stay right here, sir.
You can step down.
Well, we've been listening to testimony from Catherine Missy Carey. Missy Carey is what she's known as. And she was the chief of staff for General Paxton. She's been describing for us what happened in terms of her discovering that General Paxton was having an affair with Laura Olson and the details of what happened afterwards. You're taking a look right there at State Senator Angela Paxton. Somewhat uncomfortable, I would say, testimony, Tony, with Missy Carey describing this meeting that they had when Ken Paxton admitted to his top staffers, his wife was there, that he had been having an affair and their interaction.
And actually, this marking a turning point in this case, in the rollout of this case, because yes, we have known there was an affair. Yes, we have known the woman linked to Ken Paxton. But this is the first time anyone is taking us in a more intimate way inside the conversations between Ken Paxton and his staff about this alleged affair. And an alleged affair that they contend, Ashley, was not just a private, personal matter, but one that spilled into his work. Missy Carey saying that she was concerned about the ethical implications of this affair, the political ramifications potentially of this affair, tried to warn him, and she said that she thought after they had a meeting in 2018 that this alleged behavior was over.
And legal implications, because she said that affairs can open yourself up to bribery, and that was one of her concerns, and certainly
that she raised,
and that's certainly some points of the articles of impeachment. I want to talk about Carey for a little bit. Mm-hmm. You know that this is a turn in the trial and the prosecution's case. She is not a whistleblower.
Correct.
And her demeanor on the stand as she is being questioned by the prosecution, she does not appear to be as willing to talk about details and answer within giving a lot of context. She is almost a little more reserved in her answers, as though it seems to me, it feels to me as though there's still some loyalty towards the Paxtons.
I think 100%. I mean, it's hard to obviously assign, motivation to someone. But to your point, Ashley, and maybe this is part of it as well, I think the whistleblowers feel like they are personally and professionally under attack and have been.
And they were.
Yes, exactly.
They were.
And I think they saw this as their opportunity to defend themselves, even though they're not directly accused of any wrongdoing. In fact, many people see them as the heroes in this story, depending on how you view what's coming out, and frankly depends on which side of the political aisle you are on.
Sure.
But when you look at a person like Missy Carey, we're talking about a government employee essentially her entire career. She talks about someone having grown up with her father working in the Attorney General's office. And I can just tell you, a lot of those types of employees don't want to be front and center. They see their role as always working to position publicly the official, the elected official, while they work behind the scenes. And so I think she is reticent. She certainly seems reticent to be there, to be part of this, not enjoying herself by any stretch of the imagination.
No. And also interesting to me, Tony, is when you think about the implications, you've mentioned this off camera, she resigned from the office.
That is my understanding, yes. And before this blew up.
Before all of this was happening. And we want to take a moment to just talk about her career as an attorney. She was the first female chief of staff in the Attorney General's office. And she is the first person to ever work themselves up from being sort of a line attorney all the way up to chief of staff. And so you take this as this is someone who is accomplished in their career, who worked very hard to get to where she is, and historically it's significant because of what this means for the first woman to hold that role. And so now for her to be put in this position, sort of having to testify against the person who put her in that position, seems very uncomfortable for her.
I think it's uncomfortable for a lot of people, but I think especially for her, because the others have previously been public. They have made these public positions. They have filed a lawsuit with their name. Their names have been linked. And as I mentioned too, to my knowledge, this is the first time Missy Carey's name has really been made public in this now extremely public way.
Yeah. And her again appearing to not be reticent to talk about it. One of the things that she did as chief of staff was she oversaw the security detail,
right,
and the body man, the people who were with Attorney General Paxton, and how some of this was bubbling up to her level was they were complaining to her about the hours that they were having to work that weren't business hours, that were not things directly related to the Office of Attorney General. So not only the number of hours they were having to work, but the hours of the day that they were having to work and go, and they found that to be strange. The places they had to go.
And the word that keeps coming to my mind as I'm listening to her testimony is this notion of loyalty. Not only her loyalty to the elected officials she's working for, but also this sense of him being loyal to her. And so, to think about her sitting at Galaxy Cafe having lunch by herself and being so concerned that she took this step of photographing this woman who was talking about Ken Paxton in this personal way, noted her car, went to Ken Paxton, and he clearly was not honest with her, was not truthful with her.
I think we can say lied.
I think we can say lied. Lied.
That was his realtor.
Yes.
And that she was selling a condo on Enfield. We know that to not be true. That is a lie.
Correct. Yes. And with intent to, not just an omission of truth, but to your point.
But and seemingly to cover up this affair that he was having. And it wasn't until a few months later that she saw the woman again at an event, a political event, and saw her there, and then came to learn that she was not a realtor.
Right.
And that she was in fact the woman. And she talks about having a meeting with Paxton, that talking to him in his office and him telling her about it, and her saying to him, you need to
tell your wife. So, again, I think it just speaks to the level of loyalty, of trust, a level of confidence, that goes on between elected officials, public officials, and their high-level staff. Clearly, to your point, we've seen that the whistleblowers there is no love lost when it comes to Ken Paxton, but Missy Carey, you can tell, is still
this is different,
and she's really trying to, almost in real time, seemingly reconcile all of this.
Well, and we weren't asked the previous witnesses, the whistleblowers. We didn't get into these details. Besides Jeff Mateer telling us about the meeting. So after Carey had a meeting with General Paxton, shortly thereafter, General Paxton had that meeting with his top staff. His wife was there, and that's, as I said, when he confessed to them the affair. But he was the only person we heard even mention it. But Carey, obviously, especially because of what happened at the Galaxy Cafe, had more of a first-hand knowledge and a front seat to sort of this.
And literally talk to him about it.
Exactly. And believe that it had stopped.
Yes.
Believe that it had ended. And one of the things that you all can't see, but we do have a photographer on the ground during all of this, Carey was describing that after that meeting with the staff and Senator Paxton, that Senator Paxton was crying during the meeting, obviously visibly upset, as her husband is confessing this affair to his staffers, and that Carey says she went up to Senator Paxton and hugged her and said, I'm sorry that this happened to you.
Yes.
And our photographer was positioned on Senator Paxton, and we can tell you she remained straight-faced, no emotion, just making notes on a pad, and did not show any, semblance of emotion, which I do think is what we would expect given this situation and given what we have seen, how we have seen Senator Paxton acting throughout all
Well, and the truth is, when you think about this, 2018 was 5 years ago.
Sure.
So it's no news flash to Angela Paxton that her husband was having an affair.
But surely still at the same time has to be uncomfortable to have any detail, frankly, of your husband's affair out, not only for
the
not
world
only in
to
the
see.
public, but
Yes.
then on the Senate floor, where you serve.
Yes.
And this is now the subject matter. This is all we're hearing about. You would imagine it's uncomfortable. And let's talk a little bit about the woman, Laura Olson.
Yeah, I mean, she is a former Capitol staffer. Clearly we don't know a lot of the details in terms of how they met. I do want to point out there is Angela Paxton. You can see her there. That is
Dressed
her.
in
Yeah,
that
dressed.
red suit.
Yes, dressed in the red suit.
You say former Capitol staffer of State Senator Donna Campbell, who is a juror, who is still serving, who is sitting on the floor
Yes.
listening to all of this as well. We want to note, that was one of what they saw as a potential conflict. There are many potential, or we can just say conflicts of interest within this trial because it is politics and so many of the people are tied together. So, notable there.
And
she's
in
also
fact,
someone who's known within GOP circles. I mean,
Yeah.
she's
Yeah,
been
absolutely.
friendly with the lieutenant governor, had access to people.
Former colleague of mine from the Statesman, posted a photograph of Laura Olson and Dan Patrick at some public event, just sort of again pointing out the awkward nature of all of this.
Yeah, it's certainly awkward for everyone. Let's take a step back while we still have a good amount of time and talk about the witness that we heard from before Kerry took the stand. So this morning's witness.
And exactly. And so we are still sort of going through that testimony now, just trying to understand the ways that it did or did not move the ball. But that person's name was Mark Penley. He is one of the whistleblowers who did file suit. Again, his testimony is seen very favorably for the prosecution. But once again, we saw Mitch Little, a member of Paxton's defense team, really trying to land assaults on him to discredit him. And, Ashley, I know that just in terms of what some members of the far right or members of Paxton's group, his supporters are saying, they, again, sort of are reframing this in a way to say that, oh, no, Mark Penley's testimony was, in fact, favorable for Ken Paxton.
Well, and it hedges on this idea in terms of, for Paxton supporters, of evidence and whether or not there was evidence and whether or not there was hard, tangible evidence, if you will, that they had before they went to the FBI to report Ken Paxton. It's interesting,
and the prosecution really hanging their hat on, the defense hanging their hat on that.
And that's interesting because, again, and Penley pointed this out. He said, well, I didn't have to present evidence because it was our initial, this was our initial concern. We were having this conversation with the FBI because we were concerned, because we did believe there was wrongdoing. We did believe our boss was being blackmailed. We thought that our boss was engaging in activity that was not good. It's interesting. Someone asked, why are the things with the mistress, why is it relevant?
There's an answer to that.
And there is an answer to that. Do you want to
Sure.
answer?
Yeah. So part of the whole picture here is that Ken Paxton is accused of benefiting from his aid to Nate Paul. And one of those major alleged benefits is that Laura Olson got a job with with Nate Paul's company. And so the allegation is that a benefit Ken Paxton received was employment by Nate Paul of his mistress, who, by the way, moved from San Antonio to Austin, according to House prosecutors, so that she could be closer to Ken Paxton.
That's Article 9. It is Article 9, constitutional bribery, that he is accused of. And I think this also could speak to some of the other articles. The last 5 articles of impeachment against Paxton are just abuse of public trust, misuse of public resources, the unfitness for office. So if you are saying that he used public resources his security detail and things of that nature to carry out an affair. That's what it speaks to, those articles. So they're not just saying this in a way to sort of be salacious and say these things.
Right.
It's directly related to the actual articles.
Charges against him.
Right.
So again, a live look now at the House floor. We're on break and for what, another 6 minutes? Is that right, Ashley? Did he say 3:20?
Yes, he said 3:20, so we'll see if they hold to that 3:20.
You know, certainly a kind of a rough start with Missy Carey's testimony. We saw an attorney for the House impeachment managers who we had not previously heard from. She Teresa Booth of Houston, correct?
Yes.
Who is clearly part of this prosecution team, but who is not previously questioned a witness. And we saw Tony Busby frankly aggressively go after her line of questioning, whether or not it constituted hearsay, whether or not her questions were clear. It seemed like, the first several minutes of Missy Carey's testimony were about that, but then things seemed to level off, if you will, and Teresa Booth was able to begin a line of questioning. You can see there Tony Busby. He was the one offering the objections to the questions Teresa Booth was issuing. So what we take that to mean is that Tony Busby, because he is sitting first chair during this portion, during this witness, is that he will be the one to cross-examine her. The first cross-examination by Tony Busby since Jeff Mateer. Is that right?
That's correct. And you know what, Tony, I think will be interesting to watch in terms of what we're looking for in that cross is whether or not Tony Busby takes a different tone when he's talking with Carey. And I'm not saying take a different tone because she is a woman and she is the first woman to be on the witness stand, but because she seems to have some reluctance.
Yes. And she didn't go to the FBI.
Right, and she didn't go to the FBI, and does seemingly still have some loyalty based on how she's answering the questions, what she's telling. She's not giving us a lot of extra details or a lot of extra answers here. And so it will be interesting to see what tone he takes when he talks with her. Is he coming with her as if she's an ally or if she is an enemy, which is how he and the other defense attorneys have been treating the other whistleblowers?
Exactly. And just in terms of what we can expect, obviously, the afternoon likely will be chewed up with Teresa Booth questioning Missy Carey on direct. And then I think in addition to that, it is possible that we could get to cross-examination, Tony Busby's cross-examination this afternoon. I think it's probably a near certainty that this testimony by Missy Carey will spill into tomorrow. But if you missed this part earlier, Lieutenant Governor Dan Patrick earlier today said that this case could go to the jury later this week with deliberations possibly into the weekend. He did make it clear that no matter what, the work will continue nonstop through the weekend on Saturday and Sunday.
Yeah, lucky us.
Well, and Ashley, you have made the point that the Senate, their strong preference is to not work on Sunday.
Yes, I've been covering the Senate for a long time now, and they do not take kindly the senators to working on Sundays. They generally try to get their work done ahead of that. And so if we are living in a world where the Senate receives the verdict, if the Senate receives the case,
yes,
a Thursday night or Friday morning, I certainly think they're going to try to push through Saturday
and get
nonstop and get it done. And so, whereas maybe if you've served on a jury, you deliberate for some amount of time and then you're allowed to go home and go to sleep. I don't think we're going to see that happen on Saturday if they are still deliberating.
And again, keeping in mind, I think that we can all predict that they will take some measure of time to deliberate.
Absolutely. It's 16 articles.
But at the same time, we presume because of the politics around this, which are heavy, that many of them have an inclination, walked into the whole process with something of an inclination about how they would vote in an outcome.
I think the thing that made that very clear is when we were looking at the motions. And the votes on the motions. And you all, if you were joining us on KVUE, we carried that live on television because of the significance. There were several motions, I want to say 16, that the entire Senate had to vote on. And that was because those were motions that could have resulted in the dismissal of one or more of the charges against Paxton. And there was not a majority vote on any of those. Clearly, we're here to this point, so you know that that's the case. But there were a hard 6 senators who, on every motion, voted to dismiss. And I don't think you get any more loyal than that. I mean, even some of these saying that they did not want to move forward at all with this. They wanted to just dismiss them all. You can't imagine that someone who walked in saying we should just dismiss them all. We should throw away what the House did. We should throw away the countless dozens of pages of articles that the House submitted. We should not even hear this. We should just dismiss this whole thing. That clearly tells you how they're going. How they are going to.
Yes, exactly. And then again, they would need to, for a conviction, House prosecutors would need to pick up 9 Republican senators to push the impeachment
to side
over
with the Democrats. That's assuming that the Democrats are going to vote to convict
all of them. Yes, all 12.
All 12. And so, you know, it is interesting to see how that plays, because also you could have had senators voting again. This is politics, right? So while we want to remove political affiliations, it did not do Ken Paxton any favors to be an impeached attorney general. He would have always been an impeached attorney general if you had not. If you voted to dismiss, he would still have been impeached attorney general, opposed to impeached and acquitted attorney general. Correct. Which some might argue, if you are a Paxton fan, a Paxton supporter, you would want to get his story out there. You would want it to see that he was tried in this court of the Senate. And we found that there was nothing, that this was all, you know, as they would say, a sham, that this was.
And while Republican senators have not made public statements about their reasoning for their vote, they have gone to great pains to say that as jurors, they are not able to make public statements. But so we can't, to that end, really know what was in their mind and the reason they voted the way they did.
And when we say they go to great pains, that's so true, Tony. They put a gag order in the rules. So some people note the timing of the gag order, or when Lieutenant Governor Dan Patrick issued the gag order. But in the rules, the senators wrote and voted that they had to be put under a gag order. Correct. So they kind of made their own playbook of, we're not going to talk. We've decided we're not going to talk about this, and to ensure that we're going to have a gag order.
Release public statements. I think Donna Campbell, released a public statement saying, thanks for calling, thanks for emailing, but as a juror, I'm not going to be able to engage in this conversation.
Drew Springer also making those types of comments.
Will you bring the witness back?
And so they are now bringing the witness back in to the stand. So again, if you're just joining us, that witness, her name is Catherine Missy Carey. Missy Carey is how people know her. She's the former chief of staff for Attorney General Ken Paxton, not one of the whistleblowers.
Correct. The first non-whistleblower witness we are hearing from during this proceeding. And again, sat at the right hand of Ken Paxton. And what is distinguished, I think, by her testimony among the others who have testified is that she's really taking us inside her, not only professional but also personal relationship with Ken Paxton and her effort to help him navigate the disclosure of this affair. So she's walking back to the witness stand now. We're going to go to her and continue this testimony.
And remember, she is, interestingly enough, we're just getting a message because, again, we have a camera down. Senator Boris Miles just went up to Senator Angela Paxton and gave her a hug, embraced her. Because again, this has to be somewhat hard for her to listen to. Let's listen back into the testimony.
Can you hear me now? Okay,
I can hear you.
Okay.
Do you have an exhibit in front of you, Lacey?
I do not have an exhibit in front of me. The screen is blank.
Defense has it, 623.
did. I ignored you.
Missy, can you give me the number on there, please?
Exhibit number 623.
You recognize the person on there?
I recognize the name, yes.
You recognize the photograph that's on that exhibit?
I recognize the photograph to be Ms. Laura Olson, yes.
Is that the person you saw at the Galaxy Cafe?
To the best of my belief, yes.
Is that the person that you know to have been having an affair with Ken Paxton?
Yes.
All right. Your Honor, this time I would offer an evidence number 623.
I don't have a copy of the redacted one, or do we now? I'm not sure if we... Is it 4 pages? Yes, Your Honor. Okay, thank you. Is there any objection?
No, Your Honor.
Admit exhibit number 623 into evidence.
Thank you. The photograph that you took in your phone of the woman at the Galaxy that we now know to be Laura Olson, what did you do with it?
I deleted the photograph at the General's request.
Did he ask you to do that when you first talked with him about the woman?
He did.
When he told her it was his realtor?
He did.
All right. I want to come forward now to the summer of 2019. Were there continuing to be problems within the office, the type that we had talked about already?
Those problems began again, yes.
Okay. Who were you hearing from? I'm not asking you what they told you, but what people within the office were talking with you?
Travel aides, Mr. Mateer, the security detail.
Were there problems that were happening outside of Austin?
Yes.
All right. Was there a further conversation that you had with Ken Paxton concerning the affair?
Yes.
Did you learn that the affair was continuing?
Objection, speculation, Your Honor.
Sustained.
Thank you. Did you learn that it was continuing?
Objection, speculation, Your Honor, and anything that she would have learned. Let me finish, please.
Been ruled.
Excuse me.
Anything she might have learned, would it be based on hearsay or speculation?
Sustained.
Did you have a conversation with Ken Paxton during that time period?
I did.
That'd be the summer of 2019?
Correct.
Let's talk about that conversation. Where did it happen?
In my office on the 8th floor.
Did you initiate it or did he?
He did.
And what did you all talk about?
We talked about Miss Olson again.
And did you learn that the affair was continuing?
Yes.
Did he tell you that?
Yes.
How did he tell you that? What kind of voice was he using?
He was frantically upset.
At who?
I think he was frustrated, and he wanted to express to me that he was frustrated with me and that I didn't understand what he was trying to tell me. And he was trying to tell me, he came in and said he was frustrated and that I didn't understand. He still loved Mrs. Olson, and he wanted to work it out with me.
What did you take that to mean?
For me to be more accommodating as far as the security detail, the travel aides, any of his requests.
So in your very first conversation, when he first told you he was having an affair, had you given him some advice, some professional advice?
I did. I gave him ethics advice.
And what was that advice?
The ethics advice in 2018 was that when you try to keep things secret and you're a statewide elected official who's running for office, that it could be both ethically, legally, and morally challenging, and that it was beginning to bleed over into the office.
And is that what you were seeing?
Yes.
All right. Your second conversation in the summer of 2019, did you give him some similar advice?
I gave him the identical advice.
All right. Did you tell him that he needed to get his life in order so that the office could get back on track?
I did.
And leading and hearsay.
Sustained.
What did you tell him he should do?
Objection, hearsay.
It's not hearsay, Your Honor. She's the declarant, and Mr. Busby knows she's available for cross. He can have time with her when I'm
Overruled.
done. You can answer.
I told General Paxton quite bluntly that it wasn't my business who he was sleeping with, but that when things boiled over into the office and into the state work, that it had become my business, and that I was having concerns about how the time and the effort of the travel aides, the security detail, and myself was being spent.
And I want you to tell us what his demeanor was when you told him that.
He was angry with me.
How could you tell?
He raised his voice loud enough that it was heard outside my office, even though the door was shut. He was, his hands were waving. He was red in the face. He was upset with me.
How did that conversation end?
He stormed off out of my office. He ended the conversation.
Now, you mentioned that your duties had changed. Were you still managing all those different departments?
I was until September 1st of 2019. So at that time of the conversation, was still helping manage those departments.
Okay. I want to talk a little bit now about outside counsel contracts. Is that an area of your expertise?
It is. When I was the general counsel of the Office of the Attorney General, it was my duty to process those, read them, approve them. I wrote the administrative rules regarding those contracts. I wrote the contract form, so I'm very familiar with the outside counsel contract process.
In your time at the Attorney General's office, have you approved and actually evaluated a few or many of those contracts?
Thousands of those contracts.
All right. So you're very familiar with them?
I am.
Do people come and talk to you and ask questions about outside counsel contracts?
They do.
In fact, they ask you about a lot of things in that office, don't they?
They do.
All right. All right. I want to talk a little bit about the rules, because there are rules within the Office of Attorney General, are there not, for approving those contracts?
There's a procedure that's published on the agency's website, and there's also the Administrative Code, Texas Administrative Code 1 TAC, Chapter 57. It's related to outside counsel.
Let's talk just a minute about the procedure. Within the Office of Attorney General, when one of those contracts is being drafted up, what's the approval process? Very quickly.
For a contract for the Office of Attorney General?
Yes.
Those contracts are generally initiated by the deputy that's interested in having the contract. It's routed through a sort of an audit procedure, which is called the Executive Approval Memo. Down in the General Counsel Division, the form is filled out with the pertinent information. There's a contract number that's established. It's put into a computer system, and it's reviewed for the requirements of the Appropriations Act and the rules.
Is there a requirement that there's some kind of finding concerning the best interest of the state?
I think what you're referring to is in the Appropriations Act, Article 9, Section 1601A. There's a requirement before you can spend appropriated funds on an outside counsel for the state. A determination needs to be sent in writing to the controller that the contract is in the best interest of the state and that can be paid.
Is there also a requirement that the attorney who's being hired be qualified?
There is.
For the particular job at hand?
There is.
And do you have to have money allotted for the contract?
Yes, it helps.
That part of the
helps
procedure?
to have money allotted for the contract, yes.
All right. So
unless the attorney's working for free, but...
The forms that were used within the Attorney General's office during this time period, are they the forms that you designed?
They are.
And the procedure where everyone has to sign off, all the different levels, was that something that you worked up?
Something I was involved in working up, yes.
Okay. And it's computerized now. Was it always that way?
It was not. It used to be in paper with a routing sheet on top.
All right. Are applications for those types of contracts given identifying numbers when they're going through the process?
They are.
And is that important?
It's an important tracking mechanism to track the contract and that it's in the system and that it's approved, and it also allows the accounting division and the budget division to know which funds to pay that contract, which funds to direct the controller to pay the contract out of.
Missy, can you tell us when you first heard the name Nate Paul?
Not with precision. The first
Ballpark.
Probably 2019, and I heard that name come up in the weekly updates from David Maxwell and Mark Penley.
Were those at the meetings of all the deputy chiefs?
At times, and there were also private meetings at a regularly scheduled time with Mr. Mateer and myself and that particular deputy.
And what was the context of hearing that name? What was going on?
I was aware that at
Objection. I'm sorry, Your Honor, to interrupt. This is based on hearsay. Objection, hearsay.
Not offering it for the truth of
Sustained.
the... Missy, when you heard the name Nate Paul, what was it in context to?
Your
what
Honor,
was it related to?
Can I finish, please? It's the same question, hearsay. Objection.
I'm not offering it for the truth of the matter asserted. I'm trying to show the context in which she's known that name.
That's not an exception to the hearsay rule, Your Honor. It's hearsay.
Sustained.
When you heard the name of Nate Paul, did you do anything? Were you involved at all?
No, I was just listening
Okay.
to the updates.
At some point, did you become aware of a contract?
Objection, Your Honor. Hearsay.
I'll
You
reword
just
it.
said she wasn't involved and
I'll
she
reword
heard
it.
about it. So everything she knows about it, somebody told her.
I'll reword it. At some point, did you become aware of a contract that had been set aside for Brandon Kamek?
Yes.
When did you learn about that?
I recall being told.
Objection. I'm sorry, Miss. Your Honor, she's just telling us right now that everything she knows is hearsay.
I'll reword it.
Sustained.
Without telling us what somebody said, tell us first of all the time frame of when you became aware of it.
I'm just not sure I can tell you the exact time frame.
Okay, a ballpark's fine.
No, it's not, Your Honor. That's pure speculation. Ballpark is not good enough under oath in court.
Sustained.
Did you get a phone call from General Paxton about a contract for Brandon Kamek?
I did.
When did that happen?
September 28th of 2020.
All right. Where were you?
I was at my ranch in Mason, Texas. I got a call on my cell phone.
Okay. Was this COVID? Were you at home?
I was.
Working from home?
I was.
All right. The first contact you had, what was it from the general?
The Attorney General called and asked me for some advice, given my experience in the outside counsel world, about an outside counsel contract he was interested in entering into with Brandon Kamek. And so he called and asked me how the process worked.
And what did you tell him?
I told him how the process worked. We talked about the statute. We talked about the rules. We talked about the internal procedure of how it worked. He was interested in pursuing an outside counsel contract with him.
On September 28, did he make you aware that there had been a problem with the contract that was going through the office for signature, for approval?
He did.
Did he tell you who was holding it up?
He did.
Who did he tell you?
Mark Penley.
And did he ask you how to get that contract in effect without that signature from Mark Penley?
He did.
What did you tell him?
I told General Paxton that I believed, given my experience, that he, as the Attorney General, could sign an outside counsel contract with Mr. Kamek if he followed certain procedures that weren't able to be waived,
Okay.
which is the best interest standard in order to pay him. Then I also told him he could waive in writing based on 1 Texas Administrative Code, Section 52.7C, that if the Attorney General or the First Assistant waives the internal procedures in writing, then they can all be waived, the ones that aren't statutory or required by the Appropriations Act.
So the waiver can happen by the Attorney General or First Assistant, but it has to be in writing. Is that correct?
That's what the administrative rule says.
All right. You also mentioned that despite that, the standards of whether or not that contract is in the best interest of the state still applied. Is that correct?
Standard of whether the contract met the best interest of the state in order to be funded still applied, yes.
All right. So he can sign a contract on his own as long as he provides a written waiver. How about funding?
So at the Office of the Attorney General, there isn't an account set aside for outside counsel contracts. The money has to be moved from what is called the First Assistant's Reserve, which is some funding that's at the First Assistant's discretion. That money can be moved by in writing to the budget people and set aside the money. Then the money is coded and applied to the outside counsel contract.
So can be done, but should be done. Are those two different questions?
They are.
Did you talk with him about whether or not it should be done?
I did.
What did you tell him?
Since he had already told me that Mark Penley was refusing to sign, we talked about why that could be, that Mark Penley didn't want to sign, and why Jeff also did not want to sign, and that it was going to be really hard to get over the best interest standard until we resolve that, which is the funding part, not whether or not it was legal for the Attorney General to sign his own outside counsel contract.
Okay. How did he respond when you told him that?
He was very appreciative of the advice. He asked me if I could text him the statutes and the rules and the procedures so he could see what we were talking about, and I did that.
Before you hung up with him, did you tell him this was ill-advised?
I did.
Objection. Leading.
Sustained.
What did you mean by ill-advised? In your opinion, what does that mean?
Your Honor, if I could, I mean, obviously you sustained the objection and now she's going right back at it and now testifying herself.
Would you sustain or would you?
I'll reword it.
Reword it.
When you advise someone that a contract shouldn't be done, can be done, but shouldn't be done, how did you tell them?
I would have used the word ill-advised. That's just kind of a word I use.
And did you tell him why it was ill-advised?
I did.
What did you tell him?
I told him that his senior staff felt like that this contract was a problem and they didn't want him to do it, and that we needed to resolve that and be on the same page.
Okay. Was there continued contact from Ken Paxton concerning this contract?
He emailed me back the next morning after I sent him the stuff in writing and said he appreciated it. He did call me back again the next day, a couple hours later, and we had the conversation again. We talked about all these same things again, I think he might have reached out to me on October the 1st, but I did not return that call.
Okay. That last phone call you had with him, what was the content of it?
It was very similar to the content of the first conversation.
So he wanted to know how he could do it?
Follow-up questions about, now, didn't you say that I could do it this way or that way? And we went through that again, and how the funding worked again, and how to make it happen.
That last phone call that you had with him about how to make it happen, did you talk with him again about why he shouldn't make it happen?
My recollection is I was much firmer on how strongly the executive team felt that it was ill-advised.
Okay. I wanted to talk about his demeanor on the telephone during that particular phone call. Would you describe it?
The second phone call?
Yes.
His demeanor, it was like I was on speakerphone and somebody else was listening, which concerned me.
Why did you think that?
Your Honor, I'm sorry. I'm going to have to object. This is rank speculation, and I object under 602.
Overruled.
You've known him for how many years?
Since 2015.
You've known him through good times and bad times?
I have.
Tell us, based on your knowledge of him, what your impressions were of that phone call, of his demeanor.
It was unusual. It was like I was speaking to somebody besides him, because he's very bright and he knew exactly what we had talked about the day before, and it was a repeat of the same thing, like I was playing to an audience.
Did you think that it was a phone call where it was a private phone call, like telephone to ear?
Objection again, Your Honor. This is speculation. She doesn't know if anybody was there with him, and she's just speculating.
I'll ask it a little differently.
Yes.
Did you have an impression that you were not on a direct private telephone line with Ken Paxton at that time?
I was concerned about that, yes.
What did you think?
Again, Your Honor, what she thought is irrelevant, and it's also speculation.
Sustained.
That phone call obviously made you very uncomfortable. You've said that. What about it made you uncomfortable?
General Paxton's persistence to do this, knowing his senior staff objected, which was very unusual. And it was also unusual to me that he chose to call me and talk to me about it, since we were not on the best of terms.
Let's talk a little bit about these types of contracts. To create a contract and assign responsibility to an outside attorney, are there certain parameters and limitations?
So the outside counsel process was designed in order to protect and preserve the Attorney General's office's constitutional and statutory duties to represent the state. So necessarily, a grant of an outside counsel approval is a granting that, in the first instance, those activities would have been within the course and scope of something the Attorney General's office could do, if that makes sense.
And are the scope of duties of the Attorney General's office lined up with civil law? In other words, are they civil properties?
I mean, it's civil. There's civil parts of it. There's also the ability of the Attorney General's office to assist prosecutors on request.
Okay.
If that's what you're asking.
That's what I'm asking.
Okay.
So talk with me for just a minute about how we get to prosecution. What has to happen? What has to happen for the Attorney General's office to be able to prosecute legally?
Well, if the Attorney General's office wasn't provided statutory authority by the legislature to have sole prosecutorial authority in the area, those sorts of questions are ones that come from a request by a constitutional district attorney or county attorney for assistance, as a general rule.
Okay. So can the district attorney limit the scope of the ability of the office to do that kind of work?
I'm sure they can. They pick and choose what they decide to send over and what they ask for.
During all the years you were at the AG's office, have you ever seen the Office of Attorney General hire outside counsel to handle a criminal item?
I don't recall hiring outside counsel to handle a criminal item.
Are those large divisions within the office?
Some of them are larger than others, but we have prosecutors on staff, we have peace officers on staff.
So they're qualified people within the Attorney General's office to handle those types of things?
Yes.
Okay. I want to talk about the contract, in particular, the CAMIC contract. Have you seen it? Have you been able to look at it?
I have seen it.
All right. I want to talk about the contents of that. The limitations were provided on that contract, were they not? Was there an addendum A?
The addendum A is generally the scope of work that the outside counsel is being requested. That's how it's set up in the form.
Okay. And based on your research, what did that addendum A track? What language was that?
Can you show it to me, please, ma'am?
See, 227, please. It's in evidence.
If I could see addendum A, please, ma'am.
We need addendum A, please.
I have it.
Whoops.
Thank you.
Yeah. Do you recall looking at that language?
I have read this language before, yes, ma'am.
And was that language tracked from the Travis County District Attorney's Office referral letter? Did you take a look at that?
It appears to be very similar.
Okay. And is it a limiting type of language?
I mean, I think by its nature, all scope of services are limiting in their language.
This particular contract, though, does it give...
Your Honor, I have to object. Can we get some foundation here? She was not involved in this other than the phone call she just talked about. And we heard Ryan Vassar, who drafted this. So this is all something she learned later, and she shouldn't be up there testifying about it.
Missy, do you have a lot of experience in these contracts?
I'm talking about this particular contract, Your Honor. She just asked it again. This witness was not involved in the drafting of this contract.
This witness does not have to be involved in the drafting of the contract to give an opinion concerning it or to talk about it. That's not required under the law.
Moreover, and thank you for that. Moreover, Your Honor, now she's asking her to give some sort of legal opinion, which certainly she's not been proffered as an expert. They don't have any experts in this case.
She's a person who teaches. This is an area of her expertise. She's talked about the thousands of contracts that she's looked at and approved.
Just settle this. I'm going to overrule. Continue.
Thank you, Mr. President.
Can you repeat the question?
Take a look at addendum A, and there's a limitation in there concerning the ability to do what? What is it authorizing Brandon Kamick to do?
Let me take a second to reread it, please.
Certainly.
The contract provides that pursuant to a request basically from the Travis County District Attorney's Office that the outside counsel will conduct an investigation under the authority of the Attorney General's Office of the criminal allegations contained in the complaint.
It says to conduct a review, does it not, in the very first paragraph?
It does, a review
of the allegations.
A review of the allegations, and then the third paragraph, conduct an investigation.
Okay. Does that particular contract authorize prosecution of a case?
The last sentence in the contract excludes legal services relating to post-investigation activities, including but not limited to indictment and prosecution.
So it excludes that?
Correct.
All right. I want to talk about this contract that you were consulted about by Ken Paxton himself. Is there a problem with Ken Paxton signing a contract like this to provide services when he's authorized him at least 2 weeks ahead of time to start providing those services?
I have never been made personally aware of when Ken Paxton signed this contract, so I don't think I can answer your question.
So what I'm asking you is, if he had authorized Brandon Kamick 2 weeks earlier,
I'm sorry.
Let me finish my question, please.
There's no reason to yell. Your Honor, I'm sorry, I have to object. That counsel is putting facts that are not in evidence. The witness has already told us she has no personal knowledge. This is completely improper, and I object.
She is an employee who's familiar with the procedures and whether or not things are proper or not. In fact, she's being consulted about it, so I think I'm entitled to ask her.
Overruled.
Thank you.
Can you repeat the question, please?
Is there a problem if the contract was signed by Ken Paxton and he had authorized the services to be performed weeks ahead of time, before that date of signature?
The contract should have, in the first pages, an effective date of the contract. And I don't have in front of me what those effective dates were, but the effective dates need to line up. It's not the time of signature, it's the effective date of the contract. But there's still the problem of the funding. It's unresolved.
What if there's no date at all because it's not been put on there?
then I would be speculating as to whether or not the contract was signed before the date of the effective date of the work.
Okay. Assuming that your advice to General Paxton about his ability to sign it under that little provision, would it be properly done if he did not provide a written waiver?
If he did not provide the written waiver required by the rules, then the procedure should have been followed.
Okay, so you either follow the procedures or you have to sign it and give a written waiver as the Attorney General. Is that correct?
That's the process.
All right, so without that written waiver, where are we?
It's merely a violation of the process. It doesn't make it illegal, it just makes it a violation of the process.
How about funding it? What does it do to that?
Without the proper written indicators to the controller, they're not going to pay the invoices, even if the money's there.
The addendum A talks about a referral from the Travis County District Attorney's Office. If General Paxton had added a second referral and told Brandon Kamek just do the whole job, is there a problem with that, with a contract that's not authorizing the work to be done?
I don't know that I'm comfortable speculating to that.
Then I object, Your Honor. The witness has admitted, thank you, that this would be all speculation.
Sustained.
What are your thoughts on that?
Your Honor.
I'd like to let her finish the thought, as far as she's not rendering an opinion, but I'd like her thoughts on it.
Again, Your Honor, she just said this would be mere speculation, so this is improper.
Sustained.
Are you familiar with the attorney applicants who applied for this particular contract?
I'm familiar with their names.
Okay.
I do not know them.
Was Brandon Kamek the qualified candidate?
I don't think I was ever asked to weigh into that question.
Not asking you that. Having looked at all these contracts, and you've said you have to have a qualified candidate for the job, looking at those two, was Brandon Kamek the qualified applicant for it? Was he the best choice?
It was not my decision to make who the best choice was.
I'm not asking that. I'm asking your opinion as you sit here today.
Asked and answered, I think.
Would it ever be in the best interest of the state to pay for a free investigation to a private citizen when there's no state interest involved?
So you're hypothetically asking me if it's proper to execute an outside counsel at $0 for an investigation where there's no state interest involved at all?
Correct.
I'm not sure it's possible to execute an outside counsel contract where there's no state interest involved, because the ability to contract with an outside counsel derives from the ability of the Attorney General's office to represent a particular client in a particular matter.
We're talking about a cost, right? We're paying somebody other than an in-house attorney from the OAG to do the work requested, correct?
Statute, the government code in 402-0212 that describes outside counsel talks about the full-time employees of an agency don't count against as being outside counsel. Right. It's when you hire a counsel that's not employed by the state.
So my question is, when you're paying someone like Brandon Kamek outside of the state to provide services that benefit only one individual for a job that is not in the best interest of the state, do we have a good contract?
I'm sorry, Your Honor, objection vague. Question's completely vague.
Sustained.
You said that in order for a contract to be approved and signed from the Office of Attorney General for an outside counsel, the whole contract has to be in the best interest of the state, right?
Yes. I mean, that would be ideal. It's not because that comes from the Appropriations Act, but the state should not perform acts with taxpayer dollars that are not in the best interest of the state, in my opinion.
Right. And so if it's a job that's only going to benefit a citizen and has nothing grounded within a state interest, that's not a contract that should be approved, is it?
Objection, leading.
Sustained.
Is that the type of contract that we want?
Objection.
That we should be approving?
I'm sorry, I don't know who we is, but objection, vague.
Sustained.
Let's talk about September 28th. That afternoon, after you spoke with Ken Paxton about this contract, did your phone start blowing up?
I talked to General Paxton. I believe those phone calls were in the evening on the 28th, okay, not in the morning.
And who were you getting the phone calls from?
So when General Paxton called me, because he hadn't looped me into his world in a while, I did call Jeff Mateer before I called him back, and Jeff relayed, said...
Objection, hearsay.
Sustained.
Later on that evening, who did you speak with?
Mr. Mateer.
Did you speak with anyone else other than him?
After I spoke to General Paxton, I don't believe so. It was late.
Okay. Following day, did you receive some phone calls from other people within the office?
I did.
Who did you hear from?
I think there was sort of all involved deputies call with a number of the deputies that's been previously reported on that I was on the telephone for.
Okay. And how long were you on the phone? What
hours?
Kind of time frame? All right. How many of you were on that call?
I mean, I would say 6 to 8 of us at various times, sometimes up to 10, and people were in and out of the call.
What was going on?
There had been some subpoenas issued by Mr. Kamek that some of the staff had known about and reported, and the deputies were getting together with Mr. Mateer to discuss those facts and the circumstances around what was happening at the time with him.
Was Nate Paul at the center of that conversation?
Objection, hearsay.
Topic. I'm not asking her to repeat what was said.
Overruled.
Was Nate Paul the topic?
Yes.
Did you learn about several things that had been going on in the office?
Yes.
Any idea why you were not aware of those things before that date?
I believe that due to COVID and everyone being home and not on the same floor working together and people coming in and out on different days of the office in the middle of the pandemic, we were not all together at that time as a team in the same place at the same time. And so there wasn't complete awareness like there usually would have been of what each deputy was working on with relation to Mr. Paul and General Paxton.
So as a result of that long phone call with the group, did you come to learn, I'm not asking you to repeat, but did you come to learn about those things that had been happening within the office?
I did.
And what was the connecting theme of those things?
Mr. Paul.
All right. As a person who's spent so many years worrying about ethics and how things should be managed within a government office, what were your thoughts about what was going on?
I was surprised at the level of involvement from the Attorney General with one particular person that reached across so many levels of the executive staff, all related to one person.
In the course of your career, have you ever experienced something like that before?
Not related to a particular person as opposed to a particular topic.
Okay. Tell us what your concern was ethically with what had happened.
I learned that the contract was executed, even though the conversations I was having with General Paxton, he never told me that the contract was already executed. We were approaching the conversations as if it was not a fait accompli and had not been done. So I was very surprised by that. and I was surprised by how many different things related back to a use of resources by the agency for one person.
So, what's the big deal with that? Who cares?
Objection, Your Honor. I mean,
What's
I don't know
the
what that
deal?
is. That's not a question. It's not a proper question. I object to it.
Sustained.
What's the problem with all of those resources going to one person?
Besides it being unusual, it was unusual, and there was a lot of speculation about the underlying reasons during that phone call.
Okay. Was there any resolution with that phone call? Was there a decision to do something?
On the 29th,
Yes.
there was not.
How about the 30th, the next day?
There was.
And what did you decide to do? What did the group decide to do?
The group felt like, some of the group felt like they had an obligation to report to law enforcement.
Why would they do that? What was the problem
Objection,
with...
speculation. She's asking about people we've already heard from. Tell us what they were thinking. We've heard from them.
I'll reword it.
Sustained.
I'll reword it. At this point in time, what was the problem with what had been going on? What was the concern in your mind?
A concern in my mind was the immense amount of effort that was being put to the problems of one particular individual when so many of the executive staff disagreed with that. And I'm a consensus builder, and there was not consensus on how to move forward on these things.
Was it the degree of that?
Objection,
amount?
leading.
Sustained.
When you looked at all of the events that you learned about, and you looked at the people that had been involved with it, did you, in your mind, figure out how much of the office had actually been dedicated to doing work for Nate Paul's benefit?
I did.
What kind of number did you come up with? How did you describe it?
I think at the time I mentally came up, it was more than 50% of the deputies' time of our entire executive staff.
You ever seen anything like that in your career?
I had not.
All for the benefit of who?
I don't know that I can answer who it was for the benefit of. What I can answer is the commonality and the thread.
Sorry, ma'am. The witness just told us she can't answer the question. Next question.
And what
Sustained.
What was the commonality of it that you were about to talk about?
Nate Paul was the commonality.
All right. And the other commonality would be who directed it, and who is that?
Attorney General Paxton.
When the Attorney General's office does something that totally violates its long-time policy, for example, something like open records and not disclosing information for pending law enforcement, honoring the law enforcement exception, and not releasing documents that have to do with ongoing criminal investigations, what's the effect? What kind of things happen to the office and to the public?
Your Honor, that is a completely improper question. This person is not even involved in public information at the office. Moreover, the question is 3 or 4 different questions.
Sustained.
It's improper.
Do you have experience in open records?
I do. I was the public information coordinator for the Office of the Attorney General. I was the division chief of the division, and at the time that you're asking about, I was the supervisor of the public information officer for the Office of the Attorney General who had briefed that particular ruling to the Open Records Division.
So when you violate the policy, the long-standing policy to protect that type of information, what does it do?
Your Honor, that assumes, she just said she approved this, and now the lawyer is saying that she violated some policy. That's improper.
That's incorrect. I've not said anything like that. What's the long-term effect? What happens? What's the concern?
When the Open Records Division changes long-standing precedent in their rulings, it can create confusion, and it is a a proactive statement of precedent on other rulings in that area.
And when it's broken, what does that mean? That precedent's gone.
All the governmental agencies have to adapt to that new precedent across the board with every request that's similar.
Did you go with the others to the FBI?
I did not.
Why not?
I had retired, and so I did not. I was invited to the meeting, and I was 3 hours away, and the meeting, I was told that unless you came in person, don't come.
Did you have an occasion later on to go talk with the FBI about your observations?
I was subpoenaed by the grand jury to talk about my observations in 2021.
Okay. And did you do that?
I did.
Did you
I
cooperate?
complied with the lawful subpoena.
And your name is not on the whistleblower letter, is that correct?
I am not a whistleblower.
Why is that? Why did you not sign the letter?
Because I had, when the time all this was happening, I had already submitted my notice to retire, and my retirement was imminent. So, for lack of a better word, I was a quitter. I had quit.
Pass the witness.
Mr. Busby, your witness.
Yes, Your Honor. Thank you. Hello, ma'am.
Mr. Busby?
You look like you're a little nervous.
I'm not nervous.
Feeling good?
You know, I don't think anybody particularly wants to be here, Mr. Busby.
Let me ask you something. You said you appeared in front of the grand jury?
I was subpoenaed to appear at the grand jury.
And that was in 2021?
Yes, sir.
And it's 2023 now?
Yes, sir.
And that you told them everything you told us here?
I answered their
I
question.
object. If she's appeared before a grand jury, she cannot talk with us about what she testified to.
She can tell me that if that's the case.
Sustained.
So suffice it to say, your story hasn't changed since 2021, right?
Can you explain to me what story I'm talking about?
I'm wondering why the so-called whistleblowers who reported this to the Travis County DA's office and to the FBI and maybe others, and you who spoke to apparently the FBI or the grand jury at some point, why nothing's happened, even though every single thing that we've heard in this impeachment has already been fully vetted. Can you tell me, has there been an indictment of our Attorney General?
So your question is...
Has there been an indictment of our Attorney General?
Not that I'm aware of.
Okay. You think that Laura Olson drives a red car? Is that what you told us?
I did not say that. I said the person at the Galaxy Cafe that I saw drove a red car. I've never said it was Laura Olson for sure.
Why are you even telling us about somebody that drives a red car at the Galaxy Cafe when Laura Olson never owned a red car?
That assumes facts that are not in evidence.
Sustained.
Do you know whether Laura Olson has ever owned a red car?
I do not.
Do you know what kind of car Laura Olson would have been driving back in that time frame?
I do not.
Okay, so you just got up here in front of all these people watching at home, our distinguished jury, and was telling us about some unknown person driving a red car at Galaxy Cafe, and you don't even know who that was, do you?
That would be correct. That's what
Why
I said.
the devil are we even hearing about the Galaxy Cafe? You didn't know who that person was.
I never said that I did.
How long did you work with these people over here to prepare yourself for your testimony?
I didn't work with them. I was asked to go in front of the House managers and interviewed, as well as talk to you and your staff.
Are you sure there was some sort of Attorney General's conference in San Antonio in that time frame?
The best of my recollection.
There wasn't. I guess I'm trying to figure out, well, how good is your memory?
Is that a question?
Yeah. Not very good, is it?
No, sir, it's not.
That's what I thought. Ken Paxton was your boss before you retired, right?
Yes, sir.
You told us about all this teaching you've done in CLEs, continuing legal educations, right?
Yes, sir.
You've taught students, you've taught other lawyers, right?
Yes, sir.
And you sat up here and you were trying to explain to us contracts and how the process works, right?
Yes, sir.
And your boss called you because he wanted to legally do the right thing, and you provided him advice, didn't you?
Objection. Calls for speculation on the part of this witness.
Sustained.
He wanted to know how to properly sign an outside counsel contract, didn't he?
Objection. Calls for speculation.
It's exactly what he told her.
Objection.
Overruled.
He wanted line and verse. What do you call you, Missy? Is that what he called you?
Yes, sir.
Missy, look, I'm having a disagreement with this Penley fella. He's refusing to do his job. He's insubordinate. I need to know, under the statutes, if I have the authority, the legal authority, to sign a contract. And you gave him advice, didn't you?
Yes, sir.
And you said, Ken, you do. Isn't that right?
Correct.
Why are we here? The guy did everything he was supposed to. He had some insubordinate people in his outfit.
I object.
So
Counsel's testifying, not asking questions.
That is a question. I'm not finished.
Sustained.
You knew that Penley refused to follow the procedure and sign off on the contract, right? You knew Penley said, I ain't going to sign it, right?
I knew Penley said he did not want to sign it. Correct.
The only person in the office who has authority to sign the contract himself, unless designated, is Ken Paxton. Isn't that right?
That is correct.
Let's make sure we're all clear on that. This bureaucratic process that this person signs and this person signs and this person signs, all of their power and authority to sign a contract comes from the elected Attorney General, Ken Paxton. Isn't that true?
Subject to the Appropriations Act, the statutes, and the rules that we adopted. Correct.
Right.
Yes, sir.
So, we saw Mr. Penley's notes. If he said in his notes, Missy told Ken he had the authority to sign the contract.
That violates the rule. Sorry.
You can keep objecting. This is a document that's in evidence, Your Honor. We all looked at it.
Overruled.
When we looked at Mr. Penley's notes,
I object.
You can object again, but it's in the evidence, Your Honor. You saw it. We all saw it.
I object to him testifying about a document that this witness has not established that she's ever even seen. That's improper.
That's not right, Your Honor. When I ask her if Penley's notes are correct, that is, Missy told Ken he had the authority to sign a contract. That's an incredibly appropriate question.
Sustained.
Now, you did tell Penley that you had told Ken he had the authority, right?
I told everyone on the phone call, then Penley was one of the members of the phone call. Correct.
Let's make sure we all get that right. And your job at that point in time when you told Mr. Paxton that was?
His chief of staff.
The chief of staff of the Attorney General's office of the state of Texas advised her boss, the Attorney General, that it was okay to sign an outside counsel contract, correct?
I told General Paxton that it was legal for him to sign the outside counsel contract, correct.
And then later, when everybody was scrambling around, you told his entire executive staff that you had told him that, right?
I was completely honest with him, yes, sir.
And they still went to the FBI, didn't they?
They, in fact, went to the FBI.
That's right. Are you somebody that goes to church?
I'm not sure that's an appropriate question, is it? My personal beliefs?
Well, it is when you're telling us about the ethical, legal, and moral implications of an affair. Remember telling us all that? Remember saying that? Maybe, I think you said political, ethical, legal implications of an affair. Remember saying that?
I remember giving the Attorney General my thoughts on those topics.
Okay. so I'm going to get your thoughts on the topic. You ever met somebody that's perfect?
Never, sir.
Okay. Was there only one person that was perfect?
In my belief system, there's only one entity that's perfect.
All have sinned and fallen short of the grace of God, right?
I would agree with that, sir.
Yeah. Sometimes people make stupid mistakes, correct?
Yes, sir.
Sometimes, imagine if we impeached everybody here in Austin that had an affair. We'd be impeaching for the next 100 years, wouldn't we?
I don't think I should answer that question in this chamber, particularly. Yeah. I've been around a long time, Mr. Busby. I'm not going to go there with you.
I'm quite sure you've seen a lot, have you not?
Indeed.
Yeah, just because somebody has an affair doesn't mean that they're a, quote, criminal, does it?
I would not associate that directly.
Yeah. That would be incredibly hypocritical, would it not? If somebody said, this guy is a criminal because he had a marital indiscretion. That would be really hypocritical, would it not?
I would not say that.
Yeah. You would never say something like that, would you?
I would not.
You even sent when you were texting back and forth with Ken Paxton, your boss, you sent him the legal authority that gives him the authority to sign contracts, right?
Correct.
Okay. And you also referred him to the Attorney General's website, didn't you?
With the procedure, yes, sir.
Yeah. So you not only told him over the phone, but you also sent him the exact statute and the website, the AG's website, right?
I did.
Okay. Did you ever figure out how the grand jury subpoenas were actually obtained by Mr. Kamek?
I did not.
Okay. Of course, he didn't have to appear in front of any grand jury, right?
If you tell me that, then, I'll take your word for it. I didn't dive into that. Again, I had told General Paxton that the contract was legal to sign. Okay. But couldn't be funded. He had a funding issue.
Well, okay, we'll talk about the funding issue. The funding issue is something of course, Kamek didn't get any money.
I do not know that.
Okay.
Are you telling me Kamek didn't get any money?
Young man did a lot of work, didn't get paid.
I object to defense counsel testifying.
I'm asking if you knew that.
I object.
Sustained.
Did you know that he never got paid?
I did not know that until you just told me.
Okay. Let me ask you, would it be an appropriate process for the Attorney General, before you even try to go through the executive approval memorandum process, that's a bureaucratic process, is it not?
Correct.
Okay. It's a bunch of procedural rules that have no force in law, right?
It's a documentation that is not the legal document.
Right. Gotcha, you didn't follow the procedure in the office. The AG can decide what the procedure in the office is, can he not?
He could waive the procedure in writing, yes, sir.
He can waive it in verbal. He can do what he wants as long as he believes he's serving the people of Texas. Isn't that right?
Well, he agreed to the rules that said it would be in writing.
And he can change the rules.
If he goes through the Texas Administrative Code process in this instance, he could change the rules, yes.
Let me just ask this, though, so we're all clear. Can the AG of our state send an email to the controller? Is there a controller in the office? Somebody in charge of the money?
There's a controller in the office, and then there's a Texas controller.
Yeah, I'm talking about the internal one. Who was the internal controller in the AG's office?
Michelle Price.
Can the AG send an email to the controller within the office and say, set aside $50K or $25K for a contract I'm going to sign?
He can.
Okay. Is that something that he has the authority to do?
Yes.
Okay. Does anybody else have that authority?
The Appropriations Act in Article 9, Section 16 says the communication needs to go to the controller. So that communication would need to be forwarded to the controller to prove that the Attorney General felt it was in the best interest of the state.
The Attorney General. No one else.
The Appropriations Act uses the words Attorney General, and as you correctly stated, those kind of things he can delegate, but if he didn't delegate, it says Attorney General. Yes, sir.
If he did not delegate, it would be illegal. True?
I don't understand the question.
Let's say that one day Mr. Penley decides that he wants to set aside $50K to sign an outside counsel contract. That would be illegal, wouldn't it?
I don't think it would be illegal. I don't think anyone would do it for him. The controller would be following the procedures.
You think so?
I do.
Okay.
I have
Let's
faith
look
in the
at
staff.
let's look at an evidence we've already seen. Exhibit 361. Can we put it on the screen for the witness? Eric, can you help me out here, Eric? Everybody likes Eric, Your Honor.
And Stacy.
And Stacy. And Stacy. If you don't mind, Eric, go to page 4 of AG Exhibit 361. Do you see that there in front of you? Jeff Mateer is authorizing $50,000 to be set aside for a guy named Johnny Sutton. Do you see that?
I do see this.
Did you know that was going on?
No, sir.
Did they tell you they were doing that?
No, sir.
Do you think that the first assistant has the authority to hire outside counsel with an email?
I do.
You do. But Ken Paxton doesn't?
I believe that Ken Paxton could have sent a very similar email if he did about the funding, and he would have achieved the same result. If he did, you may show me that documentation if you'd like. I'm not aware of it.
I thought we had this real strict bureaucratic procedure to hire outside counsel. Remember you telling us about all that?
We do.
Okay.
And in that procedure, the first assistant has been delegated that authority.
No. Ken Paxton did not delegate any authority to hire Johnny Sutton. No, you know that's true.
I object. That's a misstatement of what she said.
Do you know whether Ken Paxton...
Object.
I'm going to rephrase the question.
Sustain, rephrase.
Do you know whether Ken Paxton, the boss, authorized Jeff Mateer, the subordinate, to set aside $50,000 for Johnny Sutton?
I have no personal knowledge of Johnny Sutton.
Okay. Pass witness.
Redirect.
Yes.
Are both sides, we can excuse the witness?
We are finished
Yes.
with this witness.
Yes.
You may step down, thank you.
Am I excused?
Yes. You are excused.
Thank you, sir.
She asked, is she subject to recall? Subject to recall?
No, Your Honor. I think we're done with this one. Nice to meet you.
Thank you. Who's your next witness?
Your Honor, the House calls Greg Cox.
Bailiff will bring in Greg Cox.
And Mr. President, if I may, in an attempt to hopefully expedite the process, I have one piece of evidence that I intend to show while Mr. Cox is on the stand. It is exhibit number 249, whose affidavit attached is number 640. It's a video before the Senate Finance Committee from February 10th, 2021. It is a government record, and it is authenticated by the proper affidavit associated with it. We'd offer the same in evidence.
You're going to submit that, right?
I'm offering it as evidence, Your Honor, because I intend to play it with the witness.
Do you have
to
any
expedite, I was
objections?
hoping to get any objections taken care of beforehand.
Do you have any objections?
No, Your Honor.
Okay.
Cox, please.
Mr. Cox, raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help me God. Please take your seat. Court will admit into evidence Exhibit 249 and Exhibit 640.
Thank you, Mr. President. May I proceed? Good afternoon, sir.
Good afternoon.
I'm going to need you to speak a little bit closer to the mic. I'm never really told that nobody can hear me, but I know that acoustics are not great, so please step forward or slide forward to make sure we can hear you.
Very good.
Would you please introduce yourself to the honorable senators?
My name is Greg Cox.
And tell us, sir, how you're currently employed.
I am currently the first assistant with the Hays County District Attorney's Office in San Marcos.
Could you give us, please, a quick briefing of your history, professional and perhaps even law school, that led you up to this point?
Yes, I attended law school at the University of Texas, and actually during my first year of law school, I worked here at the Texas Senate. Took a year off from law school, worked for an accounting firm, and then when I went back during my second year, I got a job as a law clerk at the Travis County District Attorney's Office in the Public Integrity Unit. Upon graduation and passing the bar, I was offered a position as an assistant district attorney, and I ended up staying with the Travis County District Attorney's Office for 30 full years.
After leaving the district attorney's office in those 30 years of service, did you go to another government or quasi-government job?
I did. I initially went and was general counsel in 2021 at the Texas Civil Commitment Office, a small state agency that oversees people that have been civilly committed as sexually violent predators. I left there and went to the Texas District and County Attorneys Association, where I was assistant director of training. And then in January of this year, I became first assistant in the Hays County office.
I appreciate that, sir. Thank you. During your time at the Travis County District Attorney's Office, you indicated you were Director of Special Prosecutions Division. Did that include investigations into public corruption?
Yes, it did. I served as Director of Special Prosecutions, which included the state-funded Public Integrity Unit while it existed for 15 years, the end of 2021 to the end of 2016.
I figure you might get some questions about that, but I'll let my colleagues take care of that. Let's move on then to your time at the District Attorney's Office towards the end. Who was the District Attorney, not the last elected District Attorney that you served under, but second to last? If I'm asking that right.
So
let me ask it a better way. Do you know Margaret Moore?
Yes.
Okay.
So 2017 through 2020, Margaret Moore was district attorney. During her administration, I was serving as director of operations.
Very good. Did she ask you at some point to speak with her, or let me ask you this. Did you flag a concern for her related to a possible open records request?
In October of 2020, one of my responsibilities was overseeing public information. I became aware of an open records request that the office had received related to Ken Paxton and Nate Paul. I didn't know what was going on. I asked a question about that. She briefed me on some things that had been going on that I had been unaware of, and then asked me to start joining into some meetings with some individuals related to that.
Is it fair to say that up until that point you had not heard the name Nate Paul in relation to the Travis County District Attorney's Office?
That's correct.
Very good. Then who did you speak with at Ms. Moore's request?
Initially, I spoke with a couple of lawyers that represented the Mitty Foundation.
And let me back up. I poorly phrased that question, as I often do. Back that up to say, Ms. Moore, you indicated wanted to speak with you.
Yes.
About this request. Did you speak with Ms. Moore, and was there anybody else present?
I spoke with Ms. Moore and Don Clemmer. I may have spoken with Mindy Montford, although I can't recall that for certain.
And based on what you learned during that conversation, was there a next step that you took?
I drafted up a real brief overview of potential criminal offenses that could be relevant to the situation that they briefed me on. And then we set up a series of meetings to gather more information.
Do you recall approximately when it was that you drafted this initial, I'm going to call it a skeleton outline?
If I am recalling the dates correctly, the initial conversation was on October 21st of 2020. I drafted the first memo on October 23rd, which was Friday of that week. And then Monday, Tuesday, and Wednesday of the following week, we had a series of meetings. And then I believe it was on October 28th that I drafted a more thorough memo about the situation.
Your Honor, if I may approach the witness after I ask the following question, I'm going to show you what I don't intend to introduce into evidence, but would ask if you would rely on your memo to refresh your memory.
Sure.
Objection, Your Honor. He hasn't said that he doesn't remember anything yet. He can't sit up there and testify from a document that's clearly hearsay.
Your Honor, I'll rephrase. I apologize. Thank you. And Mr. President, I keep saying Your Honor, force of habit.
Whatever's comfortable for you.
Thank you, sir. Do you have a full recollection of each and every item that you outlined in your October 28, 2020 memo?
I have a reasonably good recollection of it.
Do you feel that looking at that would assist and aid you in your testimony in order to provide comment to the ladies and gentlemen of the jury and not waste a lot of time?
I do.
May I approach the witness, Your Honor?
Your Honor, may I again, and again, I'm all about saving some time, but this is not proper to give him a document that he hasn't said, he didn't ask a specific question about, do you remember this, remember that? You don't just refresh your recollection with an entire document. It's not how it works.
Your Honor, respectfully, I've yet to hear a single objection on this issue from Mr. Busby other than his complaints about it. I will proffer to the court, if I may, sir.
It's hearsay. You're not allowed.
If I may, sir, I thank you. I've allowed you to continue your objections, and I ask you to give me the same decency. Your Honor, this witness is testifying that he created a report. He has testified here today that he doesn't have full memory of everything contained in that report. And Mr. President, he has said that it would assist him in providing testimony to the jury.
Overrule the objection.
Thank you. May I approach Mr. President?
Yes, you may.
I hope I'm not the only one that's ever happened to, because my wife will take care of me later on. Sir, tell me, after your initial meeting with Margaret Moore and Mr. Clemmer, what steps did you take, if any?
So the initial conversation, I was provided a briefing of some facts that they knew at that point. I then went and looked at some basic open source information to gather some additional facts, and I drafted an earlier version of this memo that did not include any fact summary. It only included an outline of potential criminal offenses that might be avenues of investigation. I provided that to Ms. Moore on Friday the 23rd, and then we had the series of meetings that I referenced a moment ago, and I drafted this memo after that series of meetings.
Do you recall the individuals who you spoke with? And I'm not asking you what they said, just the identity of those individuals.
Yes, as I started mentioning a little bit ago, two attorneys from the MIT Foundation, however you say that. Then we had a meeting that Monday afternoon, a video meeting over Zoom with Mr. Mateer. The following day, we had a telephone conference call with Mr. Maxwell. And then the next day, Wednesday of that week, we had a rather lengthy conference call with Mr. Penley.
And then did you summarize those facts as you knew them within this report that I provided to you, which you had drafted around October 28th?
Yes, I took detailed notes, and then I wrote this fact summary and the rest of the memo after that.
Very good. And again, I'm not going to go into you about the specifics in your report. You're here to testify about your memory. So let me ask you, as a result of your conversations, let me back that up. Would you call what you did an investigation?
I would call it a preliminary investigation.
Would it be fair to describe it as a limited investigation?
Yes.
So in this preliminary limited investigation, you spoke with multiple individuals, and were you able to identify in your mind possible criminal offenses?
Yes, I was.
And who would have been the subject of the possible criminal offenses?
Primarily Ken Paxton, but there were other individuals that were also identified as potential suspects.
Very good. I'd like to ask you which offenses you identified, and I'm going to ask you one by one to just go slowly. Could you tell me, please, what you believe the first potential offense you identified was?
Potentially bribery.
Bribery. What else did you identify?
Accepting a gift to a public servant.
Very good. Next.
Abuse of official capacity under 3902 of the Penal Code, which has two different ways of committing the offense. One is misusing something of value belonging to government for an improper purpose. Second part is violating a law relating to your office or employment, and I believed that there were potential offenses under both of those sections.
Ms. Manella, could I please ask you to bring up on the screen the three potential criminal offenses that have been identified?
Objection, Your Honor. We all know that Ken Paxton has not been charged with anything. This is completely improper. Possible criminal violations. This is completely improper.
Your Honor, this information goes directly to rebut inferences provided by the defense team concerning any possible investigation that may have occurred. Additionally, it goes specifically to articles of impeachment regarding potential abuse of power, potential bribery. Many of the other ones we're about to elicit from this witness, Your Honor.
May I be heard one further time, Your Honor? Imagine that it would be proper in a court for somebody to come here and say, he's possibly did this, possibly did that, possibly did this. Incredibly improper. That's pure speculation. He hasn't been charged with anything, and even if he were charged, he'd still be innocent. So this is completely improper, and I object to it because it's speculation.
Mr. Busby, I apologize for interrupting. If I may, Your Honor, just briefly, this witness is here to testify to his perceptions, his opinions. They are opinions that can be challenged. He is a lay witness under Rule 701, and he is using his information and rationally based on his perception is providing opinions which would be helpful to the jury to understand a fact and issue. He is available to be cross-examined by Mr. Busby, who I'm sure will take him on cross-examination and test his credibility.
He hasn't responded to the objection, which is this is all speculation. I mean, he could say that about everybody here. Possible this, possible that. That's why, as the gatekeeper, the court can't allow it.
And Your Honor, again, I've responded directly to it as a Rule 701 lay testimony.
Just hold it.
I apologize.
I got it. Overruled the objection. Go ahead.
Thank you. Ms. Manella, if you would, please. Sir, as I bring up on the screen, I just want to make sure these are three that you have identified here in court. Is this an accurate and correct summary of the testimony you've provided up to this point?
It is.
Please, sir, the next potential offense that you've identified.
We were also concerned about some election code violations if certain factors came into play about how money may have been transmitted or handed over. And along those same lines, money laundering under 3402 of the Penal Code.
Money laundering is listed now on here. Is that accurate and an accurate summary of what you've stated?
That is.
Very good. What is the next offense that you identified?
Tampering with a governmental record and possible perjury related to personal financial statements filed under Chapter 572 of the Government Code.
And Mr. Cox, I'll ask you as you turn to the side, just make sure to keep your voice up so we can all hear you.
Yes.
Please, sir, what's the next one you identified as a potential offense?
Coercion of a public servant under 3602 of the Penal Code.
And again, what's shown up on the screen, does that accurately reflect the testimony you provided?
It is.
Next offense?
Official oppression under 3903 of the Penal Code and retaliation under 3606 of the Penal Code.
Again, those two that have just popped up on the screen, do those accurately reflect your testimony?
Yes.
Next offense that you potentially identified?
We discussed whether there could be under Penal Code 1502 of the Penal Code or under Penal Code Section 7102, either a criminal conspiracy to commit any of these offenses, including the ones that haven't been put on the screen that I mentioned, or engaging in organized criminal activity with connection to these offenses.
Was there also an identification of a potential Government Code section violation?
Yes. Chapter 572 of the Government Code not only has the financial disclosure rules, it also has standards of conduct for state employees in subchapter C, and there was what appeared to be a fairly clear violation of one of the provisions of that section.
Sir, the information that's displayed on the screen now, is this an accurate summary of your testimony here today, specifically as to the potential offenses that you personally identified?
Yes, it is.
Your Honor, I've marked for identification purposes exhibit number 660, which is the entirety of what is shown on the screen, and I would offer the same into evidence as summation.
It is admitted into evidence.
Thank you, Your Honor.
Did you object?
I was going to, Your Honor.
I'm sorry. Excuse me.
Why don't we?
I thought you had already allowed it earlier and had not been admitted. So state your objection.
Why don't we write on there that accurately reflect the testimony of potential or possible instead of just putting the statutes on there? The witness clearly said that he speculated this might have been some offenses. And so it would be really improper to put that into evidence without clearly identifying that these are all potentials or possibles that have never been indicted on, ever.
May I respond, Your Honor? Or Mr. President? May I respond? I know Mr. President has indicated his desire not to have to look at too many numbers, so I'm probably going to make it worse by suggesting the following, but the Texas Supreme Court under Uniroyal Goodrich Tire versus Martinez and Inspire versus Webster College have adopted the charts that summarize or perhaps emphasize testimony are admissible if the underlying information has been admitted into evidence. This is simply a summary. Mr. Busby may question the witness at his leisure concerning the qualifications and any particular changes that he believes are appropriate for this jury to understand.
Your Honor, it has to be a fair summary. No one's challenging that you can do a summary, but it has to be a fair summary, and that's not fair.
I'm going to sustain the objection. You were allowed to bring it in. He said these were possible. So I'm going to sustain the objection.
And so can we have it, if it's going to come into evidence, write possible on it or potential? That's
yes.
Yes, thank you.
Do you agree?
I'd be happy to identify it as the testimony which has been provided as possible evidence, and I'll even identify that it's by Mr. Greg Cox.
And then are you
if he writes that on there, because that's going to be on the front page of the newspaper, and let's make it clear that this guy didn't have any evidence of that.
Your Honor, may I do that at a break so as not to take any further time, but before formally submitted in evidence?
Yes, on each one, each item.
Yes, Your Honor.
All right.
Mr. President, excuse me. Either. Thank you. Sir, after you've identified these possible potential offenses, and again, this is your opinion, and as you've described to us, you have worked in the criminal field for some 30 years. Is that accurate?
Correct.
What, if anything, did you do?
After discussing this with Margaret Moore, the decision was made to reach out to the U.S. Attorney's Office, make sure that moving forward with an investigation would not interfere with any ongoing federal investigation, and I was tasked with making those calls and setting up meetings about that.
The Chapter 572 of the Government Code offense that you flagged, was that one that you discussed with Margaret Moore?
I believe so, yes.
Do you recall the complete language of Section 572 of the Government Code?
Not off the top of my head.
Could you recite it off the top of your head?
I could not.
If you had a copy of the statute, would it assist you in providing your testimony here today?
Yes, it would.
Your Honor, for identification purposes only and not for admission, I'd offer 661 of the House Board of Managers exhibit to the witness and to counsel so they may review as the witness testifies.
Are you bringing it forward?
Yes, Your Honor, but again, not offered in evidence, but merely for purposes of reliance during his testimony.
Okay.
May I have a copy?
Yes.
Sir, could you identify for us, and you don't have to read directly from it, but are you familiar after having looked at this document with 572.002?
Yes, I am.
And does it provide, tell us what your thought process was, and if you need to refer to the document, please do, but what your thought process was as to why this would be a potential violation.
Well, actually, 572.002 sets out who the various officers are that are subject to this. 572.051 sets out the standards of conduct. And what I referenced earlier in my testimony about the violating a law related to his office or employment under 3902 of the Penal Code, this would constitute a law relating to someone's office or employment. And the subsection A says that a state officer should not accept or solicit any gift, favor, or service that might reasonably tend to influence the officer or employee in the discharge of his official duties, or that the officer or employee knows or should know is being offered with the intent to influence the officer or employee's official conduct.
So after flagging these potential violations for your elected district attorney Moore, what actions did you take?
I reached out to the U.S. Attorney's Office, spoke with the then manager of the Austin branch of the U.S. Attorney's Office, Ashley Hoff, and we ended up setting up a meeting.
Was the idea to reach out to the local United States Attorney's Office yours or Ms. Moore's?
I believe it was mine, although I can't say that Ms. Moore didn't also suggest it.
Was there any concern, well, let me ask it a different way. Was there any concern about an ongoing investigation?
So much of what we were talking about related to Nate Paul, and we knew that Nate Paul was the subject of a federal investigation. We were concerned that if we jumped into this and opened an investigation, we were going to interfere with an ongoing federal investigation. So we just wanted to basically deconflict with the feds before we took any action.
Is that common, that deconfliction? Is that common?
That is common.
Don't want to run into each other on the investigation?
Correct.
Want to make sure the witnesses know that there are potentially two tracks going?
Exactly.
Fair enough. Do you recall who all you, well, let me ask you this. You set up a meeting, correct?
Set up a couple of different meetings. Initially, we had a conference call, Margaret Moore, Don Clemmer, and myself from the district attorney's office, Greg Sofer, Ashley Hoff, and Christina Playton from the U.S. Attorney's Office. And we talked through a lot of the facts, and then we agreed to have an in-person meeting the following week. In between those two meetings, I was advised that because Mr. Clemmer and Ms. Moore...
Objection, hearsay. Sustained.
Can you tell us whether or not there were multiple people from your office who were supposed to be meeting with the U.S. Attorney's Office?
When we set up the in-person meeting, I was the only person attended so that no potential witnesses were involved.
And did those potential witnesses include individuals from your office?
Correct.
Fair enough. Without getting into the content of what was discussed at that meeting, did you believe you had a path forward to continue your investigation?
That's what we were trying to determine, was whether there was a path forward that did not interfere with a significant federal investigation that was going on.
Did you believe that you, after that meeting, had a path forward?
After that meeting, I was still unclear. The in-person meeting we had included people from Washington, D.C. that came down for the meeting. And then shortly after that meeting, I had a telephone call with someone from the U.S. Attorney's Office. And at that point, we stood down.
You stood down. Was that your desire to stand down?
I was frustrated by that.
Is it fair to say that you had additional investigation that you wanted to achieve?
Yes.
And I should phrase that differently. Was it something that you wanted to achieve or you felt the evidence would lead you to follow?
It was something I felt was worthy of investigation. It involved important issues involving the state of Texas, and I was concerned that, as I had seen happen too often, the federal government would sit on it for a long time and then we might not see anything happen.
Does that appear to have been the case thus far?
It does.
Finally, sir, as you were going through section 572.051, I'd ask you to take a look at subsection D of that statute.
Yes.
As it relates to the testimony that you previously provided, that an officer, an employee, a state officer, employee should not solicit gifts, favors, services, or bribes, does it indicate who is responsible for drafting the policies that would go throughout the entire state?
Subsection C of that statute says that each state agency shall adopt a policy, and it places the burden of drafting a model policy of these standards of conduct and making sure that ethical policies are in place on the Attorney General.
I'll pass the witness, Your Honor.
Mr. Busby, we were going to break in 5 minutes. We can go 10 or 15 if you want to start, and then we'll break, or do you want to break now? Okay. Members, we'll break now. This is your late afternoon break. We'll come back at 5:15, and then we'll go to about 7.
Well, we thank you for sticking with us for this KVUE Plus special coverage of the impeachment trial against suspended Texas Attorney General Ken Paxton. Sorry we had to take a moment to pause. I had to go do the 5 p.m. newscast, but back now. And what happened while I was away, as you all saw, the prosecution rested its questioning of Greg Cox and turning him over to the defense when the court resumes. Greg Cox is a former member of the Travis County District Attorney's Public Integrity Unit. And so what the Public Integrity Unit was charged with doing is looking into wrongdoing involving elected officials. That's one of their tasks. And he told the jurors that there was a laundry list of potential violations that they were looking into related to Attorney General Paxton, that they ranged from bribery, coercion, tampering with government documents, and that all of those things were related to some of the things that we've already heard from witnesses about, and certainly what is alleged in the articles of impeachment regarding the Midday Foundation and the intervention in that lawsuit by the Attorney General's office on Nate Paul's behalf regarding those documents and turning over sealed law enforcement and investigation documents to Nate Paul regarding the search into his properties, as well as that form, the opinion that was issued, though an unofficial opinion that was issued by the Attorney General's office that would have paused or stopped foreclosure sales during the COVID pandemic. And one of the things that Cox said, because Busby pushed back on this while the prosecution was questioning him, he pushed back and started saying, well, your violations, these lists of violations that were on the screen for the jurors to see, nothing came of these. These were, irrelevant. Why are we saying this? And as the prosecution continued to question Cox, we later learned that they knew that so many of those potential violations were tied to Nate Paul. And the DA's office here in Travis County knew that the federal government was investigating Nate Paul, that he was subject to a federal investigation. And what they didn't want to happen was to have those lines crossed and them to both be investigating the same things and to interfere certainly with that federal investigation. So you heard Cox talking about setting up a meeting with the U.S. Attorney's Office to talk with them about their investigation, and that's why there was a pause put on there. Let's rewind for a little bit, though, to talk about the other witnesses that we heard from today. Certainly, this case starting to take a much faster pace compared to the first week. The first week of the trial, you had the prosecution calling 1 to 2 witnesses each day. And when I say 1 to 2, we had one witness the first day. We resumed that same witness the second day and then moved on to the actual second witness. And it went at such a slow pace compared to today, where we've seen the prosecution call 3 witnesses in one day. And obviously we know time is running out and time is of the essence. Each side only has 24 hours to present their case and cross-examine the other side's witnesses. And when we started the day today, Lieutenant Governor Dan Patrick kind of gave us a check-in of where we were, saying that each side had about 14 and a half hours left, and that he anticipates this case will go to the jury, or rather those articles will go to the senators to deliberate and make a decision on by the end of this week. It could happen as soon as Thursday. And once that happens, he's indicated that the court is going to work until they reach a verdict, which means that we could be here through the weekend. He indicated there will be no days off until they reach their verdict on all 16 of those articles of impeachment that they are considering. And so taking it back to what I wanted to look at earlier, which was the other witnesses that we heard from earlier today. So we started the morning listening to Mark Penley. The prosecution called him. He's a former Deputy Attorney General of Criminal Justice for and he himself is a whistleblower who was in fact fired by the department. And he talked about what he describes as an insane request by Nate Paul and backed by Ken Paxton to have the Attorney General's Office of the state of Texas investigate federal officials, and not just any officials, but 2 magistrate judges, federal attorneys, the FBI agents that Paul wanted them investigated because he believed that those agents raided his properties initially looking for guns and drugs, and that after 2 hours of searching, they on the spot changed the warrant to look for white collar crime. This is what Nate Paul believes was done against him. We know that those searches resulted in Nate Paul being indicted. He is currently indicted by federal authorities, and they wanted the AG's office to look into this. And Penley talked about how he told not only Paul, but Paul's attorney that there was a proper venue for such an investigation, and that it was not, in fact, the Attorney General's office, but rather it would be the Office of the Inspector General or even the federal court system, which would have to comply with any type of investigatory efforts that they were to put forward. But rather than going through those venues, Paul wanted the Attorney General's Office of Texas, and he says certainly Attorney General Ken Paxton wanted the AG's office to look into this. And again, he described that as just an insane request. We then heard from Missy Carey, who worked as Paxton's chief of staff. She is the first woman to ever serve as a chief of staff for the Attorney General's office in the state of Texas. She was promoted to that position by Paxton, and she talked about what she learned, which we eventually all learned to be the affair that Paxton was carrying out with a woman named Laura Olson, and how that played out, and how Paxton told her that it was going to end, but instead carried on with it. And this is relevant because Carey is who oversaw Paxton's security detail, and members of the security detail were complaining to her about having to work odd hours, having to go to odd places, and that she's saying Paxton wanted her to be more accommodating with them to help with that. And then our third witness of the day, Greg Cox, who you see walking back to the stand right now. Again, he worked for the Public Integrity Unit in the Travis County DA's office. He now works for Hays County and is a first assistant DA. He's resuming now. We are resuming with the cross. And so, well, we're hearing actually that we're still waiting for one of the senators to return to their desk. So we have a little more time to recap for you what he was saying. But what he said to the prosecution was that they suspected Attorney General Ken Paxton of several violations. You're seeing some of the senators there walking back to their desk, including State Senator Angela Paxton, Ken Paxton's wife. Certainly an uncomfortable, to say the least, day for her to hear Missy Carey describing the moment that they all learned of Paxton's affair, a meeting where Senator Paxton was present along with the staff, and she described her crying, describing the feelings of embarrassment she must have been facing. But we're now picking up with that cross-examination of Greg Cox, so let's listen in.
You know, they say that you can indict a ham sandwich. You ever hear people say that?
I've heard that saying.
In fact, you recall that the former governor of our state was indicted just for exercising his veto. Remember that?
He was not actually indicted.
He was indicted. Governor Rick Perry was indicted for exercising his veto. Did you not know that?
I thought they did an investigation that resulted in a no bill.
No, you're misinformed. He was indicted by a Travis County grand jury. Did you not know that?
I did not know that.
And he said over and over and over, my gosh, all I did was exercise a veto. You can indict a ham sandwich.
Respectfully, I object to this line of questioning as being wholly irrelevant.
Overruled.
So here we have a Travis County, in Governor Perry's case, a Travis County grand jury indicted him for exercising his veto, and you just went through this litany of possible maybes with regard to Ken Paxton, didn't you?
That's correct.
He might have done this, he might have done that, right?
Correct.
I guess what you were saying is that, hey, I'm analyzing the law. If any of this foolishness is true, this might be the criminal violations, right?
That would be accurate.
And you know for a fact that you're not supposed to come into a court like this and testify about what somebody might or may have done. Isn't that right?
I was answering the questions that were asked.
You would have never, have you ever been in court before as a prosecutor?
I have.
So you know for a fact that that is not proper, don't you?
This is not a criminal trial.
Right. It's not proper to go into a court and testify on live stream and to jurors about something that someone might have done. That's incredibly misleading, incredibly prejudicial, and wrong, isn't it?
Objection, Your Honor, to asked and answers mischaracterizes the evidence as presented by the witness.
Overruled.
I was asked to identify the possible avenues of investigation that I outlined in the memo to the district attorney.
Possible, maybe, potentially. We don't know, right? You don't know at all, do you?
I don't understand that question.
You were just sitting up there and making a bunch of silly guesses, weren't you?
I would not agree with that.
And you just testified in this historic impeachment proceeding in response to the House's questions about all of the potentials or the maybes or the possibilities, right?
I was talking about the memo that I wrote for the district attorney outlining the avenues of investigation had the feds not waved us off and we had moved forward.
The feds waved you off, you say?
Yes.
Y'all were excited about this. We got a chance to get Ken Paxton, isn't that true?
That's not accurate.
Let's look at Eric, AG Exhibit 170, Brickman 202. You tell me if this is right. It's in evidence. Bring that right there on 10/27/2020, Eric. Right there, Eric. Let me just read this so we'll understand what y'all really were up to. My phone conference with Margaret Moore and her team went well today. They are excited about pursuing this investigation and will coordinate their efforts with the U.S. Attorney Office so that both pursuits complement each other. They obviously want to move quickly as they have time constraints. They are not going to wait on the feds. Did I read that right?
You read it correctly, yes.
Mm-hmm. So the DA's office of Travis County, Margaret Moore, she Democrat, Republican?
She's a Democrat.
Okay, so the elected Democrat district attorney of Travis County was excited. She had a chance to go after Ken Paxton for just an entire litany of things, according to your little memo, right?
I disagree with the description of excited.
And you're telling me that the feds waved her off. That's what you're telling me?
Correct.
The feds under whom? Who was in charge of the feds?
At that time, I believe it was still Attorney General Barr.
Okay, who was the president at that point in time?
Donald Trump.
Oh, think about that for a minute. You're telling me that this elected Democrat, who you claim the maybes, the possibilities, the potential, all kinds of crimes, that she, as an elected Democrat, decided, stand down. Donald Trump says, stand down. You think that we really believe that foolishness? Do you think we believe that?
I have no idea what
Nobody believes that. And you don't believe it either.
Your Honor,
do
I
you?
object, sir, thank you, to the form of the question and offering an opinion that he is not entitled to offer in testimony.
Sustain.
You don't believe that either, do you?
I don't even know what you're saying right now. What was your question?
Now, you had told us that potentially, possibly, maybe abuse of official capacity, right?
Correct.
Potential, maybe, who knows? Acceptance of gift to a public servant?
Correct.
No clue if that was true or not, was there? You had no clue, did you?
Can I explain the purpose of the memo?
I'm asking you whether you had any clue that any of those things were true.
Based upon the information provided by the 3 witnesses that we had interviewed, yes, it appeared that it was true.
You thought it was true, so you had probable cause to make an arrest, and that's what you did, right?
No, a preliminary investigation is to determine whether or not to move forward with an investigation. That was the stage we were at.
Probable cause means you have enough for an arrest, right?
Probable cause would give rise to justification for an arrest.
You didn't have justification for an arrest, did you?
We were at the point of making a determination of whether to move forward with an investigation.
There was no indictment, right?
Correct.
There was no arrest, right?
Correct.
And yet, you came here in front of all these fine people and told us a bunch of maybes. Isn't that right?
I came here and answered questions about the memo.
Mm-hmm. And looking at this litany that the lawyer wanted to put into evidence, one of those was possibly, maybe, who knows, engaging in organized criminal activity, right?
That is something I outlined in the memo.
That sounds bad, doesn't it?
It's an offense under the penal code.
That sounds like there's something really going on bad at the AG's office, right?
That is your characterization of that.
That's something you'd never want to be a part of, right?
I don't understand your question.
I'm just trying to figure out. I mean, if that's what's going on at the AG's office, if you really believe that, you certainly would never want to be a part of it, right?
I'm not an employee of the Attorney General's office.
I mean, my point is, you would never engage in such activity, would you? This maybe activity you talked about?
The activity that was being alleged on the part of Mr. Paxton?
You would never engage in any of these so-called potential crimes yourself, would you?
Correct. I would not.
You would never want to be a part of anything like that, would you?
That is correct.
You wouldn't want to be associated with something like that, would you?
That is correct.
You have dedicated your life, you claim, to the rule of law, right?
Correct.
And so there is no way you would ever want to be associated or affiliated with that kind of criminal conduct. Isn't that right?
I'm not following your line of questioning. You're talking about the conduct described in the memo about Mr. Paxton after the interview of the 3 witnesses?
I'm talking about organized criminal activity. You'd never want to be a part of that.
Correct.
I mean, if you really believe that, you certainly wouldn't want to be a part of it, right?
Correct.
You applied for a job at the AG's office, didn't you?
I did.
Let's make sure we let that sink in. You applied for a job after this silly memo you wrote, didn't you?
Yes.
Let it sink in. You wrote this silly memo where you talked about potential violations of law, and months later you applied to work at the AG's office, didn't you?
That is correct.
And you know what the kicker is? Who wrote your letter of recommendation?
Margaret Moore. She wrote a general letter of recommendation that I could use with any employer. It was not specific for that job.
She wrote you a letter of recommendation. This whole thing should be dismissed. Don't you agree?
No.
Yeah. I think the point has been made. Your Honor, I pass the witness.
Your witness on redirect.
Thank you, Mr. President. Mr. Cox, did you speak with the elected district attorney Moore to determine whether or not there was an ongoing, active investigation at the Travis County District Attorney's Office?
Did I? Please ask that again.
Fair enough. You indicated to us that prior to writing your October 28, 2020 memo, you had had a conversation with Margaret Moore. Is that accurate?
Yes.
Did you learn whether or not there was an ongoing investigation at the Travis County District Attorney's Office concerning the allegations made by Nate Paul?
Objection. The question calls for hearsay.
Sustained.
Did you review documents, or did you ask for any documents? You personally asked for any documents that would show whether or not there was an ongoing, active investigation concerning the complaints made by Nate Paul?
Now he's asking to testify about documents not in evidence, hearsay, and best evidence rule.
If I may, Your Honor, best
Sustained.
evidence. Did you have an opinion as to whether or not there was an ongoing investigation into the complaints made by Nate Paul?
Objection. His opinion is completely irrelevant.
Your Honor, we've established that under Rule 701 and others as a testifying witness, he's allowed to testify to what his opinion is based on the evidence as he knew it.
I didn't say that he was an expert, Your Honor. He's not an expert. That's improper.
And as Mr. Busby knows, without making these foolish arguments, 701 deals with lay witness opinions.
Sustain.
If we could please, Ms. Manella, play Exhibit 249.
And this goes beyond the scope of the cross.
And Your Honor, as you know,
He's expanding, if I can finish, please. I'm sorry, sir.
Of course.
He's expanding the recross, or his redirect. It's improper. He never mentioned that video that went into evidence, so he can't talk about it now.
If I may, Mr. President?
Under the rules, it was very clear in the rules that the senators passed 25-3 that redirect would have to be on what was already covered.
I apologize then, Your Honor. I didn't understand the rule. As it relates to that specific issue, we'll provide the testimony through an additional witness. Thank you, sir. Pass the witness.
I have nothing further for this witness, Your Honor.
Are you both finished with the witness? Dismissed?
Yes, Your Honor.
Okay. You are able to go.
All right, well, we were listening to, and it seems the lawmakers are done hearing from Greg Cox, who was part of the public integrity unit for the Travis County DA's office. He is someone
Before we call the witness, I want to be correct.
Looked into.
Not in the rules, being on direct to direct was what we discussed when we all met now 2 weeks ago, that redirect would be on what was brought into testimony on direct. That's what we discussed. You may bring in the witness.
So what you were listening to now, why I paused, is because we wanted to hear that clarification. So the prosecution started to ask Cox about something else that wasn't directly brought up in the cross-examination of Greg Cox, and the lieutenant governor said, well, you can't do that because you have to answer on a redirect. And if you saw in the background there, you saw a bunch of senators, including State Senator Nathan Johnson, who himself is an attorney, shaking their head, along with Cesar Blanco and Senator Royce West. These are all attorneys who said, no, that's not actually what we said in the rules. And that's why you heard the lieutenant governor sort of correcting and saying, well, this is what we agreed to on some level. But I want to listen in to, well, we'll pause. We see Rusty Hardin is coming back to the position of questioning this next witness. And of course, there's a lot of anticipation about who this next witness will be. So we heard from 5 of the 8 whistleblowers. And then today we also heard from Missy Carey, who was Paxton's former chief of staff, who talked with us. And then we heard from Greg Cox, who was with the public integrity unit. He took the stand. And now here we have it, Margaret Moore walking through the door. She is the former district attorney for Travis County. And I believe, what she is going to be talking about is certainly what was related to what Greg Cox was talking about, which is the investigation or the suspicion that the Travis County DA's office, the public integrity unit, had related to Ken Paxton and what was happening with Ken Paxton and this, what they described was a laundry list of possible violations that he had committed, and that they paused their looking into him at the bequest of the U.S. Attorney's Office. And so she's taking the seat now. Let's listen in to her testimony.
Thank you, Your Honor. Ms. Moore, I'm going to ask you, we've had trouble with this microphone with all of us, with mine and the witness, so if you would try to stay closer than you would ordinarily stay with the microphone, I'd appreciate it.
Will do.
All right, would you state your name, please?
My full name is Margaret McCarthy Moore.
Ms. Moore, how are you? I'm going to go through with you a little bit of history of your background and all, but I want to really kind of relate it to your personal, professional background. Where'd you grow up?
I grew up in Waco, Texas.
And did you live in Waco all the way through high school?
I did.
And after high school, what did you do?
I came to the University of Texas here in Austin.
And did you attend and graduate?
I did. Earned a BBA in accounting in 1970, and then I started law school here.
All right. After graduate school or after law school, what year did you become licensed to practice in the state of Texas?
1973.
And then what did you do?
At that time, I was working in the legislature. In 1973, I was working in the House. I got my license, passed the bar in April of that year. I ended up coming back and working the Constitutional Convention in 74, and I worked in 1975 during the session, and then when I became a lawyer, I really wanted to be in a courtroom, so I was able to, I was appointed the Juvenile Public Defender for Travis County in 1976.
All right, and then you had a series of other jobs. What led you into where you became the elected district attorney of Travis County?
Well, I was hired as an assistant district attorney in 1977. I had gotten to know Ronnie Earl when he was in the legislature, and he gave me a job in the DA's office.
How long were you there?
I was there until I was elected county attorney in 1980. I took office in 1981.
As the county attorney?
Yes.
How long were you the county attorney in
4
Travis?
years.
Pardon me?
4 years.
Okay. And then after your tour, would that be like 1985?
Correct.
And then what was your next position?
Mommy.
All right.
I had a daughter, and I remarried in 1984, and we had 2 sons, one in 85 and one in 87, and my husband was a litigator, so we made the family decision that somebody ought to be home with these kids. So I did not go back into the practice of law until much later. I did, though, during that time. I did serve twice on the Travis County Commissioner's Court as an appointee to fulfill unexpired terms.
What year did you become the elected district attorney for Travis County?
Well, I was elected in 2016, and I took office January 2017.
All right. So some of the things we're going to be talking about occurred in 2020. You were, of course, a Democrat, correct?
That is correct.
And then what was the outcome of the March 2020 primary? Or really, I think there was a runoff, was there not, in the race, in the primary?
2020, I was defeated in a runoff in July.
Right. So from July of 2020, you were in effect a lame duck to the end of the year, were you not?
Yes.
Right.
How flattering.
Not a phrase we all enjoy, but it was a reality, correct?
Correct.
All right, I want to take your attention, if I can, to Attorney General Paxton. Had you had a particular mission and intent as to the kind of relationship you hoped to have with Attorney General Paxton, as you were the elected district attorney as a Democrat, and he was the elected Attorney General as a Republican?
Well, and in general, my aim as district attorney was to establish good relationships between the Travis County District Attorney's Office and all of the law enforcement agencies, and that included the Attorney General's Office. I did work there under General Abbott for 9.5 years, so that was an office that I had a particular fondness for.
Well, I appreciate that. So at the time that General Paxton was the Attorney General and you were the district attorney, you had how many years' experience previously working for the Attorney General's office?
9.5.
And what year? What was that? When was that area?
I went to work there in 2000. Sorry.
That's okay.
2005 to 2014.
And was Governor Abbott at that time the Attorney General?
He was.
Was he the Attorney General for the entire time you worked for the Attorney General's office?
Yes, he was.
All right. Now, how would you describe into the period of May, June, or whatever of 2020, how would you describe your relationship and dealings with the Attorney General?
He had, General Paxton himself had been, I considered him a friend. I didn't know him well, but he'd been very generous with helping with matters that we asked him to help with. I considered him a friend.
All right, in May of 2020, did you become aware of any type of request that he was making regarding a particular matter?
Yes.
And what was that, and how did you become aware?
My first assistant was Melinda Monford, known as Mindy Monford, and she told me, informed me about...
Objection, hearsay. Sustained.
So, did you become aware of a conversation that Mindy Monford had with the Attorney General?
I did.
And as a result of that conversation, did you authorize or agree to any type of meeting with the Attorney General on behalf of members of your staff?
Of course.
All right. And when you say of course, what do you mean?
I did consider him a friend, and I'd considered the relationship between the DA's office and the Attorney General's office to be a very important working relationship. So an elected official, the highest legal officer in the land, wants to have a meeting with me or my folks, it's going to be yes.
And who attended this meeting, and what type of meeting was it? Were you informed as to where it was and all?
It was a lunch meeting to discuss a case that the Attorney General felt should be investigated by the DA's office.
So was the original contact then with a proposal for by the Attorney General for the District Attorney's Office to investigate a particular case?
It was directly between General Paxton and Ms. Monford.
Had you ever yourself at this time before heard the name of Nate Paul?
Not that I recall.
All right. No. And then were you present at the meeting?
No.
And to your knowledge, who was present at the meeting?
Mindy Monford, Don Clemmer, who is my director over special crimes, Mr. Paxton, Mr. Paul, and Mr. Wynn, an attorney from Houston that representing Mr. Paul.
All right. Now, at this lunch, did you know anything about whether there was perhaps another person? Have you ever heard of a Mr. Drew Wicker?
I have not.
So do you have any knowledge one way or the other as to whether he was at that lunch?
I do not have that knowledge.
When the lunch was over, did Mr. Clemmer and Ms. Monford come back to report on it to you?
Yes, they did.
And as a result of what they reported, what was your reaction as to what y'all intended to do with the Attorney General's recommendation, or request, rather?
Well, the allegations that were reported to me that Mr. Paul turned out to be his complaints that Mr. Paul brought to Mindy and Mr. Clemmer were ridiculous, and their communication to me was to that effect, and I agreed with them after they described it to me.
Can I have exhibit, which is in evidence 88, up on the screen, please, or on the iPad, please? Is that 68 instead? Do I have the wrong number? I'm trying to read handwriting on here.
Are you talking about the first referral?
That's the right exhibit.
68.
Do I have the right number?
Yes.
68? Thank you. Now, did you become aware, and was the issue as to what to do about a complaint by Mr. Nate Paul that he wanted to have investigated by the DA's office?
Yes.
All right. And once you found out enough about it, did you actually read the complaint that is before you, is on the screen rather, is 68? If we could go over to the other page where it says request to investigate. Did you know anything about, do you recall when you reviewed it and formed whatever opinions you had about it?
I do not recall when.
All right. But did you ultimately become aware of what the allegations were here and what the contentions were?
Oh, yes. Okay. I was aware of the allegations, but I didn't see the RTI until later, if I did it. So I don't know when that was.
What was your position as to what your office was going to do with this complaint?
Well, it was going nowhere.
All right, but if it was going to go nowhere, what do you mean by that?
I mean, it would have been handled like with courtesy. You hear fill out the form, and then it would have been followed up by a rejection letter.
All right, does the rest of this exhibit, if you could, Stacy, just go through, give about 5 seconds on each page and ask if this document showing her is the kind of form and complaint that your office would do. And I want to go particularly to the page. I want to make sure that we're not publishing any of the identifying of data on the complaint. So here you see the signature of Mr. Paul. You notice, now, do y'all request that they swear to these complaints, or is that there in case they choose to?
No, it's a practice that they swear to the complaint.
Okay, you stay with that microphone, ma'am. Pretty please. All right. Now, this, of course, has a place for somebody to notarize and swear to it if they choose to, correct?
Correct.
And what is the policy in your office ordinarily? Do people swear to these complaints? Are they asked to, or what's customarily done?
My belief is that they were asked to swear to it.
All right. Well, we notice here that this didn't happen here, correct?
It did not.
All right. Now, on the next page, I don't want to show the people over. I'm going to read you some names, but with no identifying data on the screen until it gets taken out. And I don't know whether it's been taken out of this particular screen. I'm going to just read names to you without us publishing them and see if you recall these names being names that were proposed that they would be investigated based on this document. Mr. Saban, Mr. Preston Joy, Mr. Jason Ernst, Mr. Alan View, Ms. Gupta, a Judge Mark Lane, and then a series of other, one other person, some others. Now, were you aware of the nature of who some of these people were at the time you were informed about this?
Absolutely.
And is this another reason that you're saying it wasn't going anywhere?
It was going nowhere in my office.
And does that mean that y'all had no intention of either investigating or prosecuting with this kind of allegation?
None whatsoever.
If we can, Stacy, if we can move over now, skip the people and go to Bates number 68. Excuse me, Bates number 9036, 9037. And I want to represent to you, this is Mr. Paul laying out what his contentions are so. And ultimately, did you folks decide what you were going to do with this case? That's fine, you can take it down, thank you. What were you going to do with this case if it was going to go nowhere? What did you do?
I decided to send it to David Maxwell.
And by the time you were going to send it to Mr. Maxwell, how long had you known him, and what was your view of his competence and ability, et cetera?
Well, I don't remember how long
And I want you to get back to that microphone.
I said I don't remember how long I knew of his reputation because I worked in the AG's office. I thought very highly of him. I knew that he was a former Ranger, and I'd working with the Rangers. He had a very, very stellar reputation as an investigator. I decided to send it to him because I was quite confident that he would view this complaint the same way I did.
And so, what you thought when you sent it, when you came up with the idea of sending it to the AG's office, why did you send it to the AG's office instead of just politely telling Mr. Paul, no dice, nice to have met you, we're not going to do anything?
Because I didn't want to offend Mr. Paxton.
If, in fact, Mr. Paul had come on his own, not being sponsored with the Attorney General, and made the same complaint, what would you have done?
We would have sent a rejection letter.
Pardon me?
We would have sent a rejection letter.
All right. But because it was sponsored to you by the Attorney General, what did you do?
Your Honor, I'm going to object. There's been no evidence of any sort of, quote, sponsor. So I object to that.
We just had a luncheon in which he sponsored it. I don't know what he means.
Overruled.
Thank you. Go ahead.
Had it not been for Mr. Paxton's personal interest, it would have been handled routinely. But because I valued the relationship with Mr. Paxton and considered him to have been a friend, I didn't want to offend him, and so this seemed to be a delicate way of having the matter reach conclusion.
Yeah. So let me ask you, if you sent it over to him, if I can I have 668, please? This is in evidence, Your Honor. Actually, it's AG 68. Again, I'm misreading handwriting, and I apologize for it. All right. No, I'm sorry. Let's go to 124. Now, can you read this?
Mm-hmm.
All right.
Yes, I can.
And can you identify what it is, please?
This is a letter from Don Clemmer to Brandon Kamek, sending a second complaint that Mr. Paul filed with our office.
I'm sorry. This is a second referral.
Yes.
I wanted to go to the first referral. I apologize. I'm probably giving you the wrong number, Stacy. I want the first referral, please. Thank you. Now, if you would look at this, this letter is signed by whom? Signed by whom? There, you can see below.
By Don Clemmer.
All right. Was this letter written at your suggestion?
Yes, it was written after we discussed what I wanted it to say.
Did you instruct or discuss with Mr. Clemmer the language he would use in describing to Mr. Maxwell while he was sending it?
Yes.
All right. I want to particularly to look at the last sentence where it says, or the next to last sentence, the last two sentences. However, since an employee of the Department of Public Safety is one of the subjects of the complaint, referral to the Rangers would appear inappropriate. I'm therefore requesting that your agency conduct the review. Did you consider this an official recusal from you?
Absolutely not.
All right. And then why did you got that sentence in there saying that since he was the Department of Public Safety is one of the subjects, it would be inappropriate to send to him? Why is that in there?
Well, matters of public integrity we're required to involve the Texas Rangers. One of the named the people in the complaint, it was a Ranger. But this letter was written to send it over, but not to in any way endorse it as needing to be investigated.
Had y'all done any investigation of this complaint?
I think the one thing we ascertained is that there was indeed an active federal investigation, and other than that, no.
All right. And did you at any time intend and expect the Attorney General's office to conduct an investigation?
No.
And in fact, this letter doesn't ask for an investigation, does it?
No.
This letter says for them to do what with it?
Review it.
And by that language, knowing and with Mr. Clemmer, having worked with David Maxwell, what did you want to make sure that Mr. Maxwell understood that language meant when you sent it to him?
Objection, Your Honor. This witness did not send this letter. Mr. Clemmer would be the one to answer that question.
What she
Can I finish my objection, please? Mr. Clemmer
how long? Not if you keep using my time.
Stop. Court reporter can't report.
I understand.
Record accurately.
I am going to request, though, that this man learn to object the way it's supposed to be. Otherwise, he's using up our time unnecessarily. He's been speaking through the objections all day, and I respectfully ask that the court to keep that in mind.
State your objections.
Thank you.
I sustain the objection. Continue.
All right. Now, what did you expect is what I'm asking. Not somebody else, but what did you expect when you sent that kind of language over there?
Objection, speculation.
No, I asked what she expected. I'm not asking her what she expected. Let me put it this way. What did you expect and want to happen?
Overruled. Go ahead.
I expected David Maxwell and any of the criminal lawyers in the AG's office would view this matter as absolutely baseless and not worthy of investigation. I expected it to be a dead issue on arrival.
And in fact, did you give Mr. Clemmer instructions to call Mr. Paxton ahead of time and warn him it's coming? Mr. Waxwell, not Mr. Patton.
Yes, I did. And I did not want David Maxwell to think that I didn't have the good enough sense to know this was ridiculous.
All right. Now, during that time, when it happened, did you ever authorize a Mr. Kamek or anyone else associated with the Attorney General's office, did you yourself authorize them to conduct any kind of criminal investigation?
No.
Did you appoint anyone as a special prosecutor?
No.
Did you appoint anyone as a pro tem prosecutor?
No.
Tell the jury the distinction in your mind of what a special prosecutor is, if such a position exists, what a pro tem and prosecutor is, and what you did or did not do as a result.
A pro tem district attorney is appointed when the district attorney recuses, and that's a formal process. It requires the district attorney to ask the court's permission to recuse, and when the court does recuse, a pro tem is appointed to take the place of the district attorney.
And what is the process that happens? I mean, is there as you mentioned, formal process? Let's say that the attorney, your office concludes it's wrong, appropriate for you to conduct a lawsuit as a matter of ethics or public policy, and decide that you're going to recuse yourself and ask an attorney pro tem, would it be, to be
Yes.
appointed? And that would be like a DA in an adjoining county?
That is the law now. Or it could be the Attorney General's office.
All right.
We had an instance of that.
If you decide to do that, though, what would the process be?
A motion would be made in court.
A written motion?
Correct.
All right. A written motion is made to a judge, and what would that written motion say?
It would say that the district attorney, because of a conflict, or for whatever other reason, it's usually a conflict, is asking the court's permission to recuse, and the court then please appoint a district attorney pro tem to handle, and it's always a specific matter.
All right. And did any of that, and then does the judge ultimately, for it to be effective, enter an order?
The judge rules on the motion and enters an order, and usually at that time has found someone to be appointed. It is, not uncommon to assist the judge in finding someone, but I've also had a judge say who she wanted.
Right. So if one is appointed pro tem, it ultimately results in a judicial order, does it not?
It does.
All right. Did that happen in any way? Any of those procedures you described, any of that happened involving anybody being asked to look into the complaint of Mr. Paul?
No.
Now, how would a special prosecutor work if you were going to appoint a special prosecutor?
Well, the way we use the term special prosecutor, in my experience, has been that the district attorney appoints someone to handle a special matter, and that person is not on the payroll of the district attorney, but is sworn in by the district attorney and becomes essentially like any other assistant DA. It's under this. When the pro tem is appointed, the DA loses all control over the lawsuit. The DA is out of it. And it's with a special prosecutor, the district attorney continues to supervise the handling of the case.
And are they actually sworn in by a judge?
No, they're sworn in by me.
All right. Did you do any of that in this case?
No.
So was either a attorney pro tem or a special prosecutor under that term, were either of those positions engaged in by you on this complaint of Mr. Paul?
No, they were not.
And when this file went from you to the Attorney General's office following the letter of Mr. Clemmer, did you, by that time, had you hired, retained, appointed, sworn in, any of those things, any lawyer to look into and work with you on the complaint of Mr. Paul?
No.
And after that case file left you and went to the AG's office, did you in your office have anything to do with investigating that file?
No, we did not.
Other than helping Mr. Kamek get his grand jury subpoenas, other than that, did you do anything to assist Mr. Kamek in investigating this case?
No.
And did anybody in the Attorney General's office ask you to aid in any way Mr. Kamek?
No.
Did the Attorney General ever ask you in any way to aid Mr. Kamek?
He did not ask me. I don't know that he asked anyone.
So was Mr. Kamek ever hired or employed by your office in any way?
No.
I believe I have the right number. I just want to make, if I could check. This is a video that is in evidence. I'm going to ask Stacy, Exhibit 249. I'm going to ask her to cue it up and play it for the jury, please. And I will ask you to listen, then I'll have a question afterwards.
I want to talk about the appointment of special prosecutors, and I don't know if you or the general need to answer that. Is it rare for your office to appoint a special prosecutor?
So, is this a general question about special prosecutors? Is that
just at the AG's office in general?
Okay.
Yeah,
I'm happy to address that. So,
I would actually rather if General Paxton would address it, but if
he knows this like backwards and forwards. He was a prosecutor, so he knows this issue very well.
Well, I'm wondering who hired Brandon Kamek. Was that you?
So, if I can address that,
sure.
Our office entered into a contract for Brandon Kamek to be outside counsel. And so he was serving as outside counsel for the AG's office. Now, I have, through the process of, I started, as you know, in October after this happened, I have interviewed ADAs from Travis County, and I've seen documents from Travis County that prove the fact that the Travis County DA's office made Brandon Kamek a special prosecutor. We did not make Brandon Kamek a special prosecutor. That was within the purview of the Travis County DA's office. So the special prosecutor word gets confusing at times because there's two types. One type of...
What is your testimony?
Is a pro tem prosecutor, and a pro tem prosecutor can only be put in place when a DA's office recuses themselves from a case. And that's not what happened with the Brandon Kamek situation. We hired him to be outside counsel. That contract was signed by the general. And then he went to go work because he was hired on to assist the Travis County DA's office. And the news glosses this over. No one ever goes and looks at the Travis County DA's office's files. They don't give really deep interviews on these things. But the fact is, he went and said, I'm the guy that's going to be the outside counsel for the AG's office, and I'm here to assist on your investigation. And then through that process, he worked with them to get grand jury subpoenas, and that's how he became a special prosecutor.
And I'm aware of the difference. I actually wrote the legislation that determined on pro tem who could actually be appointed. So yes, I'm familiar with this.
Is that testimony truthful?
No.
How untruthful is it? In what way?
It is astonishingly untruthful. There is no way that anyone could interpret the facts as my appointing Mr. Kamek as a special prosecutor. I couldn't pick him out of a lineup today. I don't know him.
Pass the witness.
Mr. Busby? Hey, Ms. Moore.
Hello.
How are you doing?
I'm doing well, thank you.
Good. Eric, could you pull up Article 5, the impeachment article, so we can look at it real quick? As he's doing that, Ms. Moore, you're telling us all that there was never, in this situation, an attorney pro tem, true?
Correct.
Let's look at the article of impeachment. Article. You see the language, it says, Attorney General Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. See that?
I do.
There was never a prosecutor pro tem with relation to Mr. Kamek. Isn't that true?
There was not one appointed.
Okay. It sounds like when you learned about the complaint of Nate Paul, your initial gut reaction was, that is absolutely ridiculous what he's alleging. True?
True.
But you know, of course, that sometimes the FBI does in fact violate people's rights. Right?
I've never witnessed that.
But you certainly read the news reports about it, haven't you?
I've read news reports alleging that.
I mean, there's a lot of them, but did you hear about the FBI admitted flawed forensic testimony in 32 death penalty cases?
No.
How about when the FBI conducted improper searches of U.S. officials using a foreign database?
I don't know about that.
How about when the FBI improperly spied on activists?
I don't recall reading about that either.
How about when the FBI misused an intelligence database and performed 278,000 searches?
I didn't hear about that.
And the reason I keep asking you about these repeated alleged FBI abuses is because when you first heard about this alleged FBI abuse, the first thing you thought was ridiculous, correct?
No, that's not correct. That's not what I said.
You knew that a federal judge had ruled that FBI agents had conducted illegal searches of businesses?
I don't know what you're alluding to.
How the FBI violated the privacy rights of tens of thousands of Americans?
Mr. Busby, I'm not aware of that article.
It seems to me that might be something you make yourself aware of before you decide.
Excuse me, this is all irrelevant. Using it to attack one agency or another is irrelevant to what the Attorney General did in this case, and I object to being extremely irrelevant.
Your Honor.
Overruled.
Thank you.
But Judge, the second thing is he's testifying.
I'm asking.
Cross does not give him a right to simply sit up there in an unsworn way and make these kind of allegations. He's testifying and not asking a question.
Not making any allegation.
Please.
My question to the witness.
Properly.
Yes, Your Honor. My question to this witness who claimed or who said in her statement that she gave the Board of Managers that her initial reaction was this entire claim against the FBI was ridiculous. I'm just asking her whether she had heard very similar claims
and had seen very similar claims reported all over the United States with regard to the FBI.
It does not allow him to be talking about irrelevant other circumstances, Your Honor, to make
Okay,
his
well,
point.
he stopped. He stopped. You put a stop to that, right? We've asked him to go straight, ask the questions properly. Go ahead.
Thank you.
May I answer?
I don't know. The lawyer's objecting. I don't know. I'll move on.
No, I'd like to answer because you misstated what I saw and why I responded that way. It wasn't just against the FBI. It was a whole range of agencies. It was a conspiracy that I felt was absolutely incredible and without basis. That's not just the FBI, the Texas Rangers, the U.S. Marshal, the U.S. Magistrate, the U.S. Attorney's Office, all of those together, the Securities Board. That's why I considered it incredible.
Well, could you have just said, you know what, I don't think the Rangers would do that. I don't think the magistrate would do that. But you know what, those FBI folks, they may have done that. You could have just investigated that, right? What you could have done.
Mr. Busby, I worked with the FBI. I worked with the FBI to have a prisoner, an accused murderer surrender at the border the very first month I was in office. I worked with the FBI investigating the bombings in this city. I stood next to the U.S. Attorney himself, watching assistant U.S. attorneys and FBI agents and other law enforcement officials drawing up search warrants to submit to a magistrate. I did not find this allegation of a broad conspiracy among all these agencies to have any merit.
Based on no investigation, true?
Correct.
Yep. So what you decided to do, rather than investigate it, you decided to refer it back to the AG's office, right?
I decided to send it to David Maxwell.
Yeah, you said part of the allegation was against the Texas Rangers, right?
Yes.
So you sent it to the Hall of Fame Texas Ranger, didn't you?
Well, he was the chief investigator in the AG's office.
Trying to get this right. You thought it would be inappropriate to send the allegation to the Texas Rangers, so you instead sent it to the Texas Ranger, right?
What I'd really I think would be truthful here is that I wasn't concerned about sending it to the Texas Rangers because it wasn't worth sending. I did think that the chief investigator in the Attorney General's office would view it the same way.
So I'm just trying to remember who it was sent to. So one of the allegations was against the U.S. Attorney's office?
Yes.
And the referral was to a former U.S. attorney, right?
I don't know to whom you...
Mr. Penley, a former U.S. attorney?
Mr. Penley was not named in that letter. It was specifically sent to David Maxwell.
Well, we all know now, and I know you weren't here and you wouldn't know this, but just so we're clear, the allegation, among others, was against Texas Rangers and U.S. Attorney's office, and you sent it to the AG's office, where the head of both of the divisions that would have looked at this would have been a Ranger and a U.S. Attorney. Did you realize that?
I didn't know Mr. Penley.
Let's look at the referral letter, AG 68. Eric, please.
Just to correct the record, I believe he mistakenly referred to Mr. Penley as a U.S. attorney, and I don't want that to stay unchallenged. He, of course, was an assistant U.S. attorney. I don't want a suggestion that this was being looked at by a U.S. attorney.
A former assistant U.S. attorney. I think we all know who he is. He testified.
Thank you.
Now, let's look at the referral. Clemmer at the time worked for you in the office, right?
Yes.
Okay. He had the authority to send this letter, true?
Yes.
And he sent the letter to Mr. Maxwell. You've told us that, right?
Correct.
And he says, would typically forward such a complaint to the Public Integrity Unit of the Texas Rangers for review, right?
Yes.
However, since an employee of the Department of Public Safety is one of the subjects of the complaint, referrals to the Rangers would appear inappropriate, correct?
Yes, he says it.
Okay. Now, you also made a comment with Mr. Hardin about, you typically would require someone making a criminal complaint to swear to the complaint. Is that right?
Yes, the form.
Is it required?
I didn't review every single complaint, but it's my understanding we had that policy, yes.
That was the policy in the office, is to require the complainant to swear to the complaint?
Yes.
May I approach the witness? Do you see the document I've just handed you, ma'am?
I do.
And it's an email, is it not?
It is.
An email from whom to whom? From who to whom?
There's two, it appears.
Is this email from people within your office?
Both of the emails on this piece of paper are from Todd Bircher to Don Clemmer, and then the next one is Todd Bircher to M. Wynn.
How do we move for admission of this piece of evidence?
Any objection?
No objection.
Admit to AG Exhibit 0242 into evidence.
Now we'll put on the screen Exhibit 242, which I think His Honor put in evidence, allowed into evidence. And let's just so we know what your underlings, Mr. Bircher was one of your subordinates, was he not?
He was.
And let's look at what he told Mr. Paul's lawyer in writing. I'm going to read it. You tell me if I get it right. Please see the attached RTI, which includes instructions on submitting your client's complaint. Feel free to contact me with any questions you may have. Again, no need to get a notary signature on it. That's what your people told Mr. Paul's lawyer. Isn't that true?
That's what this email says, yes.
And yet, there's been suggestion here that the complaint, Mr. Paul, a suggestion that he knew that was baloney, and that's why he didn't get it notarized. Did you know that was the suggestion being made? Did you know that was the suggestion being made?
I've been under the rules, so I haven't heard anything.
I figured that. But what we know specifically is exactly what Mr. Paul's lawyer was told is what he did. He did not get it notarized, did he?
No, he did not.
Now, I want to focus with you, if you would, on the second referral. It's in evidence, AG Exhibit 124. Let's take a look at that one. Were you aware that your subordinate, Mr. Clemmer, was sending a second referral?
I don't know when I became aware of that. It very possibly was after this. I don't know.
So it could be the case that when Mr. Clemmer sent a second referral directly to Mr. Kamek in Houston, you didn't have any idea about that at the time.
That could well be the case. I just don't recall.
Now, certainly Mr. Clemmer, common sense would dictate Mr. Clemmer knew who Mr. Kamek was, right?
I don't know what he addresses this to him.
Right. He knew who Mr. Kamek was. Otherwise, why would he send him the letter in Houston? The referral in Houston, right? That's common sense, isn't it?
It would appear.
Yeah, okay. Is it typical? Let me ask it this way. If a special prosecutor is appointed and an additional matter comes up within the office and they want to continue to use the special prosecutor, is that sometimes done?
That did not occur in my administration.
Mm-hmm. Now, I want to look at some things that were happening. Maybe you didn't know about them. Did you not realize that the people within your office were assisting Mr. Kamek in obtaining grand jury subpoenas?
I didn't know it until recently.
Okay. You had no idea that there were multiple people in your office who were guiding Mr. Kamek in obtaining grand jury subpoenas?
I did not.
But you will admit now that you know it now, right?
I do know it now.
So let's be clear. Even though you didn't know it, you admit that there were multiple people in your office who were assisting Mr. Kamek in obtaining grand jury subpoenas related to both the first and second referral. Isn't that right?
That's what I believe to be the case, yes.
Yeah. As an example, let me offer, hopefully without objection, I need to know if this is in evidence, House Managers Exhibit 186. We offer House Managers Exhibit 186. It's their exhibit. Copies?
It's not in
we offer
evidence yet. Any objection?
House Managers 186.
Mr. Hardin, any objection?
May I have just a second more, Your Honor?
Yes, you may.
I have no objection.
Admit 180, is it 186? Yes, 186 into evidence.
Yes, Your Honor. And Eric, bring up House Managers Exhibit 186 that's now in evidence and go to the third page. Make it the fourth page, Eric, please. Here we go. Now there's some email traffic between Brandon Kamek and someone named Gayla Schwab. Do you know that person?
Yes.
Who is she?
Her position was bailiff of the grand jury.
Okay. And let's go to the next page, Eric. And notice here that Gayla Schwab, who's the legal secretary at the grand jury unit, is sending an email to Brandon Kamek. Do you see that there at the bottom?
No, not on this page. I'm seeing the email from Bailey Molinar.
Look at the email. It says, "Hi, Brandon. I was directed to forward your request to Don Clemmer, director of our Special Prosecution Division, to handle this matter." Do you see that?
No, that's not the page that's on my screen.
Okay, well, my eyes are terrible, so I can't see really your screen. Eric, third page, Exhibit 186, email at the bottom to Brandon Kamek from Gayla Schwab. There we go. Now, can you see the email where she is referring Mr. Kamek to one of your subordinates?
Yes, I see that.
And do you see
enlarging it?
I know it's hard. We're going to try to roll through this quickly. And do you see that your subordinate, Mr. Clemmer's response to Mr. Kamek? Right above it?
I've seen it, but this is illegible. Okay,
How about now?
Here we go.
He says, let me know what type of case this investigation involves so I can get the right people to assist you. Thanks. That's what he says to Mr. Kamek, right?
Yes.
He says, Kamek, let me know what case this is so I can get the right folks to help you, right?
What he says.
Okay, and then...
Your Honor, excuse me, Mr. Busby, can I ask if the witness would like a paper copy to have in front of her? If so, I'll be glad to give her one.
Can you read this?
I can when they enlarge it.
Yeah,
Okay.
can read it. He's just trying to slow us
All
down.
of us
We can read it.
all of us need it enlarged, so.
Yep. And we'll enlarge every part that,
very well.
the best I can. I can't see it either, Ms. Moore. And do you see Mr. Kamek's response? Bring it up. It says, it's on September 23rd, 2020 at 4:25 p.m. You see? He says, I've been appointed on a referral from your office to the AG's office regarding a matter involving public corruption. I am trying to get grand jury subpoenas issued. Do you see that?
I do.
He explained in detail what he was up to, didn't he?
I'm not sure about the detail part, but he does say.
I mean, it's in writing. What he was telling your subordinate what he was doing, right? He's getting grand jury subpoenas for a corruption investigation, right?
Yeah, he just doesn't mention that it was the Nate Paul case, but he does say it's a matter involving public corruption. I'm reading this. The first time I saw it was last week.
Right, and that was the first referral. Let's look at the first page of this exhibit, and we can see at the top another email to Mr. Kamek from your subordinate, Don Clemmer. Pull it up, please. And here's where your subordinate is sending a referral to Mr. Kamek. That is the second referral, isn't that right?
Yes, September of 20.
Okay, so if there's any suggestion by anybody that your people weren't helping this young man obtain grand jury subpoenas, that would be false. Isn't that right?
They did help him.
They even filled out the forms for him and sent it to him via DocuSign, didn't they?
Yes.
Let's let that sink in. They filled out the form, emailed it to him using DocuSign, and all he had to do was DocuSign the applications for the subpoenas. Isn't that right?
That's my understanding.
Who put the word special prosecutor on the DocuSign that was sent to this man?
I do not know that.
So, according to you, it could be possible that your subordinates in the office put that language in the DocuSign that this young man signed electronically. Isn't that right?
Yes, but I noticed that he uses that term, special prosecutor, for the OAG.
Yeah.
So I wouldn't be surprised if they used his language.
I mean, they certainly didn't tell him, don't use that language, did they?
No, I wouldn't think that a secretary to the...
It was more than a secretary, ma'am. You know it was more than one person, don't you?
There was...
You know there
Mr. Busby, do you want me to answer these truthfully, or do you want me to just...
No, I prefer you not lie. Yes, of course, I'd prefer you not lie. I'd prefer you to follow your oath. Will you agree that there were multiple people involved in your office in assisting this young man and getting grand jury subpoenas issued?
I would agree that multiple people offered to assist him. I do not believe multiple people filled out the forms.
I want to show you something that's in evidence, and you just tell me if it's true. And I'm going to get yelled at for this, but it's Exhibit 127, Exhibit 19, Eric. It's already in evidence. (127) Exhibit 19, Eric. There we go. Now, here's some language in this letter sent to Mr. Kamek shortly thereafter, and it says, "It has come to our attention that you appeared before the Travis County Grand Jury. Can we agree that Brandon Kamek never appeared in front of any grand jury?
Ever? I have
with
no
relation
idea.
to this particular matter?
Well, he wouldn't have appeared in person before a grand jury.
I mean, all he did...
All the grand jury proceedings at this time were, in fact, over Zoom. Anyway.
He didn't even do a Zoom. All he did...
I don't think he did.
Yeah.
I mean, it would not... It would be... May I finish?
Yeah, sorry. Go ahead.
It would be unusual for anyone issuing a grand jury subpoena to actually appear in front of the physical grand jury.
Right, because what we know happened was some of your folks in the office helped him fill out forms and he signed them electronically with DocuSign, right?
That's what it appears to me happened.
Now, is it true that your office was excited about pursuing an investigation against Ken Paxton?
I can't speak for the entire office, but I was not excited about any of this.
Okay. Your Honor, I pass the witness.
Redirect, Mr. Hardin.
Yes, Your Honor. Your Honor, I move to introduce Exhibit 243. Thank you.
If you're just joining us, we are listening as the prosecution is doing their redirect on witness Margaret Moore. She's the former district attorney for Travis County and headed up the public integrity unit for the county, which looked into allegations of elected officials.
And so I object to it.
And as I said earlier, and I corrected myself, it was not within the rules, but we had discussed redirect would be on what was discussed in direct.
I understand, but part of this cross was challenging whether or not her office was involved and what her office's involvement with this and what they did. This is her answer to an Attorney General public relations statement that he made, which also sets out her position about this entire matter, and she sent it to him on October the 9th, long before any of this was looked at.
Hold on 1 second, councilors. I'm going to overrule the objection because it does go to the cross testimony.
Thank you. Can you put it up, please? Now, I'm going to ask you to publish it by reading it. If you look up close to the microphone, I'd like for you to read to the jury what you told Mr. Paxton on October the 9th of 2020 through this letter.
Well, it's addressed to Ken Paxton, Attorney General of Texas, the Office of the Attorney General, via email and by hand delivery. Dear Attorney General Paxton, on June 10th, 2020, my office sent to David Maxwell a letter referring a request to investigate, in parentheses, RTI, filed in our office by Nate Paul. The RTI was received by us after you asked my office to hear his complaints. The referral to the OAG was made with your approval. We did not conduct any investigation into the merits of the matters complained of. And referring the matter to the OAG, we concluded that ours was not the appropriate office to either address the matters raised in the complaint or to conduct an investigation into them. The referral cannot and should not be used as any indication of a need for investigation, a desire on the Travis County DA's part for an investigation to take place, or an endorsement of your acceptance of the referral. My office has closed this file and will take no further action. Furthermore, I have instructed my employees to have no further contact with you or your office regarding this matter. Any action you have already taken or will take pursuing this investigation is done solely on your own authority as provided by Texas law. The newly surfaced information raises serious concerns about the integrity of your investigation and the propriety of your conducting it. Sincerely, Margaret Moore.
Now, Ms. Moore, are you aware that if one is a special prosecutor, that they are to be supervised by the authority appointing them a special prosecutor?
Yes, especially and a properly appointed special prosecutor is supervised by the prosecuting authority.
And if somebody is appointed as a special prosecutor, or let me strike that another way, do you consider when a person that says that they are a special prosecutor for the Attorney General, when that person contacts your office and asks for help in getting out subpoenas, tells you he doesn't really have experience in doing that, and your people assisting him, do you consider that in any form, in any way, supervising his later investigation?
Objection, leading.
Sustained. You can tell me either way. What is your opinion as to whether that is some type of supervision?
Number one, I don't know that there's any such thing as a special prosecutor for the Office of the Attorney General. A prosecution is the authority to prosecute is limited to the elected district and county attorneys of the state. So I don't even know what a special prosecutor for the OAG is, but this person was not appointed by me and was not supervised by me. And
was he authorized? Would he be authorized to do any prosecution in the state of in Travis County without your approval?
No.
And is that built into the statutes that say only the elected district attorney of a county has the authority to approve and conduct prosecutions?
That is the law. And I knew that.
Finally, the video that we saw, did you notice that the Attorney General made no attempt to correct that untruthful testimony given before the Finance Committee?
Not in the clip that I saw.
That's all I have. Thank you.
We need to admit Exhibit 243 into evidence, which I had not admitted into evidence yet.
Thank you very much.
Mr. Busby, recross.
Yes, Your Honor. Let's look at, you said 247 is what it was, or 243?
243.
243.
Yes, sir.
Put on the screen, Eric, it's RAG 19, same exhibit. Ms. Moore, at the time you wrote this letter, you didn't even know about the second referral, did you?
I easily could have. It's October 9, and the second referral was sent to Kamek on the 23rd. What happened in between is the motion to quash the subpoenas issued by Mr. Kamek were granted by, the motion was granted to quash those subpoenas. And when that happened, all of this was brought to my attention. So I could, by October 9th, have seen the second referral.
Let's just make sure that we can agree on something. You didn't mention any second referral in this letter, did you?
No, I didn't.
No mention whatsoever of the second referral in this letter, is there?
No.
Okay. One thing you said in this letter, in the third paragraph, your office has closed this file, right?
I do say that.
So up until that point, y'all had an open file on this referral, didn't you?
I don't know that we did. I saw this. I don't have a full recollection of exactly what was going on at that moment, but I don't think we ever actually opened a file.
So you just closed the already closed file? Is that what you're saying?
Could have, yeah.
So how many times do you have to close a file before it's closed?
Well, Mr. Busby, I'm sorry, but this matter was dead on arrival, and it remained that way in my mind, and
conviction non-responsive.
all along.
Sustained.
Now, one of the things that happened after all this came out of the newspaper, in addition to you sending this letter, you also told one of your subordinates to put everything that had happened in writing, didn't you?
You want to be a little more specific?
You remember Mindy Monford?
Oh, yes.
You encouraged Mindy Monford to do a full statement of what the office had done with regard to these referrals, right?
I encouraged her to make a statement about what occurred, yes.
And that statement is AG Exhibit 44, and we offer it, Your Honor.
Can you give us a copy?
Is it in evidence or not? It's in evidence, Your Honor.
It's already in evidence.
I'm sorry about that. Eric, please put Exhibit 44 on the screen. In response to your encouragement, one of your subordinates, Mindy Monford, did in fact put everything that had happened, at least from her point of view, in writing. Isn't that right?
Yes.
Let's look at what she put in writing. And she swore that this was true, did she not?
Yes.
The scope is being exceeded by this based on the court's rulings.
No.
I don't believe anything that this is relevant to the. I never mentioned Mindy Monford. I didn't discuss that at all.
Your Honor, you let him put into evidence over my objection her letter about how things went down. And now to complete the record, I've put into evidence, it's already there, what her subordinate who was directly involved said went down. And it's perfectly within the line of the recross.
He's perfectly entitled to call her as a witness, and we would welcome that. But I'm not objecting to the exhibit. But going into this subject is what I'm saying is contrary to the court's previous ruling.
I think he gave the explanation why it's not contrary to the court's rule that we discussed, because it had been introduced, overruled.
So let's look at the affidavit that was done. And just, Eric, so everybody knows, look at the last page of Exhibit 44. So we'll know when Ms. Monford swore that this was what actually happened under oath. Go to the last page. Can you confirm with me, Ms. Moore, that she did this in January of 2021?
Yes.
Okay, now Eric, go back to the second page of this exhibit. Last paragraph. Ms. Moore, I just want to make sure that I get this right. Don Clemmer and I discussed the meeting with Margaret Moore by phone. That's true, isn't it? The meeting with Nate.
For enlarging it.
There we go.
Is she referring to the meeting with...
the lunch meeting with Nate Paul.
Meeting. Okay, yes.
Yep. She goes on to say at the beginning of the last sentence in that paragraph, the district attorney's office no longer has the resources to conduct broad-based investigations. Go to the next page, Eric. Pull it up so we can read it. This is what she said was the truth at the time. To conduct broad-based investigations on its own, so we knew we were not capable of thoroughly looking into the allegations. Am I right so far?
Yes.
She said, when we receive complaints from individuals such as Mr. Paul's, it is our normal course of business to refer these cases to the Texas Department of Public Safety, the Office of the Attorney General, the FBI or a local police department with jurisdiction to investigate. That's what she wrote, true?
True.
That's what she swore was the truth, right?
Yes.
Then she goes on to say, skipping a sentence, it was decided that we should refer the matter to the OAG for review. See that?
Yes.
She goes on to say, it was our intention to have the OAG review the matter and determine whether or not it rose to the level of a formal criminal investigation. Do you see that language?
I do.
Okay. Let's go to the bottom, Eric. The sentence, pull up the last half of the last paragraph. The sentence starts, I also told General Paxton, that sentence. She says, I did inform General Paxton at that time that the district attorney's office did not have sufficient resources to look into Mr. Paul's claims, and that we believe the only agency that could properly review the matter would be the OAG. That's what she swore was true, correct?
It's written here, yes.
She then says, it should be noted that at no time prior to this conversation did General Paxton ask that we refer this matter to his office. To my knowledge, the idea to refer the Nate Paul matter to the Office of Attorney General...
Pardon me. My problem, Mr. Busby, excuse me. I'm having trouble following it. Can he point us to which page he's on and just tell me so I
Does
can...
the witness know where I am? Miss Moore, do you know where I am?
I'm reading it here.
Sure you do. We all know where I am. Let me keep going.
Excuse me.
Yeah, give him the courtesy of catching up.
Fourth line from the bottom of the second page.
Thank you.
Third page. It should be noted that at no time prior to this conversation did General Paxton ask that we refer the matter to his office. To my knowledge, the idea to refer the Nate Paul matter to the OAG came from our office. Did I get that right?
Yes.
General Paxton was not certain his office could even review the matter. You see that?
I do.
Your Honor, I pass the witness.
That we'll adjourn in a moment. I want to get you the time stamp here. Time remaining, House 9 hours, 19 minutes and 12 seconds. Respondent 12 hours, 14 minutes and 15 seconds. Tomorrow will be another long day. We'll come in at 9. We'll go to about the same time, 6:30 to 7, whenever the natural ending. Until then, we are adjourned. You may be dismissed. Thank you. Can she be, I'm sorry, can she be excused? Mr. Harden? Mr. Busby, can she be excused?
Yes.
Yes.
Yes, Your Honor, but with the same understanding, she could be on call.
All right, thank you.
So we are just now into testimony with Margaret Moore, who is the former Travis County District Attorney, and you heard at the end there, Lieutenant Governor Dan Patrick giving a time check of how much time that both sides have left to present their arguments in this case. But Margaret Moore is sort of detailing for us and reading, especially in the last thing that was being read to her, Tony, was a notice saying that that their office, the Travis County Public Integrity Unit, did not have the resources to investigate Nate Paul's claim.
Well, not only did she say that, Ashley, I think the most important part of her testimony is that Ken Paxton, Team Paxton, said during a Senate hearing earlier this spring that Margaret Moore's office, not the Attorney General's office, appointed the special prosecutor, Brandon Kamek. Margaret Moore gets on the stand and says, that's hogwash. I did not appoint Brandon Kamek. We had nothing to do with his appointment. And so whatever happened there, I mean, there are two hugely different stories emerging that have emerged about who appointed the special prosecutor. Ken Paxton's office saying months ago it wasn't them. Margaret Moore now saying, well, it wasn't me. certainly the House managers have steadfastly said from day one, and the whistleblowers have said from day one, that it was Ken Paxton who appointed Brandon Kammack.
And we heard that. We heard earlier today, and certainly as the days have gone on, we've heard the whistleblowers talk about the hiring of Kammack and them saying that Paxton himself approved the contract to hire Brandon Kammack. And this is a person, by the way, who we learned today has not been paid. And so this person was presumably working for the Attorney General's office, issuing subpoenas, and had not been paid. But even in Brandon Kammack's, what was interesting is in his correspondence with the Travis County DA's office, and certainly at the bottom of his signature and the documents that were being sent, it says special prosecutor for the DA's office. So this notion that you would have Paxton's employees then go under oath to the House managers, because remember, when you are testifying before a committee, a committee of the House or the Senate, you are under oath. You are to be telling them the truth.
Yes. Although that has been raised as an issue too, right? I mean, the whether or not they gave sworn statements and all of that that has been part of the conversation.
Well, yes, I think it is part of the conversation. Certainly,
Team Paxton wants it to be part of conversation.
Want it to be conversation.
Yes,
but certainly people, and I would argue within the Attorney General's office of the state of Texas, would know that when you are testifying before the House, members of the House, right, members of the Senate, this is testimony.
You're playing for keeps.
And they remind you of this, that the lawmakers, the chair of all the committees, reminds the public of this at the beginning of every committee hearing.
Right.
It's they have a whole script that they have to read, and that is part of the script. And so to have that being said about who really hired him,
it's kind of a mess.
It is, and it's so... It runs so counter this idea that Margaret Moore, that the DA's office would have hired him. We have not even heard that until today.
And she seemed offended. I mean, offended at the notion that she is the one who did that.
Well, and I think offended that it would be what she would consider a lie. Right. That a lie was told to the House Board of Managers, to this committee that was investigating. They weren't the Board of Managers at the time when they were investigating, but to the House Investigating Committee, this idea that we would have hired him. And she said, I don't even know what a special prosecutor is. I don't even know that role exists within the Attorney General's office. Either you work for the state and you're a prosecutor, or you're not. And same with her office.
And Ashley, just in the spirit of sort of recapping the day, certainly we have seen the pace of witnesses pick up. I was looking back through my notes and I'm like, did that happen today in terms of Mark Penley's testimony? Yes, Mark Penley did testify today. Certainly delivered testimony that was similar in many ways and consistent with the other whistleblowers. But again, I think another headline of the day is that we heard from our first non-whistleblower, Missy Carey, who was Ken Paxton's chief of staff. She is the first person who delivered any testimony about Ken Paxton's mistress, Laura Olson.
Well, by name. We heard
by name. Excuse me.
Yes. Talk about the meeting that they were all in, that she recounted in more detail about the mistress, and a lot of tears were shed, and that Ken Paxton asked them to forgive him and seems remorseful. But then we're hearing from, Missy Carey, that even after that meeting, she then later came into her office saying that the affair was carrying on and he needed her, in terms of the security detail, to work with him.
And Missy Carey really providing more intimate testimony about her direct interactions with Ken Paxton.
And I would say reluctantly.
It sure seemed that way.
It really felt like she did not, at one point, I think Busby, asked, was she enjoying it?
Uncomfortable, yeah.
And no one wants to be here, frankly.
Yes.
And she certainly did not want to be there, and did not, and because this is someone who she had a close relationship with, the Paxtons.
Clearly,
especially for her to say that when Senator Angela Paxton was crying, she went up and hugged her.
And said, I'm sorry this has happened to you.
Right, and so that, indicates her relationship with them, and certainly how she may still feel about them, and the fact that when all of this is happening, she's making the decision, I'm going to go ahead and retire now.
Yeah. So again, the big question as we go into, nearing the 7 o'clock hour this evening, we're done for the day. The big question, as always, who's going to be called tomorrow? I think that's a big question about, who it may be. It seems as though, Ashley, we may not hear from the other whistleblowers. We've heard from 5. Obviously, there are 3 more who we have not heard from.
And let's, the 3 that we haven't heard from, at least one of them, you hear him called Paxton's body man, who
right.
Nate Paul paid for the kitchen renovation that claim came from. It's interesting that the prosecution wouldn't, but we also have to remember there is strategy to all of this.
Of course,
and so we could be going in order of the articles of impeachment, the witnesses that they're calling, and who speaks to the articles in those order. And also, I would say the prosecution is going to want to end its case on a bang.
Yes.
And so we have to think about that in terms of the order in which we're calling and whether or not we'll hear from more whistleblowers. And I think the big question for me, Tony, are we going to hear from Laura Olson, the woman who was having an affair with Ken Paxton?
Yeah, I said that to someone today, and the response I got was if they can find her. So it makes you wonder if potentially, this was venturing into speculation, so
Sure.
Excuse me. But, there may be an idea that they've not been able to serve a subpoena. That remains unclear. I think by all accounts, her testimony is desired and by the public, and much of the public in terms of what she can provide. But she can also provide real information that is beyond sort of the salaciousness of it, about how she got her job with Nate Paul, her knowledge, if any, about, Ken Paxton pulling those strings. So she does have very legitimate testimony to offer.
And then I think as a political insider and as his mistress, what was going on in his head to make him to really speak to what was happening and what he was thinking about this kinship of Nate Paul and the desire to help. Why was the desire to help Nate Paul so strong? Which is the question we're all sort of wondering. Surely it can't just be this thought that the feds have wrongfully investigated you, this kinship. There has to be, I think a lot of us would like to think something. Well, surely there is something more, because there are a lot of people who feel like they've been wronged by the FBI, I am sure.
Who don't have the Attorney General of Texas on direct dial.
Exactly. And so what is it about Nate Paul? But if we thought that Missy Carey didn't want to be up on the witness stand, you can imagine.
Yes, absolutely. I want to tell you, too, that we have an invited guest coming in tomorrow, so we're going to start just a few minutes early. His name is James Wood. He's an Austin attorney who has been closely following this case, so we're going to tap into his expertise tomorrow morning as well.
Right, and so we'll start with that a little bit before 9, because the Senate has been starting right at 9, and we certainly want to get some of, to hear a lot of his analysis and what he's seen in the trial. So we would say you would probably definitely want to be tuned in around 8:55 a.m. Tomorrow, ahead of them getting started.
We're doing good to get in here by the stroke of 9. I'm doing good to get in here by the stroke of 9 o'clock. But we definitely want to start a few minutes earlier tomorrow. So I hope you'll join us.
We certainly do, and we thank you for watching this special report of the impeachment trial of suspended Texas Attorney General Ken Paxton on KVUE+. We'll see you back here tomorrow morning.
Have a great night.